morning. Good morning. Good morning. Good morning. Amazing Law Nerd. It's Monday. It's March 16th. It's day 15 of Utah versus Kouri Richins. And this case was slated to go a lot longer. And all of a sudden it just came to a screeching halt. And I know that for me, it's a little difficult sometimes to just reset. But here we are resetting today for closing argument. Now, if you joined me Friday, you got to see all the things that were going on. If you did not join me Friday, no shade. I'm going to give a quick road so far on Friday. We will see what the defense did. Hopefully you have stayed safe amidst the spicy weather that's been, all the things. It was like 80 yesterday. It's snowing. This morning, it's one of those days. It's one of those days, but it's day 15 of trial. It's, one could say, an epic day. Closings are one of my favorite things. What do we expect today? Well, we'll see if the defense argues the spoliation they brought up on Friday anymore. They may not. We'll see. There is unlimited time for closing argument. We'll see if that's a blessing or a curse. The defense said that Attorney Lewis was doing closing, but then Attorney Nestor kept saying, so I can argue this and I can argue that. It was like she was prodding the judge to figure out which theory of the state she was going to argue, and the state just sit there and was just silent because that's the only thing you can do. She's like, but if this and what about that? And it's like, girl, the judge isn't writing your closing argument for you. And what I expect that we will see today, aside from if the defense argues over spoliation, is pre-instruction, which means the judge will give the jurors the instructions, then the state, then the defense, then the state if they get to it. Then I expect that we'll see if that gets us to the end of the day and there's any time left for deliberations with unlimited time to close. Who knows how long closings may take? I think anything over 3 hours from either side gets to be on to a bit much, but there's a lot of nuance to this case. And remember, there is a murder, an attempted murder, 2 counts of insurance fraud, and 1 count of forgery. I expect we'll see the defense attorneys use their jury instructions in their closing arguments quite a lot. I expect we'll see the defense try to cash in on some of the promises they made in opening. And right before we get rolling, I will let you know what promises I think the defense did not keep, because those have been rattling around in my head a little bit over the weekend. Let me know where you're coming in from, what you're drinking. I've got the coffee. I don't know if it's going to be enough, but I got the coffee. So let's go to court, shall we? Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I see where all of you are coming in from. We see just the tippy top of Judge M's head, which means it's time to go to court. Hopefully sound is good. We never know. Streaming is dynamic, just like court. And we'll see. Now, what are things I expect to see today from the defense? Well, the defense said that they were going to show or prove that Kouri Richins knew about Eric Richins' change of his trust before his death. I don't think we saw that at all. I'm really interested to see what they say about that in arguing. I wonder if they're going to argue it was in her jail call. I guess we're not on the record yet. He's like, what? Nope. We're not ready.
0-1.
Okay, I guess we're ready now. I wonder if they're going to argue it was on the jail call where she was talking to Ronnie saying, well, Eric said if anything happened to him, we're set. That's not the same. That's not the same as she knew she was not going to be in charge of everything. That's just not the same at all. The defense also said that you would never know how fentanyl got in Eric Richins' system. I don't know if the jury's going to feel misled by that because I think it's really clear it was orally ingested. I don't know if they're meaning like you don't know if it was in a lemon drop shot or a drink, or you don't know if he ate it. Again, the defense doesn't have to prove anything. They don't have to put on a case. But when the defense says in opening, we're going to show you this, it sticks out in your head when they don't. And they pull that on to themselves. Now, can the prosecution lean into that? That becomes a little sticky. But that's why they get to do a rebuttal. All right, let's call this case on the record. Don't worry, we'll fly when the jury comes in. And
And 231
We'll get to jury instructions, I imagine.
139. Mr. Burmister's looking at me. Oh, okay.
Somebody just still
Counsel
walking
for the
in?
state are present. Counsel for the defendant are present, along with Ms. Richins. We're set this morning for a closing argument. Mr. Bloodworth, is the state ready to proceed?
Yes, Your Honor.
Ms. Lewis?
We are.
Okay. Anything before we invite the jury in? Mr. Bloodworth?
No, sir.
Ms. Lewis?
No, Your Honor.
All right.
Okay, I guess the spoliation's just moot. I thought we were going to spend hours doing that today. It's just, we just don't fucking
Okay.
care? It's
Cody,
just
we're ready
completely
for the
moot? What? What is happening? Ramos is sitting there at the end of the table.
All right. Very good. Well,
And I've got my Lawnard shirt on today.
So
I've
good.
got the light purple going. I wonder if they gave up on the spoliation. I mean, I think it was kind of BS. Maybe they just wanted to waste the headspace of the prosecution this weekend. I mean, I don't think that was going to happen. But, okay. I mean, okay. I got to be honest, I'm shocked. After all of the fuss on Friday, that this morning it was like, do we have anything? Nah, nothing. Stunned, honestly. This defense team continues to surprise me with the wildness that happens. Let's see, are
I
they?
have this moment. If one member from each of your respective teams would plan to meet with Brittany
surprised.
after closings are complete, just confirm that we have consensus regarding the exhibits that we're sending back into the jury room.
Yes, Your Honor. Can we address physical evidence as well? I don't think we're requesting to send any physical evidence
I
back.
mean, what physical
but,
evidence is there?
I'm not sure.
For example, the glassine bags of the gummies, etc.
Correct.
I mean, you're definitely
I
not
wasn't
sending the
planning to
gummies
send
back
those
to the
back,
jury.
Okay, very good.
Your Honor,
Can
is
you imagine?
the court sending a computer back for
That
the
appellate
kind of audio
issue?
video files? Got it.
We have a air
Did
gap
the
computer
judge
that
get a
will
fresh
not
haircut over the
attach to
weekend?
the internet or connect to the internet that they'll be able to use to view files off a thumb drive.
Right, Your Honor.
I mean, he said he had an air gap laptop for it. I really think the defense strategy has been just baffle them with bullshit, to put it indelicately, because that really seems to be the way that they're going. But I'm really surprised that after all the fuss Friday, that today it's just like, nah, we good. For all of you asking, Emily, did they file anything? I didn't see anything. I can double check. But let's zoom. If they're not putting anything on the record, we're going to zoom to the jury coming in. Because they're just chilling. I guess the jury's coming in. Well, I guess it's nice to know court can continue to surprise us. I guess it's good to know court can continue to surprise us. After all of that fucking fuss on Friday, we're just zooming. Everybody, like, Emily, what's the TLDR on Friday? Okay, go watch Friday or the case brief about Friday. Here's the TLDR. The defense was arguing that they should be given an instruction because they don't know where the empty pill bottle that they talked about during opening is, and they say that the prosecution had a duty to preserve it and didn't. And they were arguing they should get a very heavy-handed instruction about that, and it seems that they just yeeted that argument entirely. But it seems that everybody's standing because the jury's coming in, so we need to fly to Utah is what we need to do. I'm stunned.
Have a seat as you come in, please.
Maybe we'll just 1.25 jury instructions and get into it. That was quicker than I expected.
Have a seat, please. Ladies and gentlemen, welcome back. We will begin this morning with jury instructions. Then we'll take a restroom break, and then we'll proceed with closing arguments. You have a copy of the jury instructions on your chair. You're welcome to read along, but you're not required to. You'll be able to bring those back with you into
I
the
love
jury
it when
room
courts do that.
to review during your deliberations.
All right, I'm going to put the judge at 1.25 for instructions. We've got some Zoom room. I am going to slow it down when we get to the elements of the crime. Sound good? That work for y'all? All right. Let's do that.
And we can fast forward to instruction
But I like that
number
each juror
13.
has a copy.
The preceding pages before instruction 13 are just a written copy of the jury instructions the court gave prior to opening statements. Closing roadmaps. Members of the jury, you now have all the evidence. 3 things remain to be done. First, I'll give you additional instructions that you will follow in
That's
deciding this case.
happening
Second, the lawyers will give their closing arguments.
That's
the prosecutor
happening
will go
next.
first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide.
There is your final answer, chat. Prosecution, defense, prosecution, rebuttal. This is not the same as giving a rebuttal case. It is the same as, it is the same as we see in most jurisdictions for closing.
The case. You have 2 main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. You are the exclusive judges of all
Facts.
questions of fact.
Yep.
The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt.
Right. Law plus facts.
You are bound by your oath to follow the instructions that I give you, even if you personally
That's it.
disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend upon what you decide are the true facts of the case. If an instruction applies only to facts or circumstances that you find do not exist, you may disregard that instruction. Please perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion.
I mean, I don't even know if they
Regarding
know what
closing
public
arguments.
opinion is.
When the lawyers give their closing arguments,
They are
please keep
not
in mind
evidence.
that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your
disregard
memory
it.
of the evidence.
Yep.
If they say anything about the law that conflicts with these instructions,
You
you are to
can
rely on
disregard
these
it.
instructions. During the trial, I've made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However,
like it
if
when
I
the judge
sustained an objection,
pre-instructs.
if I did not accept evidence
Helpful.
offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict.
If I said it must be stricken, you must wipe it from your memory. And the jury's like, yeah, okay. I'll do my best. He was like, line that out of your notes. Okay. It's hard to do.
As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Please do not interpret anything I've done as indicating that I have any particular
just
view of
watched
the
the
evidence
judge and not the
or the
gallery.
decision you should reach.
Very full gallery today. Remember, on Friday, they determined that there would be 2 rows for Eric Richins' family, 2 rows for Kouri Richins' friends and family. No public in the courtroom because they can watch on stream. So one row for press, 2 rows for Eric Richins, 2 rows for Kouri Richins.
You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their
Can we
objections are not evidence. My legal
zoom in
rulings and comments
on the victim's
are not
sisters?
evidence.
I
In
agree,
reaching a
Amy looks
verdict,
lovely, but
consider
can
all
we
the
leave
evidence
them
as I
alone?
have defined it here and nothing else. You may also draw all reasonable inferences from that evidence. Regarding items not admitted into evidence, transcripts, police reports, or other written audio or visual materials may have been referenced during the trial but not admitted as exhibits. It's common during deliberations for jurors to ask to review these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Regarding witness credibility, In deciding this case, you'll need to decide how believable each witness was. Please use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable?
Right.
In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you're convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony.
Which is important.
You may believe many witnesses against one.
I think people forget that nuance is possible. You can believe that a witness downplayed part of a testimony, played up part of a testimony. Some of it's true, some of it's not. They are allowed to pick.
Or one witness against many. In deciding whether a witness testified truthfully, please remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Evidence has been presented that a witness was previously convicted of a crime. This evidence was brought to your attention only to help you evaluate the credibility of that witness. Do not use it for any other purpose. It is not evidence of anything else.
That goes to both Carmen Lauber and Robert Crozier.
An informant is someone who provides evidence against someone else.
I still disagree with this instruction being given, just for the record.
For a personal reason or advantage. The testimony of an informant alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though not corroborated or supported by other evidence. You must examine and weigh an informant's testimony with greater care than the testimony of an ordinary witness. You must determine whether the informant's testimony has been affected by self-interest, by an agreement they have with the government, by their own interest in the outcome of the case, or by prejudice against the defendant. You should not convict a defendant based on the unsupported testimony of an informant unless you believe the unsupported testimony beyond a reasonable doubt.
Yeah, I don't think any of them were informants.
A person may testify under a grant of immunity, that is, an agreement with the government. Their testimonial...
This applies entirely. This applies. The other one, not so much. I yelled about it Friday.
Alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though it's not corroborated or supported by other evidence. You should consider testimony given under a grant of immunity with greater care and caution than the testimony of an ordinary witness.
That's very common.
You should consider whether testimony under a grant of immunity has been affected by the witness's own interest, the government's agreement, the witness's interest in the outcome of the case, or by prejudice against the defendant. On the other hand, you should also consider that an immunized witness can be prosecuted for perjury for making a false statement. After considering these things, you may give testimony given under a grant of immunity such weight as you feel it deserves.
I like the way that Utah breaks that down. Not every jurisdiction breaks it down that way, but they do remind the jury, hey, somebody got immunity. You should consider that somebody got immunity, but also consider that if they lie, they can be prosecuted for perjury. I appreciate that Utah balances that more than some jurisdictions. Some jurisdictions' instruction reads like, this person got immunity. I mean, should you really believe them at all? Ever? This one is more balanced than that.
You should not convict a defendant based on the unsupported testimony of an immunized witness unless you believe the unsupported testimony beyond a reasonable doubt.
And I don't think that this is
unsupported.
Remember,
the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crime charged. This presumption persists unless the prosecution's evidence convinces you, beyond a reasonable doubt, that the defendant is guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty.
So that was the reasonable doubt instruction.
The defendant has entered a plea of not guilty and denies committing the alleged crime.
When we get to the crime instructions, the crime, the elements, we will slow this down a bit. But that was there was some argument over the reasonable doubt instruction on Friday. I think it's a pretty balanced instruction, but there's argument over the definition of reasonable doubt. Emily, why do they define it? Because if somebody said to you, what is reasonable doubt? You would be like, well, it's that you don't have a doubt based on something reasonable. So each jurisdiction tries to explain what that means so that all the jurors are on the same page. Lawyers like to define things. And there was some argument over that on Friday as well.
Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume the defendant is not guilty. The defendant does not have to prove anything. She does not have to testify, call witnesses, or present evidence. Regarding direct and circumstantial evidence, facts may be proved by...
I'm going to slow this down. I want to see how Utah does their direct and circumstantial evidence instruction. Different jurisdictions do it differently. Sometimes they use a rain example, sometimes not. I'm curious what Utah does.
By direct or circumstantial evidence, the law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified that he looked outside, saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide.
Chat, I went a different way. Chat went blame it on the rain. Blame it on the rain.
You have heard evidence that before or after the alleged acts charged in this case, the defendant may have done the following: made false statements connected to the financial affairs of her business, engaged in an extramarital affair, or made false claims about...
Emily, what is he reading? These are the 404 instructions that they were fighting over. These are the 404 instructions. Listen to these. These are this is why you can use the 404.
It is up to
Character
you
not found.
to decide.
Listen to this instruction. He's going to list it out.
You have heard evidence that before or after the alleged acts charged in this case, the defendant may have done the following: made false statements connected to the financial affairs of her business, engaged in an extramarital affair, or made false claims about whether she was the sole author of a book. This evidence was not admitted to prove a character trait of the defendant or to show that she acted in a manner consistent with that trait. You may consider this evidence, if at all, for the limited purposes of determining motive, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Keep in mind that the defendant is on trial for the crimes charged in this case, and for those crimes only. You may not convict the defendant simply because you believe she may have committed some other acts at another time.
All right, that was the 404
Regarding
instruction.
fact versus expert witnesses,
I'm going to speed
there are
this
two
back
types
up.
of witnesses: fact witnesses and expert witnesses. Usually, a fact witness can testify only about facts.
I will slow this back down when we get to the crime instructions, because these are so similar to what we've heard almost everywhere else. I like that a few of you in the chat went chocolate rain, chocolate rain. Lots of different options for rain songs today. Emily, you were chatting in Ryan Hall's chat last night. Yeah, because we had swirly whirly weather last night. It was a shit show. For those of you that say I look tired, it's makeup. Or that I look rested, it's makeup. That I look tired, it's accurate. I'm tired, but it's hello, awesome. Emily, you look well rested with glowing skin. I have multiple sponsors for makeup and skincare. They help a lot. Very tired. Very tired.
Facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can give their opinions in their area of expertise.
An expert on streaming at this
point. You may
point.
have to weigh one expert's opinion against another's.
They don't have to do
and
that
weighing
here.
the opinions of experts, you may look at their qualifications,
No
the
battle of the
reasoning
experts
process
for
the
us.
experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Please use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part.
Whatever,
give it whatever weight you think it deserves.
Whatever. It's whatever. It's whatever on the expert witnesses.
You have heard the testimony of law enforcement officers.
Don't
the
give
fact
them
that a
any more
witness is
weight.
employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Regarding the defendant not testifying. A person accused of a crime may choose whether or not to testify. In this case, the defendant chose not.
You know what, Judge M, though? Do you know what they can't do? What they can't do is have their lawyers tell everyone for months and months and months and months and months that they're going to testify and then disappoint the Lawnards. That's the hard part. That's the hard part. But yes, they have an absolute legal right to not testify. They have an absolute legal right, and they generally are better off if they don't testify. Yes, yes, yes. However,
to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant.
Y'all can speculate. It would have gone abysmally. The jury can't speculate, but the jury's going to sit there and be like, yeah, it's better that she doesn't.
It does not have to prove that she is not guilty. The prosecution must prove the defendant's guilt beyond reasonable doubt.
Are you going to get to the crime?
Regarding conduct and mental state.
Nope.
A person cannot be found guilty of a criminal offense unless that person's conduct is prohibited by law and,
Actus
at the
reus,
time the conduct occurred,
mens rea.
the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires a person to act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it's enough that the defendant acted recklessly or with criminal negligence or with some other specified mental state. Later, I'll instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged.
Right.
The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind.
Right.
Some definitions.
I think we are getting close to the elements instructions, so I'm going to slow us back down as we get through definitions.
On or about includes any day that is near the day alleged in the information. For pecuniary gain means for the acquisition of money or something of monetary value. Attempt means the actor engages in conduct that constitutes a substantial step toward the commission of the crime and intends to commit the crime, or when causing a particular result is an element of the crime, acts with an awareness that her conduct is reasonably certain to cause the result. Conduct constitutes a substantial step toward the commission of the crime when it strongly corroborates the actor's required mental state to commit the crime. Utter means any intentional act.
For everyone who watched Friday, you'll know exactly why I'm backing up, because the judge kept it in.
The crime when it strongly corroborates the actor's required mental state to commit the crime. Utter means any intentional act that puts a writing into circulation and implies, by word or action, that the writing is genuine. Unless these instructions give a definition, you should give all words their usual and ordinary meanings.
On Friday, Attorney Nestor, as they were trying to go through these instructions, Attorney Nestor is like, I don't like the word utter, or no, the word utter is a weird word. Makes me think of a cow. And the judge just looked at her and then just kept going. The judge was like, I'm not doing this. I'm not doing this with you. No.
Elements of count
word.
1,
Ooh.
criminal homicide.
They actually name it elements. For any of you who are note takers, these are the things to take note on. Why? These are the elements that the prosecution has to prove for each crime.
Elements of count 1, criminal homicide, aggravated murder. Kouri Richins is charged in count 1 with committing aggravated murder between on or about March 3rd and March 4th, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements.
All right, elements.
Kouri Richins intentionally or knowingly caused the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 3 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form.
Those are the aggravating circumstances that we heard about.
Elements of count 2, attempted criminal homicide.
That was it for count 1. Intentionally caused the death for pecuniary gain or lots of words that mean poisoning. That's it. Pecuniary gain, poisoning. One of the two. Either or. They don't have to find both, but they can. All right, count 2.
Attempted aggravated murder. Kouri Richins is charged in count 2 with committing attempted aggravated murder on or about February 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins attempted to intentionally or knowingly cause the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity.
So basically count 1, but
After
an
you
attempt.
carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of attempted aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances
Yes,
the
Chad, it can be
prosecution
any
has
substance
proven.
in a lethal
You
amount.
will mark your decisions on the verdict form.
I see a lot of conversation in the chat about how many deliberating jurors in Utah for this charge. There are 8 deliberating jurors. There are 12 there. That includes alternates. Only 8 deliberate.
Definitions of mental state related to counts 1 and 2. For the purposes of counts 1 and 2, a person acts intentionally or with
These
intent
are definitions.
when her conscious objective is to cause a certain result. A person acts knowingly or with knowledge when the person is aware that her conduct is reasonably certain to cause a particular result. Elements of count 3, insurance
All right,
fraud.
We're moving on to insurance fraud.
Kouri Richins is charged in count 3 with committing insurance fraud between on or about January 29 and August 31 of 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, intentionally, knowingly, or recklessly devised a scheme or artifice to obtain anything of value by means of false or fraudulent pretenses, representations, promises, or material omissions, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 4.
Count 4 is also insurance fraud.
Kouri Richins is charged in count 4 with committing insurance fraud on or about June 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins, with intent to deceive or defraud, presented or caused to be presented any oral or written statement or representation as part of or in support of a claim for payment or other benefit pursuant to an insurance policy, certificate, or contract. Knowing that the statement or representation contained false income.
I don't know where he got the fentanyl from. That's what they're going to focus on for this one when she was on the phone with the insurance company. That's why those insurance company representatives who spoke to Kouri Richins came in. I don't know how that happened. And then we're going to get to the forgery after that.
Complete or fraudulent information concerning any fact or thing material to the claim, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt,
forgery?
then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 5, forgery. Kouri Richins is charged in count 5 with committing forgery on or about January 29, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with purpose to defraud anyone, without the authority to do so, did make, execute, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Definitions of mental state for counts 3, 4, and 5.
So this is the definition
for purposes
of
of counts 3, 4, and 5, a person acts intentionally or with intent when her conscious objective is to engage in certain conduct. A person acts knowingly or with knowledge when the person is aware of the nature of her conduct, or is aware of the particular circumstances surrounding her conduct, or is aware that her conduct is reasonably certain to cause a particular result. A person acts recklessly when she is aware of a substantial and unjustifiable risk that certain circumstances exist relating to her conduct, but she consciously disregards the risk and acts anyway, or her conduct will cause a particular result, but she consciously disregards the risk and acts anyway. The nature and extent of the risk must be of such a magnitude that disregarding it is a gross deviation from what an ordinary person would do in that situation. Conduct means either an act or an omission.
All right. You see the judge like...
Separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all the evidence related to that charge. decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Regarding jury unanimity,
You all have to
because
agree.
this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty
Unanimity
or
is
not guilty.
a weirder
That
word than
is,
utter, but-
you must be unanimous
You
in
must
your
all
verdict for
agree.
each count charged. To help you in reaching unanimous agreement, I recommend that you not commit yourselves to a particular verdict
Too early.
before discussing all the evidence.
Right.
In addition,
Talk it out.
you may not use methods of chance, such as drawing straws or
Don't flip
flipping
a coin. Yeah, don't flip a
Rather, in the jury room,
Can you imagine you're on a jury? You've sat here for weeks and weeks and weeks and weeks and weeks with everything. And you get back to the jury room and somebody's like, should we just flip a coin? I can't even imagine. However, there has to be a case somewhere where people are like, you forget it. Draw straws for the tiebreaker. Fuck it. Let's go. I can't even imagine.
consider the evidence and speak your minds with each other. Listen
Talk
carefully
to
and
each other.
respectfully to each other's views, and keep an open mind about what others have to say. If there is a difference of opinion about the
Talk it
evidence
out.
or the verdict,
Yep.
do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence
Just because others
simply to
disagree.
agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must
That's so for real. Utah is so real for that. Or just to be done. Talk it out. This is why there are numerous jurors. You might see the evidence one way. They might see the evidence a different way. You talk to each other about how you see that evidence. Completely fair.
be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. In making your decision, do not
they've gotta be
consider what punishment
almost
could
done.
result from a verdict of guilty. Your duty is to decide
one
if
of
the
the last
defendant
ones.
is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty.
It is not your problem.
Let's pause there for now.
Pause.
That went a little quicker than I anticipated.
Good
Mr.
job, Your
Bloodworth,
Honor.
would you like to proceed?
Yes, Your Honor, we may proceed and then maybe take an intermission.
Understood.
He's just whacking the crap out of that. I thought they were going to take a break. He read those fast. I thought we were going to have a bathroom break to Zoom. Miguelina, will you let the app know that we are moving to the prosecution's closing arguments? That did go quick. Yes, chat, I do see Kouri Richins, former attorney, in the chat. I also noticed that there are much fuller benches for Eric Richins than there are for Kouri Richins. Yes, I notice. I wish they would just focus on the person speaking. The prosecution I left Zoom room and they're just zooming. So we're going to let the app know that the defense is starting. I see Sky in the audience. Why would she be there? To support Kouri Richins. Even though she conflicted off the case, she might still feel strongly about supporting Kouri in her case. So I see her there in the audience. That looks like her face. Why would she be there? Because she wants to. Sure, she can do that. It's her choice. So as we zoom and let the app members come in, because I did promise that we would let you know when closing arguments began. And I know most people love the dulcet tones of this judge, but some people just don't want to hear jury instructions again. We are also going to take a minute to thank our sponsor, who we had lined up in advance. We had a few more weeks of trial. We didn't think today was going to be closing arguments day, but it is. So as the prosecution gets up and ready, we are going to say thank you real quick to Incogni. Sky is in court, chat. Sky is in court. Not in chat, in court chat. Yes, I see her in the courtroom. So a huge thank you to today's sponsor, Incogni. And then we're going to closing arguments. Leonard, we just need to take a minute to talk about today's sponsor, Incogni, who has been not only a tremendous sponsor to the channel, but also has helped me keep my information off the internet. I just saw the article from March 9th from Inc.com about another massive medical data breach, over 3.4 million people impacted, by a healthcare IT company that confirmed the breach. So make sure that you are taking back control of your data with our sponsor, Incogni. What I love about Incogni is it is constantly looking for your data and taking it off the internet. It's not just a one and done. Plus, if needed, Incogni has custom removals so they can go deeper, getting sensitive data off the internet for you. Plus, it helps reduce the risk of scams, protects your privacy, and protects those you're connected to as well. And it's not only me that loves Incogni. Incogni is the first and only personal data removal service to be independently verified by Deloitte. Plus, there's a 30-day money-back guarantee, so you can try it for yourself and cancel anytime. So if you're ready to take back your information, it's time to get Incogni. Use code EmilyDBaker at incogni.com/EmilyDBaker to get an exclusive 60% off an annual Incogni plan. That's 60% off an annual Incogni plan when you use code EmilyDBaker at incogni.com/EmilyDBaker. Now, let's get back to stream. All right, are we ready to get to the closing arguments? Thank you all. And if you're like, Emily, do you use? Yes, I do all the time. Let's get to closing. Closing time. One last call for coffee. The judge is still pounding away at his instructions. He's just putting the instructions together on the chat,
We sure did.
table. He went through those so quick. Scott's trying to unplug and plug back in. Bloodworth is like, I am ready to roll. Scott is just like in the tone-on-tone dark gray.
Mr. Bloodworth, would you like me to publish the slide deck now?
Yes, Your Honor, please.
There you are.
All right,
Please proceed.
let's go. I am going to end the poll as to which defense attorney will be doing closing in just a moment, now that we're beginning the prosecution's closing. I'm not going to poll on how long these are going to take because the limit does not exist. Let's see. I'm going to answer like 3 questions real quick. Roxia, did they ever address the issue about the juror? Not on the record where we saw it. Mindy, I do see Kouri's former lawyer, Sky Lazaro, in court today supporting her. That I don't know if I've ever seen that, but she can do that. Stephanie said, Emily, why aren't the instructions standardized based on charges? Seems weird that they argue these. We talked a lot about that on Friday. They are standardized to a point, but there are things that can be selected in and things that can be selected out. So it is modified per charge. Are they allowed to take notes during instructions and closing? It depends on the jurisdiction. They can. Closings are not evidence. And they have a set of the instructions. Each juror has their own paper, so they can. I would probably underline things and highlight things to read them, but we'll see. Let's see. Makeup by JoJo says, I still don't see a widow. That's going to come back up in closing, isn't it? That's going to come back up, isn't it? It's got to, right? Okay. Those are the questions. I will be keeping an eye for more. Let's go.
Kouri Richins feels aggrieved and is thus an intensely ambitious person. She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison, and her mother a gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but she felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful.
I see a ton of you asking, is that in evidence? Yeah. In Kouri Richins' life plan letter, we asked why he was admitting this letter. We thought it seemed like a lot of Kouri Richins' woe is me. It's all in that letter from Sedona that came in, and he's allowed to use that letter from Sedona. We were asking, why is this coming in? It seems like Kouri's woe is me tale. Well, now we know why. Woof. I'm going to back that up. Yep. That's where it came from. It is in evidence.
She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison.
I backed it up a little because
and
I
her mother, a
interrupted.
gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but she felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful. She met Eric Richins. He was a successful business owner. He had money. They had a son, married, and had 2 more sons. Kouri Richins was on her way. But she was unhappy. She wanted to leave Eric Richins, but did not want to leave his money. Their prenuptial agreement meant that if she left him, she would also leave most of his money. So, Kouri Richins took $250,000 in equity out of Eric Richins' home without him knowing it, so that she could start her own business and earn enough money to leave Eric Richins. Kouri Richins is intensely ambitious. First with Eric's money and then other people's money,
OPP.
Kouri Richins carefully curated the facade
Close enough.
of a privileged, affluent, successful business owner. Behind the facade, however, Kouri Richins was incompetent. She took tremendous risks.
Oh boy.
She borrowed money by any means necessary at exorbitant rates.
She's going to hate that.
She gambled other people's money and lost. Her business was imploding. All the while, Kouri Richins was more interested in spending time with Josh Grossmann than Eric. She dreamed of living in the Midway Mansion with Josh, running it as an event center, farming and raising kids, Eric's kids. But she did not have the money to leave Eric or the money to salvage her business. Kouri Richins is an intensely ambitious person. She is a risk taker. There was a way forward. Eric had to die.
She said that in her texts. What's on the screen, and I'm going to pause just to read what's on the screen. If they put up things that they don't read, I will pause and read them for everyone listening in the background. Deborah Blum, The Poisoner's Handbook, quote, "A gun may be fired in a flash of anger, a rock carelessly hurled, a shovel swung in sudden fury. But a homicidal poisoning requires a calculating intelligence." Yes, Chad, I see you saying other people's poison. I see it. I see some of you singing "That Girl Is Poison." I see it. I'm going to try not to go there. All right. They have now put up a slide that shows all of the charges and the elements of the charge. I love that they do this. Emily, you're incredibly biased. Yes, I used to do this in my cases as well. I am very biased when it comes to this. My bias is show them the jury instructions every single fucking time. Show them the jury instructions. Always show them the jury instructions. They need the instructions. I feel strongly about that. Don't ever do a closing without showing them the instructions. And here we are.
As Judge Mrazek just instructed, there are 5 counts. And each count has a series of elements. the state has to prove each count and each element of each count beyond a reasonable doubt. That is our burden. In this closing, we will go count by count, and then within each count, element by element.
I like how they broke these down with the 2 insurance fraud, the scheme of the insurance fraud, the claim of the insurance fraud. I think it's incredibly helpful.
To show to you how the state has met its burden of proving aggravated murder, attempted aggravated murder, 2 counts of fraud, and forgery.
Yeah, I think it's incredibly clean. The jury instructions, the elements are a bit scant. They put up on the screen jury instruction number 25, proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty.
That, again, is the reasonable doubt instruction that Judge Mrazek just read, and you will have back with you in the jury room. Judge Mrazek also read this instruction on what evidence is. And it's usually testimony
but it's up on the
and
screen.
exhibits. To reiterate, what the attorneys say is not evidence. And as I asked you in opening, please focus on the evidence.
You think there's a reason he's emphasizing what the attorneys say is not evidence?
Throughout this presentation, I generally use this format for slides. And so everybody understands where we are, the count, and then the element within the count is at the top in the red banner. We then quote some witness testimony and we cite it because it's the evidence that matters. So that
Great layout.
You'll have the exhibits back with you when you deliberate.
Great layout.
And you can reference them. Usually it's a transcript, page, line, number.
Love it.
Of the testimony.
They did this in opening too.
We also publish exhibits. And usually we'll have an exhibit number down here. If there's an exhibit, whatever, 2-5,
214.
so you can reference it.
I love that he told them how he was
Let's
going to
begin
do
with
it.
the aggravated murder count. The evidence will prove that Kouri Richins was the person who committed the aggravated murder. The evidence will prove that she intentionally or knowingly caused the death of Eric Richins, here by means of administering to him the illicit street drugs that she purchased from Carmen Lauber. She intended to kill him with the illicit street drugs. It doesn't matter what illicit street drugs. We'll get into it more. It doesn't matter if it was the propofol, if it was the fentanyl that actually killed him, if it was oxy or some other illicit street drugs. She bought illicit street drugs to kill Eric Richins. That's what matters. That's murder. These two elements are just murder. Right? If we hide this, that's a murder charge. Here we have an aggravated murder charge, and the state will prove two separate and distinct aggravators. The first is for pecuniary gain. This is a why aggravator. Why did Kouri Richins kill Eric? For money. The second aggravator is a how aggravator.
They only need
how
one
did
of
she
these.
do it?
But they
Here,
can find both.
by the administration of any substance. Here it happens to be fentanyl, but it could be any substance administered in a lethal amount.
It doesn't
Either
have to be
one
an
of
illegal
those
substance.
aggravators are what transforms this case from a murder case
An aggravated.
to an aggravated murder case.
Murder plus.
So, first element, was it Kouri Richins? Yes. The state has proved that Kouri Richins had the means, here the fentanyl, the illicit street drugs,
I'm gonna leave
the
these
motive
down
here,
for
money,
now.
and a fresh start at life, and the opportunity to kill Eric Richins. She was the only other adult in the home at the time.
Right, who else?
Nobody else killed Eric Richins.
And the defense is going to argue that he took stuff on his own.
Now, intentionally or knowingly caused the death of Eric Richins by administering the illicit street drugs. The state will prove with all kinds of evidence,
It's a business
testimony,
slide.
exhibits, patterns of her behavior, and what each of us know about humans, that she intended to cause Eric's death. She intended it probably as early as December the 7th, 2021.
When she was booking that vacay?
When she booked a
Vacay?
trip for her and Josh Grossman to the Caribbean for April.
El Doggo.
People don't book that trip. Kouri Richins did not book that trip thinking Eric Richins would be alive in April. She booked it knowing he would not. In December, before Eric died,
I love that they
before
used-
Kouri Richins murdered Eric.
I'm just pausing. For all of you listening in the background, we got to take a moment to highlight the fact that they went and screen grabbed the witnesses testifying on the stand from the feeds of court so the jury can remember who the witnesses were. 10 out of 10. 10 out of 10. Love it. Love helping the jury remember, putting the face to the witness. I love it. I love it. And then at the bottom, they have the date of when the individual, Becky Lloyd, testified. It says Becky Lloyd, trial transcript, May 9th, 2026. And then it's got the lines of the transcript to remind the jury where this came from. Not that they're going to go look at it, but to anchor what they're telling the jury in reality and in testimony. Really well done.
She told her friend, Becky Lloyd, in many ways it would be better if he were dead. That proves she intended to cause his death. This was the New York Life policy that covered the C&E buy-sell agreement.
And then it's got the exhibit number under where my face is, exhibit 7.
And on January the 1st, 2022, Kouri Richins changed the life insurance beneficiary on Cody's policy from Eric to her. The evidence proves that Kouri Richins didn't understand that was Cody's policy. And when she figured it out, she went ahead and changed it back because she planned to murder Eric. She did not plan to murder Cody. But she planned to murder.
She disagrees. Her face is disagreeing with Bloodworth in that moment. Look at the friendly
Kouri
pauses.
Richins asked two people, Hayden Jeffs and Carmen Lauber, for the Michael Jackson drug. Kouri Richins was a suburban mother real estate agent. She does not know a lot about the illicit street drug world. But she knows Michael Jackson died from taking drugs. She doesn't know how to order a street drug, but she knows she wants the Michael Jackson stuff. She knows she wants it because it is lethal,
stuff.
it is fatal, it kills. And she wanted lethal, fatal death.
He picked good pause faces. Even for the witness that didn't like him, he picked a kind pause face. I'm sure Scott did that.
Kouri Richins is intensely ambitious. She wanted the perfect life, or at least the appearance of the perfect life. And for her, that meant Josh Grossmann. But first, Eric had to go away.
Intentional pauses from
So
attorney
with these
Bloodworth.
transactions, when Carmen hit you up, what did she tell you?
She told me she had a friend that wanted,
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxygen? What did she ask for?
No, I think she might have asked for blue. I can't remember.
But you sold her M30s, right?
Yeah, I told her what she knew what she was buying.
Okay, so she wasn't like she's asking for oxys or something like that, and she got the M30s.
Right, no.
Okay. She knew that there was fentanyl in those pills.
At Kouri Richins' request, Carmen Lauber purchased illicit street drugs from Robert Crozier.
She knew there was fentanyl in those drugs was the point of that exhibit.
It's those illicit street drugs that killed Eric Richins. It's those illicit street drugs that Kouri used to murder Eric Richins. And while there may be some question as to whether she specifically ordered fentanyl or she knew she was getting fentanyl, the evidence proves she at least knew it. She wanted fatal, lethal, illicit street drugs. And all the testimony from Carmen Lauber, Robert Crozier, digital forensics, we'll get into it, all confirm that Kouri Richins ordered and received illicit street drugs, and that those street drugs contained fentanyl.
The background noise in court's hard for me too, Chad. It's
Illicit
just
street
gained up
drugs
to
is
pick
all that
everything up,
matters.
which is tough. But it is what it is.
But you heard the testimony that despite confusion in what people were ordering, people were getting fentanyl. The fake M30s looked like the real, the fake M30s looked like the real M30s. Everything on the street in early 2022 had fentanyl. That's how we...
I wanted to read this slide, so I'm pausing it just for a sec to read the slide. Let's see. Aggravated murder by means of the administration of any substance administered. And then they've got two witnesses, including the witness we did not see testify, and Dr. Eric Richins. Question, so what does M30 mean to you? Answer, so I don't know where it comes from initially. However, these pills are produced to mimic, they perfectly mirror a 30 milligram oxycodone pill. What do you mean perfectly mirror? They look exactly the same, indistinguishable. An illicit fentanyl pill and a true 30 milligram oxycodone side by side. I would not be confident in saying which was which. That's from testimony from February 27th. And then Dr. Christensen said counterfeit fentanyl pills, counterfeit oxycodone pills, fentanyl in pill form made to look like it was oxycodone pill also became a fairly common thing. We also heard Crozier say that, and we just heard some of that. And Crozier was saying he was charging the same amount for the same thing. So I read that evidence in, or that slide in. I'm going to let him continue on.
The fake M30s looked like the real, the fake M30s looked like the real M30s. Everything on the street in early 2022 had fentanyl. That's how we know that it was this purchase that ended
Just going
up
to keep moving me around.
killing Eric. It's the fentanyl. We can trace the fentanyl.
Crozier said he was charging the same amount for the same things.
Next slide. The digital forensics corroborate Carmen Lauber's testimony that 5 days before Kouri Richins murdered Eric Richins, Carmen Lauber purchased for Kouri Richins fentanyl from Robert Crozier at the Maverick in Draper.
These are those great cell tower mapping of Crozier and Lauber that we saw in trial. And they're showing those slides that we saw about the different days and who was meeting
Call
where.
detail records show an extraordinary amount of overlapping communication between Carmen Lauber, Kouri Richins, Carmen Lauber, Robert Crozier during that time. We, of course, don't have the communications. Carmen Lauber deleted them because they were evidence of a drug deal.
Right.
Kouri Richins deleted them because they were evidence of a drug deal and a murder.
Being planned.
Robert Crozier said he had lost his phone. But that's an extraordinary number of communications. We know that Kouri Richins, the evidence proves that Kouri Richins used a Moscow Mule and a shot to administer the fentanyl to Eric. She writes it in her orange notebook where she journals what happened the night she murdered Eric. It's a self-serving journal. We'll discuss that down the road. But she wrote Moscow Mule and a lemon drop shot.
Right.
And that is consistent with all the toxicology.
Oh, she doesn't like that orange notebook being used in that way. No, I didn't miss her face. I saw her face. She doesn't like her notebook being used that way.
Notes that investigators recovered from the kitchen cabinet in Kouri Richins' home, she wrote Moscow Mules. Lemon water, vodka, and rum. She left out the main ingredient, which of course is the ginger beer. But there was ginger beer. We know that from the Cock and Bull.
Right.
That OME investigator Cam Sessions found in the trash can in the kitchen.
Who had forgotten
It's
about the
interesting
Cock
that
and
Kouri
Bull?
Richins wrote vodka, in parentheses, rum.
Which is weird.
The evidence may show that the Moscow Mule she made that night was ginger beer and fentanyl. The lemon drop shot may be lemon and fentanyl. Notice that here she writes drink in bed. We'll come back to that in a minute. The Cock and Bull, as I mentioned, corroborates at least the Moscow Mule.
I'm sure we are going to come back to the drink it in bed, because if he drank it in bed and then became unresponsive, how did the glass get from the bed back to being put away? This is another slide about the Cock and Bull.
And then we know the cause of death from the death certificate was fentanyl. The fentanyl and the illicit street drugs that Kouri Richins got from Carmen Lauber, who got from Robert Crozier. We know that Eric ingested the fentanyl from the Moscow Mule, the lemon drop shop, or both. Medical examiner Dr. Pamela Ulmer, toxicologist Brianna Peterson, chief medical examiner Dr. Eric Richins, all testified that the 20,000 nanograms per milliliter of fentanyl, an extraordinary amount, in his stomach indicates oral ingestion. Indeed, Dr. Christensen not only testified to it, he told Kouri Richins that in their phone call that she recorded.
Are they going to play it? I wonder if they're going to play it. Her recording those phone calls, man.
Ms. Peterson's testimony, as well as Dr. Christensen, also proves that the fentanyl was illicit. Again, illicit, coming from the street, illegal street drug, illicit fentanyl. And it was their testimony, right, was that there was not only fentanyl in the toxicology, but there was norfentanyl, which was a marker of an illicit fentanyl.
And what else was there?
There's also acetyl fentanyl as well. But it's
And
the norfentanyl that is a marker of illicit fentanyl, which completely tracks with how Kouri Richins got the illicit street drugs. We also know that Kouri Richins
there it is.
intended to kill Eric Richins because the toxicology contained quetiapine.
Your Honor, we may have lost the audio.
Let's reset. My apologies.
I appreciate that the court says my apologies, even when it's not the court's fault. He always pulls things onto himself. It looks like Scott's going to unplug it and plug it back in. A lot of you are saying Kouri looks nervous. I can't imagine that she wouldn't be or wouldn't feel nervous watching a prosecutor lay this all out, especially a really skilled prosecutor.
Quetiapine is an antipsychotic medication.
Last one. What is quetiapine? Quetiapine?
Oh, I forgot she pretended she didn't know what it was. I forgot about that on the call that she recorded.
Quetiapine is an antipsychotic medication.
Last one. What is quetiapine? Quetiapine?
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay. I gotcha.
It's a prescription, mental health medication that's prescribed for different things.
I gotcha.
Uh-huh.
The quetiapine in the toxicology
Why are you faking?
for Eric Richins shows that Kouri Richins was involved because she was prescribed quetiapine. Now, this conversation that she recorded with Dr. Christensen is also very insightful. She pretends to not know what quetiapine is. It's her prescription. Of course she knows what it is. She pretends to not know what it is to cover up her involvement in putting the quetiapine inside Eric's body. She feigns the ignorance. She covers up her conduct in murdering Eric Richins in several ways throughout, beginning the night she murdered him, all the way through the walk the dog letter.
Docket 214.
In the orange notebook, she writes, she jumped out of bed, ran, turned on the lights, grabbed her phone, and called 911.
That's not quite accurate.
The evidence proves that is not true.
And
The
here's that
evidence proves that when she returned to their bedroom, Kouri Richins says she was in Ashton's room. There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi. Somebody. That would not appear in the call detail records. It would appear on her phone.
Ooh, buddy, if you're listening in the background, now's the time to cast your eyes back towards the screen, because holy shit, Kouri does not like this argument at all. So I'm backing it up. Damn. She mad. Oh boy.
There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time.
But
she may have called on Wi-Fi. Somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
sit back down, Miss Lewis. We're backing that up again. Emily, but what if it's not in evidence? He didn't say she did. He said she may have. Why was the speaker turned on her phone? Is it a reasonable argument from the evidence that the reason the speaker would be on is because you're on a FaceTime call? That is a reasonable inference from the evidence. But he told her to sit back down. I'm rewinding that again. Damn. All right, we're at one objection.
But she may have called on Wi-Fi. Somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
She then unlocked her phone again at 3:08, 3:10, 3:15.
All right, one objection.
3:19. And then 15 minutes later,
The slide
she called
shows
911.
the phone activity.
That is not immediately called 911. Perhaps she was staging the scene during these 15 minutes.
I love how
We're going to discuss
unbothered
the
he
911 call in a minute. This is a
So
receiver
unbothered.
activation. At 3:22:12, when we're in the 911 call, she's on receiver on her phone. The 911 call operator asks her, "Are you on speakerphone?" She says yes. No. She's on receiver.
is. Your phone's going to tell on you.
Before we play,
And now we're going to hear some of the 911.
Before we play this, sorry. We're going to listen to the first part, actually most of the 911 call again. I ask that as you listen to it, you'll hear the first minute. The first minute is not the sound of a wife becoming a widow.
Oh, shit.
To echo her friend Chelsea Barney, the first minute is the sound of a wife becoming a black widow.
Oh, damn!
Listen to how Kouri Richins on
Oh,
the 911
damn.
call immediately presents, very soon after the call begins, presents her alibi narrative. Listen to how she tells the 911 dispatcher where she was when Eric died. She is distancing herself. Rather than, he's not breathing, he has no pulse, I have to figure out what to do, I need help. She's saying, hey, look, I was not there, I was in my son's room.
Right.
That's her alibi. She's distancing herself from the time and the place that she murdered Eric.
Damn. We knew that the opening from defense would come back
The
to bite
911
them.
call operator asks her to perform CPR. Notice how she distances herself from that. No, I don't know how. No, he's too heavy. No, I can't move him. She is not immediately trying to revive him. We're going to run a clock from the time that the dispatcher asks her if she can start CPR to the time she purportedly starts it.
Oh boy.
It's 6 minutes.
Oh shit.
Listen, please, to the portion of the 911 call where the operator instructs Kouri Richins how to remove Eric from the bed. Listen how the dispatcher says, move to the side of the bed. Kouri Richins says she does. Remove the pillows. Pull the arm, pull the leg, lift up the sheath, pull him off.
6 minutes is so long.
If Kouri Richins is following the instructions of the 911 dispatcher, Eric Richins' body is on the floor, on the side of the bed. Not the foot of the bed where it was found.
Damn.
Listen also.
Kouri's looking at her lawyers saying, what is he talking about? Your 911 call, girl. You could hear her say that. I'm going to rewind it so you can hear her say that. What is he talking? He's talking about your 911 call, girl. I am more stressed taking my pets to the vet than Kouri seemed to be finding her spouse non-responsive in bed. Right. Mm-hmm. But you can hear Kouri say at counsel table, what is he talking about? He's talking about your 911 call, girl. He's talking about the fact that you seem to lack any urgency. And they're going to run a timer. Damn.
Not the foot of the bed where it was found. Listen also to her choice of language. She has dehumanized Eric Richins. When she is talking about removing Eric from the bed and she is protesting and she is saying she cannot, she is not saying, I can't move him. She is saying, I can't move it. Eric is no longer a him to him. She murdered Eric. Eric is an it.
Eric's now a body.
Finally, listen to when she says she is performing CPR and the phone is on speaker.
Oh, the faces
The phone's
are
not on
facing.
speaker. Determine whether she's performing CPR. Okay, Scott.
And now they're going to play the 911. If you're listening in the background, they say they're going to run a timer on the screen. I think they're going to run the entire 911 and we're just going to let it play. But Kouri is just like, seriously? Ma'am, you're looking in the direction of the jury making these faces. I don't think it's going to help.
My husband's not breathing. He's cold. Okay, what's the address? 282 Willow Court. 282 Willow Court? Uh-huh. Okay, what's a good phone number in case we get disconnected? 435 671 4987. Okay, it's going to be in Francis? Uh-huh. Okay, tell me exactly what happened. I don't know. I just came in. I was sleeping with my kids. Okay, I can't understand you. I need you to take a deep breath. What's going on? I don't know. I was sleeping in with my kids. I just came in the bed, in our bed, and I turned over, and he's just cold. He's just cold. Who's cold? My husband. I turned the light on. And he's not breathing? No. He's not breathing? No. I need you to confirm it for me. Is he not breathing? No. Okay, we're gonna. Can you do CPR?
No, I don't know how.
You don't know. I'm gonna tell you how to. Are you willing to do CPR?
Yeah.
Okay. If there's a defibrillator available, send someone to get it now and tell me when you have it.
No, there's not.
Available? Okay. I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next, okay?
Stop showing the audience.
Okay, are you right by your husband right now?
Yes, he's so pale. His mouth is open.
Okay, listen carefully. Are you able to lay him on the floor or the ground? On the floor, on the ground?
I'm just thinking. I can't touch him. I can't.
You can do it. You can do it. You need to calm down, okay?
He's yellow.
We need to help him. I can guide you through CPR. Take a deep breath for me. I'm here with you.
He doesn't have a pulse.
He doesn't have a pulse?
No. There's no pulse.
Okay. I'm here with you.
I didn't hear anything. I was just in there.
I'm here with you. We need to get him help. If you need to put me on speaker, put me on speaker. I'm gonna guide you through CPR, okay?
Okay.
Tell me when you've done that.
Okay, I'm ready.
You ready? Okay, he's on the floor?
He's on the bed.
Okay, are you able by any chance to move him on the floor?
Let me check. There's spots on it. I don't know what's happening.
Okay. I'm here with you.
She's telling you.
You're not able to move him to the floor?
Go out. Don't come in here. Oh my God, my sister.
You're not able to move him to the floor? Just listen carefully. We just need to get him on the floor. Don't worry about hurting them.
No, he's just too heavy.
Is he still on the bed?
Yes.
Okay, if there's a sheet or a
calling
blanket
you.
under them, can you loosen it from the mattress?
Yes.
Okay, stand at the side of the bed closest to them and remove anything under their head.
Okay.
Okay? I need you to pull the sheets towards you and slide them off the bed. Don't worry about him falling. We just need to help him now.
Okay.
Tell me when he's on the floor.
I can't move it. It's just dead weight. Like it just...
You're not. If he has sheets under, pull them to the floor. Don't worry about hurting him.
Can you please send somebody?
Okay, I have the ambulance that's on the way. Okay, there's another way to do this, okay? Grab their feet. Grab his feet.
Okay.
Slide them towards you until they're just off the bed. How old is your husband?
39.
39?
Yeah.
Okay. Okay, were you able to put his feet off the bed?
I'm pulling.
Okay, now grab the arm closest to you and pull the rest of the way off the bed. Again, don't worry about the fall. We just need to help them now. I have the ambulance on the way. I just need you to do this, okay, so we can get the help for him.
Just start doing CPR.
Once they arrive, they'll take over. We just need to start CPR now. You are doing great, okay? I just need you to get him on the floor.
Okay, he's on the floor.
You got him on the floor?
Yeah.
Okay, listen carefully, okay? Make sure that there's nothing under his head. Is he laying flat on his back?
Yeah.
Okay. Okay, just listen carefully and I'll tell you how to do chest compressions, okay?
Okay.
Place the heel of your hand on the breastbone. This is in the center of the chest, right between the nipples.
Okay.
Put your other hand on top of that hand.
Okay.
Okay? Start pumping the chest hard and fast, at least twice per second, and 2 inches deep.
Okay.
Okay, start counting out loud so I can count with you, okay? We're gonna count 1, 2, 3, 4, okay? Let me know when you're ready.
Okay. 1,
1, 2, 3, 4.
The counting, ma'am. Where's the counting? Kouri?
1, 2, 3, 4. Count out loud so I can hear you. I'm counting with you. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1. If it's easier for you, am I on speaker?
yes.
Okay. 1, 2, 3, 4. Do you know if the front door is open?
No, it's locked.
It's not. Are you? I need you to go. Is there anybody else within the home, or is it just you?
It's all my kids.
Okay. Are one of them old enough to go unlock the door?
Yeah, it's unlocked.
It's unlocked now.
Yeah, he's here. He's there.
Okay.
At the, yeah. The protesting that was part of the 6-minute delay in Kouri Richins performing CPR. I can't move it. It is just dead weight. Contrast that 911 call with her self-serving text message to her best friend, Chelsea Barney. I tried so fucking hard to save him, his lifeless body on my bedroom floor. I pumped so damn hard, so hard, screaming at him to come back to life, that I needed him.
Oh, boy.
None of that happened.
Yeah, you would have heard it.
She's covering up her involvement in murdering Eric Richins.
Hey, where's the screaming? Where's the urgency? She thought
Recall the alibi
hear
narrative at the beginning of the 911 call. Her letting the 911 operator and everyone know that she was not with Eric when he died. I was somewhere else. I was distant in place and time. When she calls her father-in-law, Eric's dad, Gene Richins, what does she say right at the outset? I was sleeping with Asha and I came into the room. Gene, I wasn't there. Wasn't me. When Eric's sister Katie arrives, he wasn't breathing. I went to bed. I was in Ashton's room. He was having nightmares. I wasn't there. It was not me. Her alibi. Her cover-up. This is the written form that sheriff's deputies gave Kouri Richins early morning of March 4th to write out what happened. It says, Describe in detail what you saw, know, or heard of the incident. Where does she start? Eric and I put the kids to bed around 9 p.m. We had a drink. In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink.
That's a solid connection.
She didn't start with, I walked into the bedroom at 3 a.m. My husband was not breathing and cold.
Damn.
Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began.
That is an excellent fucking point, counselor. That is a great point. That is a great point. The incident didn't start with, I got into my bed and my husband was cold. Damn, that is a solid connection. A lot of you are like, can you back that up? Yep, we got instant replay. When did this incident start in Kouri Richins' mind? We did not see this. This was admitted into evidence, but we did not see this while that officer was on the stand. Why? Because they saved it for argument. Describe in detail what you saw, heard, know of the incident, follow the deputy's instructions. This is in her handwriting. Eric and I put the kids to bed around 9 p.m. This is her recitation of how the evening went. Great point. Not, I woke up in my kids' room and went back to my bed and my husband was cold. Great point.
In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink. She didn't start with, I walked into the bedroom at 3 a.m. My husband was not breathing and cold. Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began.
Well, those are different faces you're making now, Kouri.
And then more of her self-serving alibi narrative. It wasn't me, I wasn't there. Before she gets into really what matters. Intentionally or knowingly caused the death of Eric Richins. We know it was intentional because she planned the immediate reaction. When she spoke with Eric's sister, Katie, very shortly after medical examiners rolled Eric Richins' body out of his home for the last time, she told Katie that she was going to plan the Midway, she was going to follow through with the purchase of the Midway mansion. She was going to sell the home that she was living in. And she had a plan for running Eric's business, C&E. The morning of Eric's death. She had those plans in place because she knew she was going to murder Eric.
Yeah, she'd been thinking about it.
She had already thought about not only murdering him, but what I'm doing immediately after murdering him.
And then a vacay.
Her plan with the Midway mansion is consistent with her dream of living there with Josh Grossmann, running it as an event center, farming and raising Eric's kids. Her plan to sell the home she lived in proves that she had no idea that home was in a trust. And she couldn't sell it. Her plan on running Eric Richins' half of C&E shows that she did not understand the buy-sell agreement, the life insurance coverage on the buy-sell agreement, or that life insurance coverage went to the trust, not her. The morning Eric died, she had a plan on how she was spending Eric's money and didn't realize it was trust money. We know that Kouri Richins intended to kill Eric. The evidence proves that she intended to kill Eric, in part based on her conversation with Josh Grossmann shortly after killing Eric. Kouri Richins asked Josh
testimony up on the screen.
He had ever killed anybody. Killed was her word. Not have you ever lost a loved one. How do you agree?
That point.
Not have you ever walked in and found a dead body unexpectedly.
We talked about that. That.
Not.
Chat, how many times did I say that? That point. That. She didn't ask Grossmann how you grieve. She didn't ask Grossmann about being adjacent to death. She didn't ask Grossmann about losing someone you're close to. That part. And she could have, because he would have also dealt with loss.
After killing Eric.
That.
Kouri Richins asked Josh if he had ever killed anybody. Killed was her word.
I had to back it up.
Not have you ever lost a loved one. How do you agree? Not have you ever walked in and found a dead body unexpectedly. Not how do you respond to a tragic and horrible accident. It is have you killed? And then she asked how it made him feel. She asked that because she was working through her own feelings on killing and wanted Josh to help her work through those feelings. And never mind that that's a highly selfish question. She's worried about working through her feelings on killing. Never mind Josh Grossmann's feelings on having had to have killed in service of his country. It was her feelings that mattered.
That part.
The walk the dog letter.
Oh boy.
There's a lot to unpack in this.
Yeah, there is.
But right now, let's unpack the fact that Kouri Richins says Eric gets pain pills and fentanyl from Mexico. She goes on to talk and says, Eric finally told me and asked if Carmen could get him some pain pills and fentanyl from Mexico. Some refers back to pain pills in Mexico from fentanyl. Sorry, pain pills and fentanyl from Mexico. Kouri Richins knows 4 months after she's been arrested for Eric Richins' murder, a year and a half after she murdered him, she knows that she bought fentanyl, and she has to explain it. And how does she explain it? A year and a half after murdering Eric Richins, she blames it on Eric. Oh, I bought it for Eric.
Yep.
That's the sum of the evidence. Her self-serving statement
Blame
asking
Eric.
her brother to testify falsely that she brought it from Eric. For Eric.
It's great groundwork because you know what the defense is going to do in closing. The blame Eric, blame Eric is great groundwork because the defense isn't going to shift gears And he clocks it before they even get up there. Because you know that's what they're going to do. And then the jury, the second the defense starts blaming Eric, they're going to be like, right, we knew that's what you were going to do. Because Kouri started doing it in the walk the dog letter. Mm-hmm.
Year and a half
Smart.
after she murdered. Kouri Richins did not tell the 911 dispatcher, hey, I just bought some fentanyl for Eric. She didn't tell the paramedics, he might be dying from the fentanyl I just bought for him. He didn't tell the deputies that responded. He didn't tell Detective Woody. He didn't tell Dr. Ulmer. Didn't tell Christensen. Didn't tell her friends.
There we go.
Didn't tell her family. All the off-ramps she had to, the opportunity to take to say, hey,
Eric,
I bought the fentanyl for Eric. She doesn't, because it did not happen. She did not concoct this story until a year and a half after she killed him. And it is a story. It's a fake story that she wants her brother to testify to. There are, of course, other inaccuracies.
Oh boy. For those of you watching in the background, come on back. It looks like we've got some of the body cam video that's going to get queued up on this slide that also has titled Story Inaccuracy. We're still on count 1. We've got stuff from the Orange Notebook. We've got stuff from Margaret. We've got stuff from the body cam. One of the things that sticks out to me is that in that 911 call, and I don't know if the prosecution will circle around, it's just life. In the 911 call, we don't see Kouri saying any questions like, is CPR supposed to be like this? Is it supposed to be like this? No asking about it, no comments about anything coming out of his mouth. And I think that's probably where they're going to circle back. Also, she says she started throwing up. That didn't happen here. So come on back and watch this, because we're going to get some body cam.
Kouri Richins in the Orange Notebook writes, self-servingly, when the EMT walked up to me and said he didn't make it, we did all we could, I lost it, I immediately ran to the bathroom. This is the video of when the EMT walked up to her.
Family members are becoming his dad, her mom, family are becoming the kids are in that door over there. There's 2 kids that are awake, they're in that door. Yeah, she said to the left. Yeah, I think that one master bedroom. Or the master bedroom. So basically she said we went to bed at 9:30. She slept with the kids because then she goes to bed. When she went to bed, at around 3 o'clock, moved into her bed.
We'll stop it there. We could play it for several more minutes. She doesn't immediately or otherwise run to the bathroom and throw up.
At all.
When people make up stories, they are inconsistent in the retelling. Here, in the Orange Notebook, Kouri Richins says they make
Showing
the
the
Moscow
notebook
Mule and the lemon drop shot
on the screen
in the kitchen, and then they go to bed and brush their teeth. Here, they drink it in the bedroom. not the kitchen.
This is a screen with the slides showing phone activity, testimony from Chelsea Barney, calls. The title of this one is Kouri Richins' Story Inconsistent. I think some of that is just highlighting that it was inconsistent. Some of it highlighting the fact that defense said in opening a million times that Kouri never changed her story.
Kouri Richins tells her attorney, it's on the right, she tells her attorney that Eric was on the phone when she went into Ashton's bedroom. But Eric Richins' phone activity tells a different story. Kouri Richins repeatedly said that she went into Ashton's bedroom 9:30, 9:45. Eric was off the phone before 9. In the Orange Notebook, Kouri Richins says that Eric was awake when she went into Ashton's room. And that rambling phone call with Bryce Knutson that Chelsea Barney recorded.
Oh, that call.
She suggests that he was asleep because she says when she returned to the bedroom about 3 a.m., Eric was in the exact same position as he was when he fell asleep.
Oh, that's an interesting catch.
That means she was there when he fell asleep, not in Ashton's room. Her story is inconsistent in the details.
It is, and you know what detail we never got? What the fuck happened to Bryce's pants? I still want to know. That's a great connection. In the inconsistencies throughout this evidence.
That proves that much of it is fake. We've read text messages throughout this presentation. We'll continue to publish some more for you to read. None of those text messages were recovered from Kouri Richins' phone. They were recovered from Eric's phone, Chelsea Barney's phone, Josh Grossman's phone, but not Kouri Richins' phone. Because they were deleted. That is part of her cover-up. When comparing the contents of the phone with few to no text messages, with the contents of the call detail records, with thousands of text messages, that's how we know they were deleted.
A great point.
When Detective Woody executed the first of the search warrants on April the 13th, 2022, and she informed Kouri Richins that toxicology showed that Eric died of fentanyl poisoning, Detective Woody seized her phone. On her phone that she got to replace the seized phone, on the phone that Kouri Richins got to replace the seized phone, these are the searches. What was Kouri Richins worried about? She was worried about the police recovering all her deleted text messages. Why? They're inculpatory. They would further prove that Kouri Richins bought drugs from Carmen Lauber to then murder Eric Richins.
Google searches will get you. Google is a snitch through and through. Those Google searches gonna get you. I wonder when they're gonna highlight the one that talks about poisoning, because that's an interesting way to say it. Here's some of those searches on the screen. I'm going to read them for those of you listening in the background. These say Kouri Richins' phone searches after white iPhone seized on April 13th, 2022. The way they are clocking the timing on some of these is because The first phone was seized, and then the second phone was procured and then seized. So this is from the second phone. So this is after police seized the first phone, so they can clock that it happened after. Here are the searches that are being shown on the screen. Signs of being under federal investigation. Can cops force you to do a lie detector test? Summit County District Attorney misspelled. Summit County District Attorney, same misspelling again. What do cops, when they seize electronics, what does the FBI, when does the FBI get involved in a case? Ma'am, you don't want that. The FBI! What is a white collar crime? Can FBI find deleted messages? Can probable cause be a testimony? What happens if you are detained but never got read Miranda rights? Ma'am, you were not in a custodial detention. Go to law school. Ask your lawyer. These aren't the only searches.
Her phone searches reveal
what she was thinking. Yeah, 100%.
She's worried about being investigated. She's worried about having to take a lie detector test. She's worried about my office. She's worried about her seized electronics.
The FBI!
She's worried about the FBI. She's worried about the FBI.
Prison is on her mind.
Prison is on her mind.
So is my...
I'm gonna let him finish. Hold on. Oh, they highlighted poisoned. If you're listening in the background, just come on back and look at this slide.
So is money.
So is poison.
She's interested in the life insurance. We don't know precisely when these searches were conducted. It's just not in the digital data. We have the data we have.
Because the rest of it was deleted.
But we do know that she hasn't been paid out yet on life insurance. And she started getting paid out in June of 2022. And this phone she got in April of 2022. So the inference is that these searches occurred between April and June of 2022. This one's the most insightful.
Poison?
If someone is poisoned, what does it go down on the death certificate as?
Ding, ding, ding.
She did search if someone accidentally ODs. She doesn't search if somebody is dead for unknown reasons. She searches if somebody is poisoned, because that is what happened.
Mm-hmm. Kouri's words are going to get her, even though she didn't testify.
Now we have to
Kouri's words are going
prove
to get
that
her.
Kouri Richins intended to murder Eric Richins.
Well, if you
Which means we have to prove that
Accidentally
Eric
OD.
Richins did not commit
It's
suicide.
not poisoning.
Kouri herself says he didn't. No mental health concerns. But the other evidence proves it as well. Eric had every reason to live. The first three of which are Carter, Ashton, and Weston. He was a phenomenal father. He protected his boys. He put his money in trust mostly for the benefit of them, to protect them. He was a protector. He's not leaving his boys. He was also planning for the future. He was a successful business person, and he and Cody had future business plans. He had future plans with his sister. They were planning family vacation to Disneyland. He was planning on buying a cabin in the Uintas with his father for the family. Every shred of evidence in this case proves that Eric did not commit suicide.
And I've never seen someone get up and clean up the area around them afterwards. They're not taking the glasses out of the bedroom. You know?
This wasn't an accidental overdose. Eric Richins did not use drugs. He did not use illicit drugs. Set aside THC gummies.
Even though he had no THC in his system.
Kouri Richins said no, never to Deputy Wynn and paramedic Offred. These are people that it would have made sense to tell he used illicit drugs to in the moment as paramedic Offred's trying to save Eric's life. But no, she was honest. Nope, never.
On the screen, for those of you listening in the background, because you have no choice, A, I'm sorry, but B, he has a timeline put up of Kouri Richins' statements and the exhibit number placed under them from March 4th, March 17th, April 15th, May 7th, June 23rd, and January 12th, and who Kouri made the statement to.
Same thing with Dr. Ulmer as they're reviewing the toxicology and trying to explain the fentanyl. Right? Dr. Ulmer's like, well, there's this fentanyl, really can't explain it. Did he do illicit drugs? No, never. Grossmann, she's honest with anybody. She's honest with Grossmann. No, Eric did not use drugs. Her best friend, another person she's honest with. Nope. Life insurance company? No. Chief medical examiner? No. And every bit of evidence that came into this case, everyone who testified and knew Eric well, his friends, his family, no, Eric didn't use illicit drugs. Not even prescription drugs. Your Honor, this might be a good place to take a break.
Oh.
Let's do it.
Let's do it. Guess what we're not going to do? We're not going to take a break. We're going to watch what they do, but we're not going to take a break.
Just a friendly reminder. Don't talk about the case. Don't allow anybody to talk to you about it.
We're going to zoom.
Do not do anything with your devices
we're moving
during
into
this break
money
related to this case at all. We'll return at 10:20. Please
moving
rise for the jury.
Into more money. For those of you just tuning in, there is no time limit for closing arguments. The state is in their closing argument. The state will go, then the defense, then the state again. Closing arguments could take all day in this case. We just got through, I think, most of count one. We haven't even, well, I don't think they're done with count one. We haven't gotten to count two, and we definitely haven't gotten to the fraud case.
Until 10:20. Thank you.
They are taking a recess to use the restroom. We are going to zoom. Kouri's faces sure have changed during closing. The snarky has left the building at this point. We're going to, I zoomed. I literally ooped. I zoomed way too far. We're going to see if there's anything on the record before the jury comes back in, because I'm always nosy. And there may be, there may not be. I honestly don't know with this case. Anything honestly is possible at this point.
0139.
All right, they're back on the record.
Bloodworth, are we ready for the jury?
Yes, Your Honor.
Ms. Lewis?
Yes, Your Honor.
Let's do it.
All right. Some of you had been worried about whether or not Attorney Ramos was there today. He is at the end of the table. He has consistently been at kind of that end of the table. And so he is there. They're going to bring the jury.
Bring the jury.
Which we didn't even do today.
Bring the jury.
We did fly to Utah earlier. If you didn't get your frequent flyer miles, don't worry, we'll fly again. I'm going to zoom while we wait for the jury to come in and get in. It looks like to finance. I think the prosecution
Mr. Bloodworth,
organization
make sure that mic is still on, and please proceed.
Is some
Very
of
good.
my favorite.
Thank you, Your Honor.
Bloodworth is not afraid of an intentional pause, and I think it works to
We
his
call
effect.
at the outset of closing when we were looking at the aggravated murder charge.
These are the
I
finances
mentioned
up on
the
the
first
screen.
two elements are murder, and then we get into the two
Pecuniary gain.
aggravators. So the closing up until now has been the murder charge. That is straight murder, but the state, of course, has charged aggravated murder. So now we'll talk about the two aggravators. The why aggravator, money motive, and the how aggravator, administering any substance in a lethal amount. You'll recall Brooke Carrington's testimony. And when she began her forensic accounting analysis, this drew her attention.
This accounting was so good.
The number of overdraft and non-sufficient funds transactions beginning in April. That jumped from 1 in September to 37 in October, beginning in October. That jumped from 1 in September to 37 in October to 77 in December. And Brooke Carrington's analysis was the beginning of the downward financial death spiral. Then Ms. Carrington analyzed the overall debt, and it showed a growing debt picture nearing $8 million in debt when Kouri Richins closed on the Midway Mansion.
I like
All
that
the
they
while,
used what was used in the case
she's not paying it off.
in their closing.
She's barely sending her creditors any money. And it's never an increasing amount of money. It's flat.
That debt gives me anxiety looking at it. It's just,
The payday loans particularly showed distress to Ms. Carrington. This isn't a traditional mortgage. This isn't even hard money lending. This is, give me money today, I'll give you money when you get paid at an extraordinary, exorbitant.
give me money today. I promise I'll get you back. This goes all the way through
Brooke Carrington
to total
solved
debt
this,
paid. Trying to move me out of the
she
way a
sees
little
the
bit.
line here go flat. Payday lenders would no longer lend to Kouri Richins.
I wonder why.
She was barely paying them off, or barely paying towards them.
Yeah, he was ready to go full like Popeye.
Kouri Richins lost money flipping homes.
It wasn't Popeye who said it, was it?
You heard Brooke Carrington testify about the extraordinary growth and unsustainable level of growth for even sophisticated business people. Kouri Richins is not a sophisticated business person. She didn't even understand fundamental accounting, fundamental tax reporting.
I'm waiting for him to say she was just unserious. Business. Wimpy,
Brooke
thank you,
Carrington
chat.
plotted out the profitability analysis of each of Kouri Richins' home flips. Kouri Richins, when she bought a home, when you total up the home she bought and the loans she took out, she started her projects $2 million in the hole. When she was finished her projects, of money that Brooke could trace to expenses, she could only trace about half of it to expenses because Kouri Richins did not conduct normal accounting. Kouri Richins lost $469,000 on her home flips. But recall that Brooke Carrington testifies there's this other pot out there of $400,000 that I know she lost. I just can't trace it to a particular project. When you add those up, it's nearly $900,000 loss in flipping homes alone. Recall that Brooke Carrington said that does not count the foreclosures. While deliberating, you'll have this, and on the second page, you'll see all the foreclosures. She lost millions more in foreclosures. To include foreclosures on Chelsea Barney's home and the Midway Mansion.
Ooh, the Chelsea Barney home hurts. Also, chat, if I seem distracted, yeah, it was like 80 degrees here yesterday and I'm watching it snow. So that's me looking out my window because, yes, Chelsea Barney's home hurts. I don't think they're doubling down on it as much as they could, but Chelsea Barney's home, We'll see if they do. Chelsea Barney's home hurts. It's one of those things that you're just like, ooh.
Kouri Richins would borrow money
rough.
by any means necessary.
Yep.
6 times she submitted inaccurate bank statements to lenders to get money.
Oh, it's a lot of exhibits.
Those bank statements reflected her business account and balances in C&E's business account.
Oh, the spliced accounts.
This evidence proves the level of financial desperation that Kouri Richins was in late 2021 and early 2022.
I know it's weird. I know it might feel weird, but we are in a murder case, and somehow the Chelsea Barney house stuff hits different. I can't explain it. It just is. I get it. You get it. It is. We're in a murder case, and somehow when we start getting through some of this other evidence, you're like, oof! It just continues to illuminate the levels of betrayal here that goes beyond just her spouse.
The next level of financial desperation is taking $45,000 of your best friend's hard-earned cash tips from waitressing, telling her that you are going to apply that as a down payment to a mortgage on her house where she lives with her partner and her children.
They're showing Chelsea's testimony on the screen.
And then diverting part of it to pay off Fund 5 Merchant, a payday lender.
And they're showing where the money went on the screen.
And spending the remainder of it, as Brooke Harrington testified, on expenses to rehabilitate homes and servicing existing debt.
They're
Then
continuing to show Chelsea's
telling
testimony.
your friend, your best friend, since middle school, that you applied the money to the loan, here's the deed, sign the deed, and then not filing it. You will see, if you review that Brooke Harrington's schedule that had all the property transactions, you'll see that not only did Kouri Richins not file the deed, she took out another loan on the house.
Put the house
That's
up as
the loan that
collateral.
was foreclosed on, that resulted in Chelsea Barney, her partner, and their children getting evicted.
Yep.
And losing their life savings. That is the next level of financial desperation that Kouri Richins was in January 2022. There's the tax liabilities. In the grand scheme of the amount of debt, 150 grand in tax liabilities is de minimis, but they were on her mind.
The taxes aren't the worst, but she was calling the IRS. And they're putting up some of Brooke Harrington's
There's an
testimony
interesting
on the
little
screen.
nugget here. She underreported her expenses in flipping homes to her tax accountant, which resulted in her paying more taxes than she would have. One would think,
why would you do that?
A sophisticated business person would think to limit their tax liability. That's not what interested Kouri Richins. What interested her was the appearance of success in business, the appearance of affluence, And by underreporting her expenses, it looks like she made more money than she did, and she appeared more successful than she was. Because she cared not about being successful, she cared about her facade. She cared about appearing successful. You'll recall that C&E distributed $36,000 to pay some of this $150,000 tax liability, which Kouri Richins then diverted to close on a home. And her tax liability was on her mind 2 days before murdering Eric Richins. She spent over an hour and a half on the phone with the IRS.
And for those of you that did not watch the entirety of trial, no shade because it's been busy, but yes, the last 4 digits of the line for the IRS she was calling is in fact 1040.
It was on her mind because if the IRS moved on her tax liabilities, Eric would find out. She had to fix it with the IRS before Eric found out. You're familiar.
Yep.
Kouri Richins needed cash immediately when she murdered Eric. Eric's long-term earning potential, immaterial. She wanted to close on the Midway Mansion. She had no money to refurbish it, to flip it right away, to run it as an event center. But she was going to close on it. She needed money now. Doesn't matter if Eric's going to earn a ton of money down the road. That does not help her now with the Midway Mansion. It does not help her now with servicing her existing debt. She needs money now because she's closing on the Midway Mansion on March the 4th. And when she closes on the Midway Mansion, it's worth $2.9 million. She's borrowing $3.2 million. None of it's her money. She's reaching into other people's pockets to get that money.
That she was able to borrow that much money. It just, after all of this,
Not
it still
only does
blows
she
me
want
away.
money to purchase the Midway Mansion, she wants $87,000 for herself. She takes out $87,000 at closing, and how does she spend it? Servicing existing debt and expenses for rehabs.
He did. I know. I saw the OPP.
She ultimately closed.
Should we rewind it?
On the Midway Mansion.
Should we rewind it? Should we rewind it? We can. We can rewind it. I know. I know. You guys asked. I am so locked in. There are parts of this that I didn't even catch, like the money she took out. We'll rewind it. I think
it's worth $2.9 million. She's borrowing $3.2 million. None of it's her money. She's reaching into other people's pockets to get that money. Not only does she want
it was smooth
money to purchase the Midway Mansion, she wants $87,000 for herself. She takes out $87,000 at closing, and how does she spend it?
Chat feels vindicated.
Servicing existing debt and expenses for rehabs.
It was a very natural OPP.
She ultimately closed
better than other people's pennies. The other people's
on the Midway
pockets.
Mansion the day after she murdered Eric. There's an interesting thought here. Did she close on the Midway mansion in spite of murdering Eric?
Or because?
Or did she close on it because she murdered Eric? She hedged. She was supposed to close on the 4th. She didn't want to close until she knew Eric Richins was dead. Because she knew she would have his money. She knew she could do something with the mansion. And that's why when everybody else signed on the 4th, or in advance of the 4th, she signed on the 5th. It's unconscionable that she closed in spite of his death.
Defense has their mics on.
It's unconscionable that she closed because of his death.
Defense has their mics on. They can just push them off. They have not. But they're making notes about their closing. The defense gets to respond to what the prosecution said, and they have to weave that into what they've already
This is
prepared.
probably Kouri Richins' true plan for the Midway mansion. And if Eric had not put most of his assets into trust, it could have happened.
This again, for me, this again goes to Kouri didn't know. What they're showing on the screen is a text between Kouri and Grossmann from February 23rd, 2022. Kouri says, I don't know which way to interpret that, but anyway, I have a crazy dream. You quit your job. I thought he was working for you for free. Whatever. You quit your job. I divorce and come up with millions and millions. We buy Midway and live in the guest house and rent out the huge house as a big event center. $15,000 a day like they charge down the road, maybe $12,000 to stay competitive. And we will just run the event, quote unquote, center as our daily job and hang out every day, raise some kids, have a little farm. Deal? February 23rd.
Recall Brooke Harrington's testimony that after closing on the Midway mansion, Kouri Richins' liabilities were right about $8 million, and she was in the hole $1.6 million. Her net worth was negative $1.6 million when she murdered Eric. And that her business was in financial distress, her financial enterprise was collapsing, had been collapsing, and but for a significant infusion of cash and capital would continue to collapse.
That's what Brooke said.
That significant infusion of cash and capital was supposed to be Eric Richins' money. You have a fortunate perspective during this case in that you get to observe the defendant. You get to observe Kouri Richins. And you observe her affect with some when some witnesses testify, and you observe her affect change when other witnesses testify. You observed that when we played the 911 call during trial, her affect was flat, no emotion. You also observe that when Brooke Harrington testified about the financial distress of her business, she was exercised. Because that testimony pierced her facade. It pierced her facade of being a successful...
I don't think I've ever heard anyone use that like that. She was exercised. And I have exercised. Emily, no. The defense is just a full like... Wow, okay. I want to hear what Bloodworth says, but I was not tracking the use of the word exercised, so I'm going back.
You also observe that when Brooke Harrington testified about the financial distress of her business, she was exercised. Because that testimony pierced her facade. It pierced her facade of being a successful, privileged, and affluent person.
Yeah, she didn't like that.
It was a narcissistic injury.
Oh, shit.
She was bothered because the world saw that she is indeed not a success and not affluent. The bulk of Eric Richins' estate was in insurance coverage.
The defense.
Some of it got
lots
paid out
to
to
say
the
over
trust.
there.
Some of
A lot of you are asking in the chat, is that improper? They're allowed to comment on what's observed in court. So he can comment on how Kouri behaved in court. He can't comment on her decision not to testify. He can't comment on, and you've never heard from her, but he can comment on courtroom demeanor.
it got paid out to Kouri Richins.
Especially if he can catch it.
Kouri Richins knew this.
Because he saw it.
Knew that
in
much
court.
of his estate was insurance coverage. And different than taking money from Eric's home equity, different than taking money from Eric's bank account, to take Eric's insurance money, Eric has to die.
I wish the defense would just mute their mics. I agree, it's distracting.
Now for the aggravator of administration of any substance.
We're only on to the second aggravator.
Any substance in a lethal amount. The substance here happened to have been fentanyl. Could have been any part of the illicit street drug that she bought. Happened to be fentanyl that she administered in a Moscow Mule and a shot or a shot. But we know that's how she administered it because it was in his belly.
Right. It was in his belly, and she said it.
We know it was a lethal amount.
They really did a good job on the
Fentanyl
pauses.
killed him. That's the substance. Lethal amount can be as small as 3 nanograms per milliliter. And in this case, he had 15. 5 times what can be a lethal amount. That, by the way, is not an accident. That amount of fentanyl shows that Kouri Richins wanted Eric not only dead, but good and dead.
Oh, shit. Oh, I wonder if this will spill over into talking about the attempted murder, right? She didn't just want him dead. She wanted him good and dead. She wanted him actually dead because of February 14th.
Now, count 2.
Yep.
The aggravated
that makes so
murder.
much sense.
The elements are the same as count 1. The only difference is attempt. Attempt requires, as the court instructed, a substantial step. There's plenty of substantial steps, from ordering the drugs to making the Moscow Mule. Here, the aggravated murder count proves the attempted aggravated murder count and vice versa.
Yeah, that's a good segue.
The commonalities between Kouri Richins' conduct are not coincidental.
And he's got a timeline for those of you listening on the background. He's got a slide that says the aggravated murder proves the attempted aggravated murder and vice versa. And it shows February 14th, attempted aggravated murder, drug buy 3 days out, February 11th, call with the IRS 3 days out, financial stressor, Chelsea Barney's house, gives Eric a sandwich, leaves Eric Richins alone, goes to Utah County, delayed response, never came home. And then they've got that equal to what's going on March 3rd, drug buy 5 days out, February 26th, call with IRS 1 day out, financial stressor, Midway Mansion, gives Eric a drink, leaves Eric Richins alone, sleeps with children, delayed response, 911 call. And analogizes the pattern to each other.
In each instance, she purchased drugs from Carmen Lauber a few days out. In each instance, she spoke with the IRS a few days out. taxes were on her mind.
Interesting.
Eric would find out if the IRS was after them. In each case, she had an immediate financial stressor. We just discussed closing on the Midway Mansion. If you look at Brooke Carrington's materials, she had a note due on Chelsea Barney's house shortly before February the 14th. She had an immediate financial stressor in each instance. In each instance, she administered the substance in a way that Eric would ingest it.
Great
On
slides.
Valentine's Day, it was a sandwich. When she murdered him, it was a drink. Notice that she learned from her mistake.
That's what he said.
One can season a sandwich with fentanyl. Eric can eat it, tell something's wrong, set the fentanyl-laced sandwich aside.
Not in a shot, not in a drink.
You throw a lemon drop shot back. By the time Eric would notice, the shot was in. It was in his body. Moscow Mule, just to be good and sure.
Wow.
In each case, she leaves Eric alone. She distances herself from the dirty deed. She leaves the bedroom when she murders him. She leaves the county when she attempts to murder him.
Song lyric, not commentary. Sorry, chat.
That's part of her alibi. Not only can she not be present, she has to be distant. So that when she calls 911, she says, I wasn't even there. I was in Utah County.
Great parallels.
And in each case, she has a delayed response, right? It's the delayed response in calling 911 when she murders him. And it's her delayed response in returning home when she failed to murder him. The element of, again, is it Kouri Richins? Yes. She is the person with the means, the motive, and the opportunity. Nobody else.
This goes to the attempted murder February
Means,
14th.
Illicit street drugs in the sandwich, the motive, money, fresh start at life, the opportunity, she left the sandwich in Eric's truck.
I wonder if he's going to save the line from her friend staking, don't eat what Kouri gave you, till the end. I'm curious, because this seems to be the place where that is popping up in my mind, that her friend staking said, I mean, we joke, don't eat what Kouri gives you. And then she kind of looked at Kouri and was like, I wonder if that's going to be the end of the rebuttal so the defense doesn't comment on it, because the defense probably won't bring that up. I would probably leave it till rebuttal. It would fit here. I would probably leave it till
or
rebuttal.
knowingly cause the death of Eric Richins, right? It's attempt, so attempted to cause the death of Eric Richins. The same reasons. She told Becky Lloyd it would be better if he were dead. She wanted the Michael Jackson stuff, the lethal stuff, the fatal stuff, the stuff that kills. She wanted Eric Richins' life insurance. You only get life insurance
if someone's
when
dead.
Eric's dead.
I'm glad they panned away from Miss Nestor.
The commonalities persist.
Scratching her nose on the inside.
Kouri Richins ordered fentanyl from Carmen Lauber, or ordered something from Carmen Lauber. The Michael Jackson stuff, the fatal stuff. Carmen says, I told her I could get her fentanyl. She said, okay, get the fentanyl. But she ordered illicit street drugs from Carmen Lauber, who got them from Robert Crozier at the Maverick in Draper.
The Maverick and Draper is going to become a landmark of a different
volume
kind.
of calls during the drug purchase between both Kouri Richins and Carmen Lauber and Robert Crozier and Carmen Lauber. And
This
recall,
is
we
showing
don't
the
have the contents of the texts
cell phone data
because they were deleted from Kouri Richins' phone, deleted from Carmen Lauber's phone, and Crozier lost his phone.
So many rehomed phones.
The IRS was on her mind. She called him twice, 3 days before attempting to murder Eric Richins. We know she placed the call to the Mirror Lake Diner to order a potentially fatal sandwich. We know that
Weird
Kouri
that
ordered
jail
it.
call about the sandwich.
Kouri picked it up in person. It was swiped. Don't know if you can tell that's Kouri Richins' signature, but notice it's one stroke. There's no pen lift. We'll talk
Back
more
to
about that in a minute.
Throckmorton. We'll talk about that with the forgery, I imagine.
Kouri Richins then distanced herself. She left the sandwich for Eric, and she drove an hour away to meet up with Josh Grossmann on Valentine's Day. There's another commonality between the attempted murder and the murder, of course. They're big days. Losing your husband on Valentine's Day, that garners extra sympathy, extra attention. Losing your husband the same day you're supposed to close on the biggest purchase of your life, that garners extra attention. The type of attention that Kouri Richins relishes in.
She did not like that at all. Ma'am, you're not
You
supposed
heard
to like
Kouri
what
Richins
the prosecutor says
testify
about you.
how
It's-
Eric was a cowboy
trying to
when it came to injury or
prosecute
illness.
you.
He worked through it all. He cowboyed up. Cowboys don't go to the hospital unless they're near death. They don't even think about going to the hospital
So exactly like
unless
farmers.
they're near death. And at 11:33, Eric's thinking about going to the hospital. And then all the activity, the physical activity on his phone ceases. For 87 minutes in the middle of a busy workday.
It's good evidence.
Shortly after activity resumes in Eric's phone, he calls his best friend and business partner Kouri Wright. Recall Cody said he could hear the fear in Eric's voice, a fear he'd only heard twice before, both times associated with death. A fear he heard when Eric told him his mother had passed away, and a fear he heard when someone who struck Eric's truck in an automobile accident, and Eric thought that person might have passed away. He then spoke with his hunting buddy and close friend Josh Kays. You know and learn a lot about somebody
He's tied that together well.
when you hunt together and travel together. And Josh Kays said Eric sounded somber and serious. Josh asked Eric perhaps the two most pertinent questions. If he was going to the hospital, and what was he going to do about it? Let's turn to alley staking, singular, not plural.
Well, no, Mr. Bloodworth, we can't have you talking about stakings. Singular. That was funny.
Clearly close with Kouri. Friends since
Still
middle
close
school.
with Kouri. Still loves Kouri.
You observed the banter when Miss Staking was testifying, the banter between her and Kouri Richins. It was friendly.
Even on the stand,
She's
it was
still
friendly.
friendly with her. And Allie Staking testified about how a week or two after Valentine's Day when Kouri Richins attempted to murder Eric. When I questioned her, she said, well, Eric jokingly, kind of jokingly, maybe jokingly said that Kouri Richins tried to poison me.
My wife tried to kill
Perhaps
me.
joking. But Kouri Richins' reaction is what was important here. Kouri said no. She got defensive. That is not what happened. It was like an allergic reaction or something. It wasn't at all dramatic. She is covering up her poisoning him. Then when defense counsel questioned mistaking,
What'd she say?
mistaking kind of backed off the jokiness of Eric's comment and attributed the jokiness to everyone else. Ali Staking said, well, defense counsel questioned, what did he tell you? That he believed Kouri had tried to poison him. Maybe it was one of those joking things like, I'm sending a message to Kouri Richins. I know what you tried to do. I'm joking about it, but I'm going to let you know.
I know you
Maybe
know.
he was serious. Either way, comes back to Kouri Richins trying to poison him on Valentine's Day. Kouri Richins repeatedly tries to cover up that she tried to murder Eric on Valentine's Day.
I'm going to pause this and read what's on the screen because I don't think he's going to, and I think it goes to the state's points that Kouri Richins' words are going to be what they talk about most. This is a text from June 18th, 2022 from Kouri Richins to Chelsea Barney. I didn't even make him a fucking sandwich, those fucking idiots. I'm not a sandwich maker. I bought the damn sandwich. Ugh. I didn't even make the sandwich. Fucking idiots. Sorry, that was a lot of exposition in there. I'm going to keep reading it. She said it was Valentine's Day and Eric and I both were working from home that day and I ordered lunch from Mirror Lake Diner. It definitely wasn't lunch. He never broke out in hives or used an EpiPen. I was fucking with him. I think we can put a comma in there and change the meaning of that sentence, but we're going to let it go. He said the sandwich hurt his stomach, so he was going to nap. No hives, no EpiPen. They are such liars. And then he woke up and went to work. We also have transcript from the call between Kouri and her mother, Lisa Darden, who picked up the sandwich from the diner. Kouri, are you asking me that? Her mom, yes. Kouri, oh, I did. Mom, I thought so. Okay, that's enough of that. Ronnie said, no. I said, Ronnie, yes. And there was something about a love letter put on a seat of his truck with the sandwiches. I said, I don't think so, Ronnie. I never heard that. I said, I believe they were eaten in the office. Supposedly Kouri said yes. Mom says, you put a love letter on the seat of his truck with the sandwiches. Kouri said, no. Lisa said, yeah, exactly. Kouri said, they were ate in the office.
She says she was home with him. She tells her best friend, Chelsea Barney, I was home with him. She was not. She was with Josh Grossmann. She did not come home until after 6:30 p.m. She was saying he never broke out in hives or used an EpiPen. That means he broke out in hives and used an EpiPen. When she spoke with her mother on August the 22nd,
I wonder if they're going to play it.
when she says she didn't put a love note and the sandwich in the front seat of his truck, she put a love note and the sandwich in the front seat of his truck. She is trying to distance herself. She is trying to cover up. She is trying to deflect.
Why? Because it seems more heartless to leave a poisoned sandwich with a love note and then go to your lover's house versus not leaving a note with the sandwich and going to your lover's house? A book lover said, not in evidence. This is in evidence. It's in the jail call.
When Eric said he was thinking about heading to the hospital, what does she say? Take a nap. Call me when you're up.
I hope you lay down and sleep.
She's saying that thinking he will take a nap and not wake up.
Uh-huh. Why don't you lay down and sleep? Oh, the timeline of the text. I wonder if they're going to juxtapose these with the text with Grossmann. This is Kouri Richins being not responsive as Eric's texting her. And we are seeing text back and forth. Eric in green, Kouri in blue. Eric, are you home? Kouri, no, in Provo, waiting for my cabinet installer guy. Are you home? In the office, been sleeping out here. Kouri, how you feeling? Okay, wish you were here. Kouri, I would cuddle you. Head him back in 20. He just got here. That's at 1:49 p.m. 3:48 question mark. 4:06, she responds with 2 question marks. He says, thanks for answering. She said, did you call? You didn't call. At 4:27. At 6:34, we are headed in there. Food is on the front seat of my truck.
When he does, Eric texts Kouri. He's asking if she's home because he had just said, I'm going to hospital. Then he had stopped communicating, or he said, I'm thinking about going to the hospital, and then stopped communicating for nearly 2 hours. He's figuring she was coming home to assist him, but she wasn't. She's in Provo waiting for a cabinet installer guy. Maybe.
A different kind of cabinet installation, my guy.
She says then she's going to head home in 20 minutes. Nearly 2 hours later, question mark, where are you? You were heading home 20 minutes ago. She responds, what? Thanks for answering. Did you call? You didn't call. She thinks he's heading home. She's not. She's trying to figure out what to do. She's trying to figure out what to do because Eric survived. She had not planned on that. She is delaying to make her plan. And then at 6:34, Eric texts, we're headed in there. Food is on the front seat of his truck. The same place she left the poisoned sandwich with the love note. Eric Richins is telling her, I know what you did.
She doesn't agree with that argument based on her face. Her face is facing. She does not agree with that
That
comment.
is the attempted aggravated murder. But that's the attempted murder. Now, of course, we have the 2 aggravators. They're the same. Same as with the aggravated murder. The money motive.
Pecuniary
same.
gain.
Similar financial distress. Same. There's also the first start at life motive, right? That hasn't changed a bit.
I don't think they need to
Josh
go into
Grossmann.
that all that much.
It's Josh Grossmann on Valentine's Day, and he's Josh Grossmann on March the 4th. Money motive the same. Fresh start at life motive the same.
Yeah.
Now the second aggravator, administration of any substance in a lethal amount.
I think they
Recall
do need to
Dr. Eric
focus on this.
Richins' testimony that hives, EpiPen, all consistent with an opiate-like or an opiate allergic-like response, a pseudo-allergic response.
That's part of why they called this witness.
Hives, EpiPen, along with zero activity, shows that Kouri Richins attempted to administer the illicit street drugs that she bought 3 days earlier from Carmen Lauber in a lethal amount. She just failed.
which explains more about what happened on March 3rd, 4th, right? That's what they're arguing. She didn't do it properly.
Next guy.
So she tried.
Okay, the insurance fraud.
Again.
There are two insurance frauds. Let me distinguish them, please, for you. The first one is a scheme charge, a fraud scheme. The second one is a fraud claim charge.
All right, just asking real quick, Chad, if you had forgotten there were insurance fraud charges in this case, it is not your fault. They zoomed right through it to tie it up in closing. If you forgot that there were 3 other counts other than murder and attempted murder, go ahead and let me know in the chat, because fair that there are 2 insurance fraud counts and then 1 forgery count. They scooted through this testimony fairly quickly, but all the testimony came in. But if you hadn't kept your eye on these counts, they might have just kind of gotten washed in with all the financial stuff, which is fair. But I appreciate that he's going to break these down a bit, because it's easy to just be like, wait, what?
Them, please, right. For you. The first one is a scheme charge, a fraud scheme. The second one is a fraud claim charge. Count 3, the scheme charge relates to the $100,000 True Stage policy. We're going to put it up in a minute. The fraud claim charge relates to the $250,000 True Stage policy. The forgery, which we will get to,
the signing,
is a forgery related to count 3, the scheme charge.
Signing.
Let me unpack them now. Okay. Different than the aggravated murder and attempted aggravated murder, I'll address all elements of the insurance fraud scheme kind of at once, because they all jump out of this single page. And the scheme is quite simple. Kouri Richins wanted to murder Eric Richins, thus took out an insurance policy on his life to get money for murdering Eric Richins. Then she murdered Eric Richins, and then she submitted a claim to get the money. That is the scheme. And we know it was Kouri Richins.
I'm still stunned they paid her, honestly.
Everything on this application for this $100,000 True Stage insurance policy returns to Kouri Richins.
I think the
Kouri
defense
Richins
probably
received-
has their best argument here with like, look, she didn't just put in the P.O. box because she wanted to. It was already pre-populated. I think the defense can make some headway here, though I think if the jury's already like, no, we believe she was already planning on murdering him at this point, it's just all going to go together.
The application, because she was a member of PED-FED, the application was addressed to her at her work address, so she would have been the one to receive it. If there was any questions about it, any further follow-up mailings about it, they would go to her and not to Eric. This applicant information is all her, but the partner information is all her as well. Her work address, no email address where they could contact Eric. We'll get to the Social Security number in a minute. The primary phone, that's not Eric's phone.
No, it isn't.
You'll see that Eric's phone is 801-792-9317. And when you look at this closely during deliberations, you'll see that was originally a 7 that she later marked up to read like an 8. She initially wrote his correct phone number, then did not want anyone from True States to call him, so she changed the 7 to an 8.
That's an interesting detail.
So that Eric would never know that this policy existed.
Why change the number if he said, yeah, sign it?
After Kouri Richins took $250,000 out of Eric's home equity, he put all of his insurance that he knew about into the trust.
That part.
If Eric had filled this out, the beneficiary would have been the trust, not Kouri Richins. Then we'll get to the signature. That's the fraud count 5 as well. It plays into this. We'll talk to it during count 3.
That is a very good point with the beneficiary information. He knew that everything was beneficiary to the trust. So why would he make this a beneficiary to her and undermine the trust that he set so much time and effort and money setting up? It's a really good point.
But it's also the freestanding charge in count 5. Let's go to the next page. The Social Security number was blacked out for privacy reasons on the application we just reviewed, but you'll recall Ann Coates testifying that the last 6 digits were transposed. We all know our own Social Security numbers. We often get a little bit confused on our spouses. Eric did not sign the application.
This goes to the forgery.
Matt Throckmorton, the handwriting expert. Eric did not sign it. It was probably a simulated forgery.
I like that he brought up the evidence used in trial on this slide, because you can see it.
Recall his testimony that Eric Richins has pen lifts in his signature. The forged one didn't have any pen lifts.
Just
You'll
like
see
the
Kouri
diner.
Richins' signature throughout this case. No pen lifts.
She didn't know you were supposed to. She didn't study handwriting.
Then, Kouri Richins filed a claim for this $100,000 two-stage policy. It's actually the same claim for both policies.
I think we'll see some argument about this from the defense.
She really does not know where her husband, Eric, got the fentanyl from. Of course she knows. She ordered it from Carmen Lauber. That is the fraud scheme. Plan to kill Eric, fill out life insurance so I can get money for killing Eric, kill Eric, and then claim the money. Now for the insurance fraud claim count. Count 4.
I like that he's walking through these counts. I think it's needed.
This is the true stage $250,000 policy. This is the claimant's statement filled out. Kouri Richins, beneficiary.
I mean, I watched every minute of this trial with all of you, and I still forgot this document. I know we saw it. I know we talked about it. Still forget. So this is the $250,000 policy. This is the claim statement made to the insurer.
Kouri Richins' email.
I imagine he'll get into Kouri calling them and finding out where the insurance
Kouri
is and what's
Richins'
holding it up.
address. Everything about this claim says Kouri Richins is submitting this claim.
That's her handwriting from everything that we've seen.
And then
the phone calls.
Like before, the fraud here, the falseness of it is she says she doesn't know where the fentanyl came from, when in fact she ordered illicit street drugs from Carmen Lauber. And indeed, later in the Walk the Dog letter, admits to asking Carmen for fentanyl.
These calls I remember very well. And And that's what he just showed on the screen.
Finally, count 5, the forgery charge.
Signature.
We've discussed most of the forgery when we discussed count
Throckmorton.
3. But there's this without the authority to do so element. It's not a forgery if Eric gave Kouri Richins permission. The state has to prove that Kouri Richins did not sign Eric's name with permission, with authority.
And this is the last count. I imagine they're just about done with the first part of their closing. Because why would he have given her
All of
permission?
the evidence in this case proves that Kouri Richins does not ask for permission, she takes.
I mean, that's true too.
She took with the home equity loan. She took other people's money. She's a taker, not an asker.
She's a pusher.
Finally, like I mentioned earlier,
Mean Girls.
Eric Richins, the evidence proves, would have put the trust as the beneficiary, not Kouri Richins. If he had given permission, it would have been permission to make the trust the beneficiary. That's the forgery charge.
And I think we see that in her phone call that's recorded.
Let's please now turn to Kouri's motive for a fresh.
I think we see that in the phone call that was recorded with Bryce, where Kouri is saying in that phone call, Eric didn't want me to have the money from the HELOC, but I took it anyway because I bet on myself. And I was right. I bet on myself and I took that money and I turned it into $11 million. I took that money and I was right. So no, I don't feel bad about it. I should have. I should have taken it because I was right. I bet on me and I was going to bet on me.
Start at life. You heard the instructions. The state does not have to prove any motive except for the pecuniary gain motive because it's an aggravator. But motive explains why Kouri murdered Eric Richins, why she attempted to murder him. Motive explains a lot here. These texts at this point are familiar.
These are the texts between Kouri and Grossmann. December 18th,
The
February
day
15th,
after
February 19th,
Kouri
February
Richins
23rd.
speaks with Becky Lloyd and tells Becky Lloyd Eric she would be better if Eric were dead, she texts Josh Grossmann that she's in love with him, a man not her husband.
I didn't put the
I was
timing
divorced
on that
right now and
together.
asked you to marry me, would you? That's the day after the attempted murder. If he could just go away and you could just be here, life would be so perfect. We're familiar with this text. We've read it
a lot
already today. I ask you to read it again. This time, replace the word divorce with the word murder.
She wasn't planning on getting a divorce, is their argument. We've seen that from the beginning. She wasn't planning on getting a divorce on February 23rd when she said, I come up with millions and millions and we buy Midway.
This graphic shows a juxtaposition between Josh and Eric that is insightful to what Kouri thinks about each of them. In each instance, she is texting, well, she is kind of simultaneously texting. These are laid out chronologically. She is simultaneously texting with both Josh and Eric about closing on the Midway mansion.
They have now started to insert Eric Richins' text. I was wondering if we were going to see Eric's texts in like the timeline in here. I wasn't sure if we would or not. And here we see it, and I've paused it to read them. You've got Kouri texting and then Eric texting. So Kouri's texting March 2nd at 9:16. I just can't even believe this. I want to celebrate with you while Friday, when it's officially closed, recorded, and we're done. She's texting that to Grossmann. Then she texts Grossmann, love you, love you, love you. Thank you for always being my support, shoulder, and rock. I need you all the time. Some things I just could never do without your encouragement. You have no idea how much I appreciate you. And then Eric Richins texts her a minute later, want to grab lunch today with a celebratory shot. Kouri texts him back, I can't. Celebratory shot tonight. I got to do all this final paperwork this morning because everyone is funding tomorrow. And then she's texting Grossmann. Tell me you're worth millions a year. I'm honored to be your best friend. I'm honored to be your best friend, actually. Lover, go to. Life is going to be different. I promise. You're one hell of a patient person. I hate your hard days. I wish I could be there to turn them around. Can I try Friday? Give me a few days. Hang in there until then, please. She texts that to Grossmann on March 2nd at 6:46:50 p.m.
And she's so excited she is so excited.
She just can't hide it.
Texting with Josh. I can't believe it. I want to celebrate with you. Love you, love you, love you. Thank you for always being my support, shoulder, and rock. I need you all the time. Some things I could never do without your encouragement. You have no idea how much I appreciate you. Eric tries to reach out. You want a shot? Can't. Sorry, busy.
Nope.
Then right back to Josh Grossmann. To me, you're worth millions a year. I'm honored to be your best friend, your lover, your go-to. Life is going to be different, I promise. You're one hell of a patient person. I hate your hard days. I wish I could be there to turn them around for you. Can I try Friday? Give me a few days. Hang in there until then, please. By Friday, of course, Eric Richins was dead. Kouri had murdered him.
Right.
She's right. Life's going to be different.
Yeah, it is.
She promised him. It was.
Eric's family is sitting in the courtroom watching this get laid out. It's got to be hard.
Then, 16 days after Kouri Richins murdered Eric, are we there yet?
This is the text about the vacay to St. Martin, to Secrets.
And then 1 month later, Kouri's ready for Kouri's ready for Josh to be her husband. Josh Grossmann loved Kouri Richins. He believed that she loved him. Not sure that's true.
I think that's fair commentary. In argument.
You saw him testify. He was gutted.
He was. I agree with that.
He's a grown-ass man gutted.
I never thought I would hear Bloodworth standing in court saying, this grown-ass man. Wow, but he did. Damn. And Grossmann was a puddle when testifying. I had to back that up. Yeah.
You saw him testify. He was gutted. He's a grown-ass man gutted. You also observed Kouri Richins' affect when he testified. Flat.
Gutted is a great use of word. I mean, I'm really partial to it because it was also my use of word for how I thought Grossmann testified, which we talked about when we were trying to find the words.
The evidence proves
around how Grossmann testified. But gutted is
Kouri
the
Richins
right word.
Murdered, attempted to murder Eric Richins. And that she committed 2 counts of insurance fraud and forgery. The evidence does not support any other rational explanation.
I think he might be done with his part of the closing. I imagine they'll take a break.
The state, since its opening statement, has stressed the requirement to consider the evidence that has been admitted and not what the attorneys say. What the attorneys say, insinuate, speculate, is not evidence.
Oh boy!
Please let me show you why the state has stressed this. In the defense's opening statement, counsel said that the evidence will show that Kouri Richins had a 1/2 interest in the Willow Court home. There is no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show that Eric was always checking Kouri's phone.
Oh boy.
There's no evidence of that. Defense counsel said that the evidence will show Eric and Kouri Richins went to marriage counseling. There's no evidence of that. Defense counsel said that the evidence will show in the few weeks before Eric died, his closest friend thought that he and Kouri Richins were the happiest together that the friend had ever seen. There's no evidence of that. Defense counsel said that the night Eric died, he and Kouri Richins had their drinks and set their cups in the sink. There's no evidence of that. Defense counsel said that the evidence will show that the cups were sitting in the sink and the nanny put them in the dishwasher the next morning and they still had fluid in them. There's no evidence of that. Defense counsel said that Eric talked to a friend named Scott Wagner at 10 p.m. the night he died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show Eric unlocked Kouri Richins' phone at 10:30 p.m. the night he died, and this is the last thing that he did.
Oh boy.
There's no evidence of that. Defense counsel said that the evidence would show investigators interviewed Kouri over and over and over again about what happened the night that Eric died.
It does show they interviewed her at least twice.
There's no evidence of that.
Over and over and over again, no, but at least twice.
Defense counsel said that the evidence would show that law enforcement secretly recorded Kouri Richins' phone conversations for over a year after Eric died.
Did they say that?
There's no evidence of that, and indeed contrary evidence. Defense counsel said that you will hear Kouri Richins telling her family that she purchased pain pills for Eric at his request.
It's in the walk the
You
dog
did not
letter.
hear that. Although she did write it in the walk the dog letter.
Fair.
4 months after she was arrested. In listening to defense counsel's closing argument, please only consider the evidence that has been admitted.
Damn, Bloodworth. I imagine the court will take a break. However, a lot of you have asked the question, Emily, can the prosecution comment on what the defense showed and didn't show without burden shifting? Yes. They did not say that the defense had to show you this. They said defense said the evidence would show this. It did not. That the evidence would show this. It did not. That the evidence would show this. It did not. They're not saying the defense has to show you. The defense failed to prove. The defense said the evidence would show. The evidence did not show. Because the defense did not have to make those statements in opening. The defense said the evidence would show this, and it didn't. They called back to the defense opening a couple times. And at the beginning of this, we heard him say, this is not a wife becoming a widow. Also hearkening back to the defense's opening. I'm curious if the court's going to take a break for the jury, so I'm going to see what the court's going to do. But I think it was a well-organized closing, great use of exhibits, great use of audio-visual, went through it, I don't think with more detail than was necessary. Definitely definitely left no stone unturned on that and called it out. It was a good closing. It was really well organized.
Ms. Lewis.
I guess Ms. Lewis is doing closing.
Address something outside the presence of the jury before
Of course. Folks, let's give you an opportunity to
I
stretch
guess they
your
are
legs,
taking a
use the
break.
restroom. Please rise for the jury.
Oh boy, what do you want, Miss Lewis? I wouldn't be surprised if they took a break for the defense to just change their audiovisual. I didn't clock how long Bloodworth's closing was because we rewound a couple times. I think it was a really strong closing. Lewis wants to address something outside the presence of the jury.
Have a seat.
I don't know if it's just changing over their AV, because I would imagine they would need a minute
Your Honor,
to do
at
that.
this point, we'd like to make a motion for
That's not
mistrial and make a proffer on it.
What? Okay, first of all, that's not Lewis. Miss Nestor, what? What did you just say?
Have a seat.
Your Honor, at this point, we'd like to make a motion for mistrial and make a proffer on it. First of all, at multiple points in the prosecution's closing, he made efforts to dehumanize the defendant. In fact,
What?
calling her a black widow, comparing her to a deadly spider, calling her...
Ma'am, you're not serious. He's quoting the testimony. First of all, Nestor sounds like whatever she was getting sick with last week caught up to her. You're really... Oh, okay. I guess the defense is going to make a motion for mistrial. Is this what she's been taking notes on? Because she's got notes. Okay. Chad, I'm going to listen for a second. I don't know if we're going to go code red. I don't know. I don't know if we're in the realm of zealous advocacy, fuckery, audacity. I don't know where we are. What the fuck?
First of all,
maybe
at multiple points in the prosecution's closing, he made efforts to dehumanize the defendant. In fact, calling her a black widow, comparing her to a deadly spider, calling her a narcissist when there's been no evidence introduced.
Yep. Motion granted. Yep. Nope. Motion granted. He didn't call her a narcissist. He said it was narcissistic injury. Nope. I granted. The second time on the spider did it for me. Chat, code red granted, because honestly, what the fuck? If you are new to chat, welcome. Code red is our code for what the fuck is even happening. The bumper is flashy if you are flash sensitive. The flashing ends when the music ends. Chat, motion granted. Your Honor, they compared her to a spider, and it was not the itsy bitsy. How dare they? How dare they? Code red. We can't say that these defense attorneys did not try every avenue of argument. Your Honor, we hate the spider analogy. It was in... Get mad at Chelsea Barney then. She's the one that said Black Widow. So the defense, if you're just coming in here, the defense is making an oral motion for mistrial because of the prosecution's closing.
Your Honor, at this point, we'd like to make a motion for mistrial and make a proffer on it.
She doesn't even sound like she's got any energy to it.
First of all,
she's just like,
At multiple points in the prosecution's closing, he made efforts to dehumanize the defendant. In fact, calling her a black widow, comparing her to a deadly spider, calling her a narcissist when there's been no evidence introduced to support that, no expert testimony, nothing of the nature. Furthermore, it's completely improper for the prosecution to comment on her demeanor while she sat at counsel table. That's a comment on her failure to testify.
No, it's not.
Asking the jury to take into consideration facial expressions, which in his opinion may or may not have happened. I don't know what he's basing that on.
Her
But it's
face?
improper, and it's our suggestion that is a comment on her failure to testify by revealing what her response to testimony was, is calling upon her to testify in this case.
Ma'am, I hope you are feeling limbo, because that is a stretch. That is a stretch, but she doesn't even have any energy behind it. I don't know if she is just sick, because it sounds like she has been getting sick. But, ma'am, they can comment on the defendant's demeanor in court.
Furthermore, in the closing, there was wild speculation on what was in Kouri Richins' mind, completely made up by Mr. Bloodworth with no evidence whatsoever to support it.
Wild speculation,
Mr.
like
Bloodworth
argument?
wrongly told the jury that giving any illicit street drugs to Mr. Richins was sufficient to support aggravated murder. That, in fact, is not true. The only drug that would support aggravated murder would be fentanyl.
That's not true.
What he said to the contrary is not consistent with the court's instructions, and we would ask that that be corrected with a curative instruction.
That's not what the instructions said.
That they should listen, they should follow the court's instructions on
She's
what
doing her
it
job.
takes.
She's doing her job.
It would not be
She's doing her
sufficient
job.
if she bought some other type of drug that did not cause his death. That's just not the law.
No, ma'am, it has to be the drug she bought and gave to him. But the drug she bought and gave to him doesn't have to be fentanyl. It could be any illicit street drug.
Let's see, just a moment.
I'm trying, Your Honor. They're doing their job.
I think that's it,
Zealous
Your Honor.
Advocacy. She doesn't have a lot of energy behind that motion. The defense is preserving it. For the record, I just don't agree.
Mr. Bloodworth?
He's like, what? Excuse me, what?
Forgive me. I need a little bit more detail as I go through these.
Yeah.
Which of these do you want a curative instruction regarding, and which of these are you moving for a mistrial on?
Moving for mistrial on all of it, Your Honor. The curative instruction, I think, is required by the wrongful information that giving him any illicit street drug is sufficient to support aggravated murder. That's just not true. And that's super important, because if they do believe that, there is evidence to make a finding that there was oxycodone. And there was no oxycodone found in his body. So that can't support a conviction. So that's what I think requires the curative instruction.
I don't remember that
The
at
rest
all.
of it, I don't know any way you can cure it, Your Honor.
The Utah Court of Appeals disagrees with you regarding the prosecutor's comments. A long line of cases talk about the potential prejudicial effect of an improper comment by a prosecutor only being able to be measured after the defense gives its closing and the state gives its rebuttal, and we consider any curative instructions. What's your alternative position there? I could, for example, instruct the jury that Mr. Bloodworth's observations of
They
Ms.
have
Richins'
that,
demeanor
though.
are not evidence, and they are to rely
But they know that.
on their observations of Ms. Richins, if any, only.
They know
I
that.
just don't even think that her demeanor is proper to rely upon, because she didn't
Certainly can
testify.
be. I mean, she
Did you hear the court? Certainly can be. Counsel, and you should have advised her of this. That the jury will consider her face, her body language, when she looks at them, when she doesn't. It's not commenting on her not testifying. It's commenting on how she's responding to the testimony.
I just don't even think that her demeanor is proper to rely upon, because she didn't
Certainly can
testify.
be. if she burst out in laughter during the showing of the decedent's body, I don't think it would be appropriate for me to tell the jury you can't possibly consider that.
I'm sorry, but I have no idea what you're talking about. I totally trust you, but I have no recollection.
Ma'am, I don't know what the Dayquil is happening in here. The court is giving an analogy. He's not saying Kouri burst out laughing. He's giving, it's like an analogy. But she looked at the witnesses and went, what? She faced at them. If her demeanor was consistent, there would be nothing to comment on.
Of any laughter when his body was
No,
showing.
it was a hypothetical, Ms. Nestor.
Oh,
to
thank
probe
goodness.
the bounds of your categorical statement that the jury can never consider the defendant's demeanor.
I'm sorry. I thought you were saying she did that, and I was just horrified.
Please stay focused.
But I am focused. I just misheard you. So
damn, they're getting snappy with each other already.
I mean, is what you're asking me is, do we want a curative instruction now? Do we want to wait until later? Is that what the court is asking?
Right.
Why do you
Court's
want
indulgence.
Why do you want a curative instruction? Because you're going to get up and do whatever the fuck you're going to do, and the prosecution's going to ask for the same thing.
For just a moment.
This isn't going. Why do you want a curative instruction?
Okay, I think we do want it now, if we can get one now.
Why?
Let's hash that out for a second. What I proposed was an instruction that
Bloodworth said like four
the
times.
jury may rely.
Bloodworth said like 4 times. What we say is not evidence.
On their own observations, if any, of Ms. Richins' demeanor in trial, but they cannot rely on counsel's statements regarding what Ms. Richins' demeanor was.
You really want to call more attention to it? You really want to call more attention to her face? Seriously. You want to do that?
Clear, there were no comments regarding her silence.
At all. They commented on her face.
Well, I mean, it's our position that when you comment on how she looked while she remained silent at counsel table, that is a comment on her silence in our estimation. But I agree that he didn't say anything specifically about silence.
You argued it 3 minutes ago.
That instruction would be preferable to no instruction, I think.
I think that's a
The Black Widow
miscalculation.
comment was connected to comments that were made by Chelsea Barney, correct?
Yes.
I don't.
Yes.
They came out of his mouth in closing.
And he specifically referenced Chelsea Barney's testimony. Is it your position that Chelsea Barney never used that phrase or words?
I don't recall
She
her
did.
saying that.
I
but
do.
It's been a
Because we all went, not Chelsea Barney with the Black Widow comment. I definitely remember that. No, that happened.
long trial, and I would not want to make that I 1,000% am sure, but I certainly don't recall that.
I'm sure. She
It was
absolutely
in the
did. It was in
recorded
it.
phone call with Bryce Knutson.
And then
He didn't comment on the fact that your client said in that same phone call with Bryce Knutson that if she was going to kill Eric, she would have shot him in the head 2 years prior. He refrained from commenting on that.
everybody is speculating as to defendant's state of mind. It's one of the factual issues that the jury will have to determine according to circumstantial evidence, because as we instruct them, there's no direct evidence of what's in her mind. Why was anything that Mr. Bloodworth said regarding the inferences that can be drawn regarding her state of mind inappropriate?
Because they were made up out of whole cloth with no evidence to back it up.
Because we don't like it, Your Honor.
So he went to great lengths to fantasize about what she was thinking about when there's been no evidence to that. He could have certainly said, look, she could have been
It's argument. You take the only fanfic we're dealing with is the walk the dog letter. It's argument. You take the evidence and you make reasonable inferences therefrom in argument. This is so fucking weird. Why did I think it wouldn't be weird? She's gone and made it weird again. It's utterly ridiculous.
And inappropriate.
Because they were made up out of whole cloth with no evidence to back it up.
You're going to have to be more specific.
So he went to great lengths to fantasize a bunch about what she was thinking about when there's been no evidence to that. He could have certainly said, look, she could have been thinking this, she could have been thinking that. He didn't. He gave them what was in her mind, which is just based on things he made up in his own head, not based on evidence.
The petulance of these arguments. But like, Your Honor, excuse me, he like made things up in his own mind and then said them. Have you never watched closing arguments before, ma'am? This is such a weird argument. It's just such a weird argument.
They all based on his view of the evidence that came into trial. Was there any references to evidence that did not come in?
No. That's preposterous.
Well, first of all, calling her a narcissist. I mean, that didn't come in. There was no testimony that she's ever been diagnosed to have a narcissistic personality disorder. There's no evidence at all about her.
And why is that? It's because we have very firm rules in the chat about no diagnosing. And ma'am, you are making it really difficult. You are making no name calling difficult. You're making no diagnosing difficult. He didn't call her a narcissist. He said because it was a narcissistic injury, he sidestepped it. He argued, if not narcissist, why narcissist shaped? But he did not call her a narcissist. He sidestepped the name calling.
Mental condition. And then when he talked about her putting the reasoning why she picked certain days to get more attention, that nothing about that has ever come into play, ever.
Argument.
I mean, that's just one of many. He went through lots of scenarios about what she was thinking as if it was a fact, and it wasn't. So, I mean, I think he can encourage the jury to use circumstantial evidence to try to reach their own conclusions, but he can't say this was in her mind when he...
Objection, Your Honor, their closing was too effective. We need a little more distance between their closing and our closing. They said about the distancing, and we need some distance between their closing and our closing. We're also going to engage in the distancing. Distance.
He doesn't know.
We would like more distance, please.
Okay. Anything else?
I think that's it, Your Honor.
That's wild.
Mr. Bloodworth, go ahead, sir.
Your Honor, were there any particular
Do I need to respond to that, Your Honor?
Points the defense counsel raised that remain unresolved in the court's mind?
Any objection to the proposed instruction regarding the jury must rely on their own observations, if any, of defendant's demeanor, but cannot consider counsel's statements regarding her demeanor?
No objection.
Okay. And then
Bloodworth's like, it's just going to highlight it. We're going full Streisand effect.
Regarding giving any kind of illicit street drug is sufficient to show the murder count. Mm-hmm. Talk to me about that. I did catch that comment. They're not making that one up. Now, there was more, and in the total course of the state's initial opening, I think you made it clear that you were encouraging the jury to make specific findings beyond a reasonable doubt regarding each required element. Mm-hmm. There was that initial comment, though. I don't think an instruction regarding having trouble crafting a curative instruction that doesn't just
because it doesn't need a curative instruction.
Of the case. What's your view of this?
Your Honor, I don't think anything needs to be cured. The state does not have to prove that the defendant intended to murder Eric Richins with fentanyl.
True.
The state only needs to prove that the defendant intended to murder him
with an overdose of
the illicit street drugs that she purchased from Carmen Lauber.
And that they contained fentanyl. Yeah.
Well, on the second element or the aggravator? Because there's a distinction there.
I think on both. She has to actually knowingly or intentionally cause the death for count one. So if she buys something that she thinks is OxyContin.
Correct.
I mean, even if she gives him a boatload of OxyContin thinking it'll kill him, and it happens to be a boatload of fentanyl that kills him, the same though.
And intends the giving of the OxyContin to kill him. And it turns out that what she got was blue M30s that had fentanyl, and it killed him. The difference between aggravated murder and murder is irrelevant. She has committed an aggravated murder.
Right.
What the distinction I think that I acknowledge is that she doesn't have to intend to kill him with fentanyl. Correct. She has to intend to kill him with poison.
Yes.
Even if she thought she was getting one and got the other.
Correct.
As long as it worked.
But that's what they
she
argued.
committed the crime.
Isn't that what they argued?
And I think that's what I said throughout.
I think
that is the weight of the argument overall that you made.
If there's a particular sentence I said that is different than that, then I agree we would.
Isn't that what he argued?
But I don't think I said anything different than that.
On this one, Ms. Nestor, I think the better course, rather than for the court to insert itself at this point, is to allow
the defense to argue
the rest of closing to play out, and we can readdress this issue at the end.
Okay.
I expect that this issue will get teased out in detail through Ms. Lewis's
I'm sure the defense will talk about it
and the state's
a lot.
Give me a moment to collect my thoughts regarding the others. All right, thank you. Court will be in recess until... Oh, I'm sorry, go ahead.
I'm sorry, Your Honor, can I just maybe say one thing?
Yes, please.
The state did not refer to the defendant as a narcissist. The state said that was a narcissistic injury.
Right, I got it.
Right. Okay.
I'll be back. 11:40, please. We'll be in recess.
Okay. The court's taking a recess. We are behind real time with Zoom Room. But while the court takes a recess, I hate to do this to you, Chad. I need 3 minutes. I need to run to the restroom. We've been streaming for almost 4 hours. It was a very late night for EDB, but it is my goal to zoom through this recess, zoom through the lunch break, and grab snacks now so I don't have to get up again. Hopefully that worked. Does that work for you? All of you are like, I need snacks. Okay, here's the thing. The defense just made a motion for mistrial. At one point, the court said, well, they're not making that one up. The defense has now kind of sidestepped the motion for mistrial. It was not a wholehearted motion. It felt like as much as the defense was saying we need to preserve this for the record, they were preserving it for the record. They were upset that they felt the prosecution dehumanized Kouri Richins by referring to her as a black widow, which is a poisonous spider technically venomous, but Emily, potato. But they were upset with that. They were upset that she was called a narcissist, even though the prosecution said it was a narcissistic injury. They were upset that the prosecution pointed out the defendant's face, demeanor, and said it commented on the defendant's right to remain silent. I do not think that it did. Neither does the court based on their comments. And the defense is asking for a curative instruction, which I think is just going to highlight, pay attention to the defendant's face. And if they have been paying attention to the defendant's face during these closings, her face has been quite expressive during these closings. I think highlighting it is maybe not what the defense wants to do, but they want to highlight it. They want the court to give that curative instruction and say that the jury is to rely on their own observations of the defendant, which just highlights that they think it's damaging the way she responded. I think you would have let it go. But no, nobody's making like Elsa on the defense team. There's no let it go. There's no let it go. I appreciate that the real CH super chatted. If it bites and you die, it's venomous. If you bite and you die, it's poisonous. Right. She said a poisonous spider. My kids are very particular on this thing about the difference between poisonous and venomous. I also appreciate the who's doing the biting is where we're at. And again, I think maybe they said poisonous because Kouri poisoning Eric is so much at the forefront of this case and the Google searches. I'm going to take just a moment to run to the restroom. Chat, grab your snacks. We'll see what the judge says. We'll zoom as far as we can zoom to get into the defense closing, because I do not think this judge is going to grant a mistrial on that. It was not even a full-throated argument. It was just like, Your Honor, they said things about her face. Tell them not to. Okay, counsel, the issue is preserved. I will see you back in just a few moments. Make sure you have the Law Nerd app. I will also ping you when we are coming back, and you will also hear, well, you'll hear the chimes. All right. I will be right back. I will see you in a moment, chat. All right, chat. Y'all ready? We're still in code red. I had to refresh the button. It was bugging me. You know what that's like. Some days things just bug you and you can't deal with the thing that's bugging you. Right now, it's the defense. I keep trying to remind myself that they are just doing their job. It is the way that they are doing it that I find off-putting. But we are zooming past the break to see what the judge rules on the defense's latest request for a mistrial and a curative instruction. The prosecution's argument was, what do you need me to respond to? I didn't say that. All right, let's zoom past the break and resume with the court. Well, I imagine he'll be giving his ruling and deciding what the curative instruction will be or won't be. The prosecution said they had no objection to the curative instruction. So I guess we will see. I thought I was right on the precipice of the judge coming back on the bench. Did I zoom not far enough? Maybe I zoomed too far. Did we zoom too far? Maybe. I think I did. I overzoomed. How did I overzoom?
Motion for mistrial.
All right. It jumped. I thought we were right there. All right, let's see what the court has to say. We'll fix it and post it. It's fine. Welcome back, everybody. Oh, this trial has been bumpy. It's had its bumpy bits.
Back on the record in
for
231-500-139. Counsel for state and the defendant are present. The defendant
jury is still
present
out?
as well. Counsel, this is what I propose. Let me give you a ruling regarding defendant's motion for mistrial. Then I'd propose I give the jury the curative instruction related to evidence of defendant's
So jury
demeanor.
is still out. The judge is
Then
going
I'd
to rule.
propose we take a lunch break, Ms. Lewis, so we're not interrupting your closing.
I agree with that.
Okay. Any objection, Mr. Bloodworth?
No objection, Your Honor.
Then it's silly to give the curative instruction.
The issue before the court is a motion for mistrial and request for curative instruction in the alternative made by defendant on the record this morning. The motion for mistrial is based upon several comments made by
Oh yeah, the judge just
Mr. Blood.
the judge 100% spoiled his ruling. The judge 100% spoiled his ruling. That's exactly what happened. He was just like, yeah. Then we're going to give the jury a break and we're going to continue. Yeah, 100%.
Worth in the state's initial opening that in defendant's view are so improper as to require a mistrial. The court will address defendant's arguments one at a time. First, the defendant argues that Mr. Bloodworth's reference to Chelsea Barney using the phrase Black Widow during a recorded telephone conversation that was played for the jury, though Chelsea Barney's comment was not admitted for its truth, improperly compares defendant to some kind of terrible insect. The court listened to the comment in real time.
Your Honor, okay. I'm not gonna make a joke about a terrible insect. We're gonna leave it go. We all read Charlotte's Web as children, Your Honor. Spiders get a bad rap. We'll leave the arachnids alone. Let's continue.
Improperly compares defendant to some kind of terrible insect. The court listened to the comment in real time during the state's opening. That is not a fair characterization. Rather, that was a rhetorical flourish by Mr. Bloodworth comparing comments by one witness or the defendant herself to her becoming a widow to Chelsea Barney, referring to her being referred to or considered as a black widow. It's not a reference to an insect. Rather, it's a reference to, in the court's view of Chelsea Barney's comment, a spouse that kills another spouse.
Correct. Also, Chat would like to make the record perfectly clear that Chat knows that a black widow is an arachnid and not an insect, and would like the record corrected. Chat, you are very wise, and I appreciate all of you. We're going to have a poisonous, venomous conversation again with arachnid versus insect, but fair. And yes, the reference to Black Widow was not to a Marvel character. It was to a woman killing her spouse or other men. Yes, that's exactly what it was to. And I appreciate the rhetorical flourish. Yes.
There's nothing so improper or improper at all about that comparison, which has a factual foundation in Chelsea Barney's statements that were played for the jury as to support a request for mistrial or require any other relief. Moreover, the defendant requests a mistrial based upon, in defendant's view, Mr. Bloodworth characterizing Ms. Richins as a narcissist. Defendant argues that that is unsupported and improper expert testimony from counsel that has no basis in the evidence. The actual phrase used by Mr. Bloodworth was narcissistic injury in relation to Ms. Richins' hearing from Brooke Carrington when she testified that in the state's view, defendants' appearances of wealth and success were not accurate.
Yes, and
that is permissible line of advocacy during closing argument. It is not testifying in any way by Mr. Bloodworth. It is not otherwise prejudicial or unfairly prejudicial. With respect to Mr. Bloodworth's argument related to defendant's demeanor, the court determines that in an abundance of caution, it is appropriate to instruct the jury that they...
Your Honor, at some point, it's okay to not, with the abundance of caution. It's too much caution at some point, Your Honor. It's been so cautious, but you cannot stop the defense from punching themselves. And so if they want to bring more highlight to it, all you're going to do is call the jury in, highlight Kouri's face, and then send them out to lunch. They're going to clock it.
That in an abundance of caution, it is appropriate to instruct the jury that they may consider their observations of defendant's demeanor in the courtroom, if any, but they may not consider counsel's statements regarding counsel's observations of defendant's demeanor, as counsel's statements and counsel's observations are not evidence.
I think it's a bad.
Moreover, the court notes that Mr. Bloodworth did not comment on Ms. Richins' silence or in otherwise implicate her protected right to choose not to testify. Mr. Bloodworth's statements regarding what the state believes it has proven regarding defendant's state of mind at various points in time is permissible advocacy based upon evidence in the record, and defendant's counsel will have ample opportunity to try to persuade the jury to draw different inferences from that same evidence regarding defendant's state of mind. There's no basis for a mistrial there. And regarding any misstatement by Mr. Bloodworth in his initial comments regarding count one that may have created confusion as to whether the state needed to show that regardless of her intent to purchase, secure, or otherwise administer fentanyl, all the state needs to show is that Kouri Richins intended to purchase, secure, and administer poison, and that it happened to contain fentanyl. That's was, on the one hand, borne out in detail through the rest of the state's initial closing, and the court expects will be borne out in detail through defendant's closing and the state's rebuttal. The court determines that no curative instruction is necessary on that point at this time. Mr. Bloodworth, any clarification?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay.
The judge made a very thorough record.
Are we ready?
The judge made a very thorough ruling. I appreciate how much of a ruling he made. He addressed everything the defense threw up at him at the end of the prosecution's close before we get to the rebuttal. But he does make a pretty thorough record for appeal. He has been incredibly cautious with those things. And so what, we're going to bring the jury in and then give them that and then send them to lunch?
Okay. Can we bring the jury in, please?
All right, I guess so. I think that is a strategic error on the part of the defense.
My screen is still active, and I don't want anything to accidentally pop up during defense's closing. Thank you.
There you go.
But they're, okay. Sure, I'm gonna put the lights back to normal, see if we get to a code red at another point. We're gonna uncode red the code red. We're gonna tell the jury one thing and then send them to lunch. If you're sitting on the jury, doesn't that just highlight for you? Don't you just go, ooh, the defense doesn't want us to pay attention to that? Maybe it's just the way I read how jurors behave, but I think it's just human when they're like, here's an instruction. I think they all just go, ooh, what happened? Ooh, who's mad? All right, we're changing the lights back to normal, lest we go to code red again. This jury has been in and out, up and down. I think he just told them a quick turnaround. They're just going to be annoyed. And then they're going to sit with that over lunch. That's even worse.
Okay.
It's even worse.
Thank you for your patience. A quick instruction and then a scheduling note. First, a quick instruction. You may consider your observations of defendant's demeanor during trial, but you may not consider counsel's statements regarding counsel's observations of defendant's demeanor, because counsel's statements are not evidence. We're going to break now for lunch so that we do not interrupt defendant's counsel's closing argument for the lunch break. We will take a recess until 12:45. During the break, as always, please do not discuss the case. Please do not allow anyone to discuss it with you. Please do not do any research whatsoever about the case. We'll be in recess until 12:45. Thank you.
And now all they're going to do is watch her face. I'm going to see if they put anything on the record or if they just go to lunch, and then we're going to zoom. I think it just highlights that they thought it was bad, honestly.
No, Your Honor.
Ms. Lewis. We'll be in recess until 12:45. Thank you.
Ramos is like, I'm out. Ramos was grabbing his bag. I do think the defense team is under the weather. We've, I think, heard it with Miss Nestor's voice over the last few days that the defense table seems to be under the weather. The jury's going to come back in. I think it's fair for us to take an afternoon flight to Utah as the jury comes back in. My question is whether or not we will finish closing arguments today. Do you think? Let's see. I'll let this play as the jury starts to come in. Do you think we will finish closing
Ms. Lewis,
today?
would you tap that microphone for me?
Well, between Friday and today, we've now finished everything off with the judge saying tap that. And so I think we have a full bingo on things that everybody wanted the judge to say to perfectly snip him into a secret audible type of a narrative.
Ms. Lewis, would you tap that microphone for me?
Emily, you rewound it. Of course I did. Come on now.
I don't know. I'm sorry. There you go. Great. That should be fine. Brittany will let you know if it's not. We're ready for the jury, Cody. Katie, is there a slide deck that we're playing? Okay.
And when I say, do you think we will finish closing today, I mean, do we think we will finish all of the defense closing
at the moment, right?
and the prosecution's rebuttal? Yes, the prosecution does get to do a rebuttal.
Ready to go?
We're going to fly.
Oh, okay. But it's not up yet. Okay.
We're going to fly to Utah while the jury's coming in. We've had one objection so far by the defense. I guess I'll put up a poll in a few and see how many objections we get during the defense's closing.
Please have a seat as you come in.
Let's fly to Utah and pick up those afternoon miles. And we're going to be getting into the defense closing argument as soon as the jury is seated.
All right, please have a seat. Thank you for your patience. We'll continue with closing argument. Ms. Lewis.
Yeah, I think everyone is under the weather at defense table. It happens during trial. I'm curious to see how this goes. I guess Miss Lewis is giving the closing. Honestly, I didn't believe it because Nestor kept saying Lewis is doing the closing, and then she kept saying, I can argue, I can argue, I can argue. I'm surprised. A good number of you thought that they would stick with their representation. You had a lot of faith in that. All right, defense closing. Let's see what happens. Is that how we start? We start our closing with Nestor's sick too? No, Lewis is sick too. I heard that. Oh, that wasn't Lewis. That was somebody else.
In the early, excuse me.
No, that was
in
her.
the early morning hours of March 4th, 2022, the house was quiet. Kouri Richins fell asleep in her young son's room, like many parents do. At some point in the night, she gets up and walks back down the hallway to her bedroom. She slips back into bed beside her husband. She settles in next to him. She reaches over, and he feels cold. Eric Richins, the father of her children, the man that she has built a life with. Something feels wrong. She pulls the blanket up around him, but something still isn't right. He feels heavy. She turns on the light. And when she looks at her husband, really looks at him, she realizes something is terribly wrong. And in that instant, in that bedroom, in the quiet early of the morning, Kouri Richins' world collapsed. Reasonable doubt. It's not just a slogan, it's not just a suggestion, it's a constitutional shield that protects the innocent and prevents the state from punishing without truth. And it is the state that has that high burden, the highest burden under the law, to prove each and every single element of each and every charged offense beyond a reasonable doubt. The state stood up on day one and they told you they were going to prove that Kouri Richins had the means, the motive, and the opportunity to kill Eric Richins.
And I think they have shown means, motive,
And we're
and
going to talk about
opportunity.
each of these, but first, I want to talk a little more about reasonable doubt. I've told juries for a long time that one way to understand reasonable doubt is, are there other reasonable explanations as to what happened? As you look at the evidence, if there are other reasonable explanations, this is reasonable doubt. And you have to find...
I really hope that they give her enough cough drops to get through this closing, because she does not sound great either, or a hot tea or something. But it sounds like Miss Lewis is also under the weather. And it sucks when your voice is just not going to voice with you. I get it. But I'm not surprised that the defense is going to lean into multiple reasonable explanations. That's what I've talked about throughout the defense. The way the defense has done things, that the defense is going to argue if there are two reasonable explanations and go through and say if there are two reasonable explanations. She's celebrating the closing on the house, not her husband's death. That, I think, is where we're going to see the defense focus. Hopefully they use some of a PowerPoint presentation to stay on track, because I think we're going to see them go through point by point and focus on that, which is, I think, their best option for closing.
Kouri not guilty. I put to you that every fact that the state has put forth to say that Ms. Richins is guilty has another reasonable explanation. Let's go back to March 3rd, 2022. From everything we've heard during this trial, Kouri and Eric were happy that night. They were celebrating. Kouri was just about to close on the Midway Mansion. Rightly or wrongly, she believed that this was going to be the deal that put her over the top. The deal that had made everything she'd done with her business, the good, the bad, and the ugly, all worth it. The night of March 3rd, they have a celebratory drink, they go to bed, and then Kouri hears one of her sons cry out. And like parents all over the world do, she goes in to lie down on the floor of her son's room.
Her lying on the
An
floor is not
alibi?
evidence, but...
Or the truth.
Okay.
She
Could it
wasn't
also be
inconsistent
both?
when she told this story. She told everyone, I was lying in Ash's room, I was lying down with him. What does reason tell you? What does experience tell you? When she wakes up, she goes back to her room. Eric appears to be asleep. We don't know for sure what happens over the next 15 minutes or so. The state asks you to leap to conclusions about what she was doing during that time. Yet they have not shown you any evidence of this. They just tell you to believe it. But what does reason tell you? She gets up. She goes to the bathroom. She picks up her phone. We all pick up our phone all the time. Been away from it for an hour or two. She goes to the bathroom. Maybe she walks to the kitchen. Maybe she gets a drink of water. Maybe she lets out the dog. And then
who let the dogs
out? She goes back to her bedroom, phone probably in hand, gets into the bed next to her husband, again, realizes he's cold, pulls up the blanket, realizes something's wrong, and turns on the light. It probably takes a moment or two for her brain to register what she's seen.
But 15 minutes?
And then she makes that call that nobody ever wants to make. She calls 911.
I agree with that.
A big part of this state's case is that Ms. Richins is not grieving properly. You heard this from a couple of different witnesses, 2 or 3. What does that mean? I was unexpectedly widowed when I was not much older than Kouri, and I had 2 little boys.
Ma'am, that is some tenuous ground and cross, Miss Lewis. That is a really fine needle to thread. That is a really fine needle to thread.
Is not grieving properly.
I backed
you
up.
heard
That's
this from
not,
a couple of different witnesses, 2 or 3.
That's not.
What does that mean?
You're going to get real close to vouching.
When I was not much older than Kouri, and I had 2 little boys. How do you judge someone in that moment? If I've learned one thing during this trial, I've learned I didn't grieve right. I didn't know that, but it's clear now that I didn't. They want you to look at a woman in the worst moment of her life and to judge her grief. There is no wrong way to grieve.
Oh, ma'am.
They're asking you to judge how she is acting at that moment and then use that moment of evidence of guilt. In the opening, we pointed out...
Yeah, she shouldn't...
Go ahead and put it on the...
She shouldn't be bringing up her own life experiences. The prosecution's not going to argue. I wonder if there's members of the jury who wonder if that's even true, though. And that's the danger. If you don't have the jury with you, there might be jurors there wondering, is that even true? And, that's tenuous and kind of perilous grounds to bring in the personal life. Yeah, and if the state did it, they would have objected because it's not proper play to sympathy and vouching.
That the state looks at facts one way and sees a witch. But if you look at those facts another way, you see a widow. Here's an example. Hands over her face, curled up. A witch, hiding because she's done something wrong, or a widow, hiding and blocking out what has just happened to her, what has just happened to her children, what has just happened to her family and to her life.
Perilous grounds, ma'am.
Look familiar?
The witch widow is tough.
Portrayals of women grieving in art.
Oh boy, that's not gonna land right. We're really bringing the weeping angels into this because my brain goes to one particular place when we're talking about weeping angels. And you know what? You don't want to look away. Don't fucking blink, Lewis. Oh dear.
Look familiar?
Don't blink.
Portrayals of women grieving in art. Portrayals of women in grief. The state tells you during evidence that, she didn't immediately talk to Gene Richins when he came to the house because she felt so guilty she couldn't talk to him.
You got one Doctor Who fan on that jury.
Was it because she didn't want to tell a father his son had died? She didn't tell the boys when she should have. It was weird. She didn't go talk to them. They were in the playroom. Again, because she felt guilty or because she was dreading the most difficult conversation, the conversation no mother ever wants to have with her young sons. Their father is dead.
I think that point's fair.
The father that everyone agrees was a wonderful father is gone, and she has to tell those little boys, you're never going to see him again. Believe me, that conversation may be the worst moment in a mother's life. How can a woman be judged on how she handles that moment? You heard her friend Allie staking.
If she hadn't deleted all of her text messages, I think the jury might judge her a little differently, but they're being asked to judge her, so...
How can a woman be judged on how she handles that moment? You heard her friend Allie staking. When Allie arrived at the home that day, she said Kouri was clearly upset. She said she was distraught. This is someone who's known her since junior high, not an officer who met her 5 minutes ago. She said Kouri was acting as you would expect. That night, friends came over to talk about Eric, to drink to Eric.
The defense is putting up a screenshot of the witness testifying from court cameras and then snippets of what looks like testimony in transcript form. It is not, in my opinion, as artfully done, but it still gets the same impression using the witness testimony and the image of the witness.
Wake is what the Irish call it.
Okay, we're getting to an Irish wake.
That night, friends came over to talk about Eric, to drink to Eric. A wake is what the Irish call it. The state wants you to leap to the conclusion that that night, Kouri was celebrating Eric's death. You heard Allie stalking. They were celebrating Eric's life.
I thought it was staking. Is it stalking?
They kept it light for the boys. They were dancing, they were smiling. All of them were, even Eric's sister. Can we not smile in our grief? They want to tell you no. But reason and experience tells you differently. Let's talk about the investigation. The investigation in this matter was nothing but sloppy. It was driven by bias. Did you notice during the state's closing they didn't really even talk about the investigation? Instead, they speculated. What was in people's heads? What were they thinking? Speculation, conjecture, not proof.
Kouri's words.
Instead of looking at the evidence to determine what happened, the state they determined what happened, and then they found the evidence to support it. This is confirmation bias. Confirmation bias is when you favor evidence that supports a belief and ignore evidence that contradicts it. That is how this entire case was investigated.
Ma'am, same initials.
Working backwards from a conclusion.
Wrong case.
It started on March 4th. Detective Woody, before she's even entered.
The first officers who went into that house were just like, I think he died. That's wild. And Woody seemed to have the sister-in-laws came up to Woody and were like, we think Kouri did it. It seemed to me like Woody's reaction to that was, okay, sure, Jan. We'll take that into account. Woody didn't seem to give it a ton of credence that the sisters thought that at all. But okay.
The home. Amy Richins tells her they think Kouri is somehow involved. Then both Katie and Amy Richins tell Detective Woody they think this is because she recently found out about a trust Eric created. Immediately, this influenced this investigation. But what happened that first day? They found nothing to support foul play. Kouri tells them he was a user of THC gummies, that maybe he used one that night. They never ask where the gummies are. They do a cursory search of the bedroom and bathroom. They admit that they don't look in places where the gummies were found a month later, high up in the bathroom.
They did
high
look there.
above the refrigerator.
We saw
high up in the laundry room.
We saw the
in
body
a
cam.
pocket of either Kouri or Eric's jacket in a closet. All places where they would have been put out of reach of children. Okay. But they didn't find any of them that day. You know what else they didn't do? They didn't secure the scene. They moved things around. They told you they didn't have probable cause to search the whole house. We couldn't search the whole house. All we could do was look in the bedroom and the bathroom. But they could have asked for consent.
They did for the
Kouri
kitchen.
gave them consent when they asked to search one place outside of the bedroom. The entire house could have been searched that day, but they didn't do it. They didn't even ask. What else happens that morning? Officer Nguyen, he does his little his, well, not little, but his death checklist. He says,
his little, you guys, his little death checklist. Ma'am.
did he have any history of prescription abuse? Did he have any history of illicit drug use? And what does Kouri tell him? No. How easy would it have been to just say yes? If she had just killed him with illicit drugs, why in the name of God did she just not say yes? Had she said yes, we probably wouldn't all be sitting here today. She didn't say yes because she did not know how he had died. Over the last 4 years, they've gone back to that house 10 more times. And they still can't tell you what happened the early morning of March 4th, 2022. 10 warrants, that's a lot. That's not typical.
That's fact.
They were still searching for evidence on February 9th of this year, 2 weeks before trial.
Do we know it's for this case or the other case?
4 years of investigation. And they are still trying to find evidence to make their case because they know they don't have enough. They're still trying to prove Kouri Richins guilty.
Okay.
So let's talk about Todd Gabler. In comes Todd Gabler, the private investigator. Jeff O'Driscoll told you, well, he was an investigator for the estate. Just the civil case.
Gabler was pretty great, though.
Seriously? He's putting trackers on the car of Kouri, her mother, her brother. He's trying to track Carmen Lauber's car.
I didn't hear anything about
He's providing evidence
mom
to
and
the
brother.
police. Detective Woody testified that this information from the private investigator is what helped advance their investigation. He testified he was in the house alone numerous times, finding things the police didn't, not using gloves, calling law enforcement when he found things. He said he didn't need a babysitter while he did all these things, which is different than what Clint Benson told you. He said nobody was ever in that house without me being there.
He said
That wasn't
without him
true.
knowing.
What he told you wasn't true. Todd Gabler was in and out of that house numerous times by himself. He also told you that he was completely fair and unbiased, testing 2 hypotheses. His hypotheses, suicide and homicide. He ignored any others.
Didn't Gabler
including
say accidental?
And how did he handle this unbiased testing of hypotheses?
I thought Gabler said accidental. Chat, let me know what you remember. But I think he said they were trying to narrow it down, homicide, suicide, accident, whether Eric took it himself or didn't. And then I think he said he ruled out suicide and thought whether it was accidental OD or homicide was where he got, that he narrowed it down to those 2.
You heard Josh Grossman. He said the first time he talked to Todd Gabler said right out of the gate, Kouri killed Eric. Josh told you that tainted what he thought of next. How does it not taint an interview when your opening line is, oh, Kouri killed Eric, so now let's tell me what you have, what you know. Josh told you he started looking back at things differently than he had before because of that. Like I said, he tracked Kouri's car, he tracked her family's car, he tracked Carmen Lauber car. He didn't track Cody Wright's car. He had more to gain from Eric's death than anyone. He didn't track anyone involved
Ma'am,
in the
that's
civil case regarding the trust.
Choice.
He only tracked people that he thought might lead to information for law enforcement. Did he follow up on Eric's trip to Mexico shortly before the death? No. Did he go to Mexico? Did he try and figure out where Eric had been in Sonora, Mexico? No. Nothing about that investigation was unbiased. Nothing. He passed it all on to law enforcement. And then what he did is he said to law enforcement, you should talk to Carmen Lauber. She's on the ropes in drug court. This would be a really good time to interview her because she would be very likely to be compliant at this time. Everything about this investigation was led by the Richins family. They started on day 1. on.
Oh, boy.
And they continued until trial. They are the ones who initially hired and paid for experts. Their private investigator gave information to the police. You know, and by the way, Gabler testified that he followed all the rules of being a private investigator.
We got a BT Dubs already?
And that may very well be true. But he doesn't have to operate under the Constitution. There's a reason that we have rights under the Constitution. There is a reason that law enforcement has to get warrants to enter your home, to take electronic.
I thought they didn't need to get warrants, ma'am. I thought they could just ask. I thought they could just, you said earlier that they could just ask.
Reason that we have rights under the Constitution. There is a reason that law enforcement has to get warrants to enter your home, to take electronics, to search your house. It is to protect the citizens of our country. It is to protect the innocent.
I thought you said consent was fine.
These important.
I thought you said consent was fine. The victim's family gave him consent. I thought you said consent was okay. Also not a state actor, but I thought consent was fine. They own the house. They gave consent. Where am I not following? I'm not following.
Search your house. It is to protect the citizens of our country. It is to protect the innocent. Sidestepping these important constitutional rights by hiring a private investigator who then let law enforcement know what to do taints this entire investigation. And you know what? That is terrifying. It's terrifying. If someone has enough money to hire a PI, they can circumvent our constitutional rights, dig into every aspect of our rights, of our lives, and turn it over to police. We have a constitution for a reason. It's to protect us all. I want to talk about the lead investigator, Jeff O'Driscoll. Here's what he testified that his investigation consisted
Your turn, O'Driscoll. Smoke.
He got assigned to the case sometime in March of 2023. He got a search warrant for some medical records. He thinks he got a search warrant for a couple of cell phones.
He was not great.
He interviewed Chelsea Barney, where they discovered that they were wrong about some text messages. Law enforcement was wrong with what they thought they were looking for. He interviewed someone named Jake Sorensen, who must not have had anything important to say because we never heard from him. Then he interviews Carmen Lauber because he was told to by the private investigator. That's it. That was the investigation.
Why is Jake catching straight?
He didn't investigate any other leads. He didn't attempt to corroborate information, particularly in the letter that we saw that Kouri wrote to her mother, the walk the dog letter. Now, he told you he didn't need to corroborate that because he didn't get that letter till after Kouri was arrested. So, you know, I guess the state was done. You wouldn't want to start looking for things that might show her innocent. You've arrested her. Interestingly, they were still executing search warrants. They were still trying to find evidence for guilt, but they weren't looking at any evidence that might show innocence.
Pounding the table and arguing the Constitution kind of go
It is absolutely possible that everything she said in that letter was true. In fact, at least 3 things in that letter.
This is a good argument. I just wish you would stop yelling at me because this is a good argument. Yell about the PI, yell about O'Driscoll, yell about O'Driscoll doing whatever that was on the stand. But when you get to the walk the dog and wanting to argue that there's 2 reasonable interpretations of the walk the dog, stop yelling at the jury. Stop yelling at them. If you want them on your side, you can't yell at them. They're just going to shut down if you yell at them about the walk the dog letter. It doesn't feel reasonable if you are screaming at them.
Were corroborated by the state's own witnesses. But they didn't investigate it. Again, ignore what might contradict your theory. Confirmation bias. Reasonable doubt. Also remember that letter never went to anyone. So it was nothing more than thoughts on paper. That's all that letter was. What else didn't he do? He didn't interview the person Eric was talking to in Mexico the night of his death, and we'll come back to that, but he didn't follow up on that. He said that. He didn't follow up on where Eric went in Mexico or who he was communicating with in Mexico when he was there. He didn't investigate what Eric did or where he went on February 14th, 2022. He didn't follow up to see if did Eric go to the hospital that day. In fact, he did nothing regarding that day. Nothing. What else? He didn't find fentanyl anywhere.
That doesn't go towards accident, though, ma'am.
Allegedly, there were 90 to 120 pills of something. At least oxycodone. Where were they? I guess somebody took them. But they didn't have them. So whatever pills Carmen may or may not have provided to Kouri were gone. They no longer existed.
The sewer system.
They couldn't find or test those pills. And we do know that she bought oxycodone. But you know what? There was no oxycodone in Eric's stomach that night.
Right.
So instead, Detective O'Driscoll says, well, we wanted to corroborate Carmen's story. I mean, we were going to corroborate it. We weren't just going to go by it. The story that they fed her, they want to corroborate the truth. They wanted to corroborate a story. Again, let's find what confirms our theory.
I mean, the phone's
Let's
the phone.
ignore what doesn't. Confirmation bias.
If he accidentally took them,
doubt.
would you have time to flush the rest of them?
Sitting here in this courtroom after 4 years of investigation, there was an awful lot that O'Driscoll just could not tell you. Things he couldn't remember. He couldn't remember what people had told him in interviews. For example, he was asked, did you interview Eric's allergy doctor? Well, yes, but I can't remember what he said. Well, that might have been important because he testified the EpiPens in the house belonged to the children. Well, maybe because Eric had recently used his a couple of weeks earlier when he had an allergic reaction. He said, well, if I could have a few minutes, I could find out what was said. I could give you more information. We were in trial. He was on the stand 4 years after Eric had died. 3 years after he'd been appointed as lead investigator. And either he wasn't prepared to testify or he just didn't know.
I mean, it's fair. O'Driscoll was not great.
He is the lead in.
However, I will say the symmetry of this shot, we've gotten to pound the table. But first of all, O'Driscoll's testimony was not great. Second of all, the symmetry of this shot from whoever is operating the camera, producer snaps for this. You got O'Driscoll with the former attorney Sky Lazaro over his shoulder, and then you can see Eric Richins' sister and brother-in-law right behind Sky. Look, man, if courts had an awards for cinematography, the production on this one has been fantastic. Great camera work, 10 out of 10. Emily, you have to continue letting Lewis finish. I don't like being yelled at. I don't like being yelled at.
After he'd been appointed as lead investigator, and either he wasn't prepared to testify or he just didn't know. He is the lead investigator. Now the state elicited testimony from him that how could he possibly know the entire case is just too much. I couldn't know all of that information.
You bet they want to point out O'Driscoll's face if he started facing.
He's the one they relied on to testify about this investigation. You didn't hear from anyone else about the last 3 years of that investigation.
I mean, you did. You heard from Woody. You heard from a lot of people.
You know what else he couldn't testify to? He couldn't testify how the fentanyl got into Eric's system. He said, well, he ingested it.
He did say orally. He was not great on the stand, but he did say orally.
There was no evidence, none, that fentanyl was put in a drink. That was argument. Argument is not evidence. And they waited until closing to tell you, oh, she put it in a drink, without any evidence.
I think it's pretty clear the whole case.
Okay, she made him a drink that night, but that's it. She made him a drink. There's no evidence that fentanyl was in that drink.
I mean, her friend did say, don't eat what Kouri gives you. So there's that.
And the lead detective who couldn't tell you anything, he sat through this entire trial. He heard every witness testify. He had an opportunity to form his answers or reform his answers based on what he knew other people had said. And yet he still didn't know the evidence.
The yelling is hard for me too.
I want to talk a
Kat.
minute about deleted texts.
You've got to earn...
And the phone searches, just quickly.
You've got to earn your outrage. I think outrage of a lead investigator who's standing up there and being like, I don't know. I think that's fair outrage. But if you're outraged about everything, it just starts to wah.
Deleted texts. They said there were deleted texts off Kouri's phone, and that it looks like that probably was true. Why would you delete texts off your phone? Maybe because you were having an affair over the last 2 years? You might want to delete that off your phone.
Then why
before your whole husband's family finds out about it?
Such a small window of time that they were deleted.
Maybe because she was buying oxycodone. I mean, she asked Carmen for pain pills. Doesn't mean she killed her husband.
So you agree with that now?
But you probably want that off of your phone. The phone searches. So the evidence showed that Kouri found out on April 13th that Eric died of a fentanyl overdose. And that's the day they took her phone and she gets a new phone. These searches are all done on that new phone. Searches of how much fentanyl does it take to kill someone, or how much fentanyl is a lethal overdose, I don't remember exactly. Yeah, because she just found out her husband died of a lethal overdose of fentanyl. You might want to know what that means. And she texted other things. They said, oh, she texted about women's prisons. Of course she's worried. An innocent person would be worried. Anyone would be worried if they just found out that they are a suspect in a homicide investigation.
I thought she was concerned about Jen Shaw, counsel.
She would have been scared to death. She was looking for information based on what she found out after Eric died.
It's a kind of wild acquiescence.
All right, what do we know
closing.
about those last few hours before Eric's death? It's not a lot, but we do know some things from the autopsy and the toxicology reports.
Wild acquiescence.
We know that he had fentanyl in both his blood and his stomach. We know he had quetiapine and alcohol only in his stomach and not his blood. So this means the quetiapine had to be taken after the fentanyl. Had they been taken together, they would have both been in his blood.
That's not what they said.
We know there was no histamine response, no anaphylaxis. So he had not had an allergic reaction to anything in his body that night, including fentanyl. The state wants you to believe that the allergic reaction he had on February 14th was to fentanyl. If he had an allergic reaction on February 14th, he would have had one again 3 weeks later. Now, I know the toxicologist testified, well, you don't have an allergic reaction every time, and you can look at her testimony, but it was a little bit hard to understand, but I believe she was talking about, you might eat peanuts for a lot of times and then have an allergic reaction, and then it starts. Once you have an allergic reaction to something, it doesn't typically go away. We know he had norfentanyl in his body, and this is because his body had started to metabolize the fentanyl. The state's toxicologist told you that the fentanyl could have been left over from a previous use. That was a possibility. Another reasonable possibility. The fentanyl was there from a previous use. That was the evidence. That is reasonable doubt. What else do we know from the ME and the toxicologist? Well, we know that the fentanyl was not put in a drink.
How I remember
and
that
how do we
testimony.
Know this? There was only fentanyl in the blood and not alcohol. The state's toxicologist leaned toward the fact that maybe Eric didn't even drink alcohol, that the alcohol in his stomach was post-mortem decomposition.
Yeah, she said it was possible.
But the other scenario that she said that was possible was that Eric took the fentanyl, then took the quetiapine, had a small amount of alcohol.
Also possible.
She testified that it would take 15 to 60 minutes for fentanyl to make its way into the blood. That alcohol takes 15 to 30 minutes to make its way into the blood. So if the alcohol and fentanyl were taken together, they both would have been there at the same time in the blood. But just the fact that one reasonable possibility is that the fentanyl was taken before the quetiapine and the alcohol gives you reasonable doubt that it was placed in a drink an hour earlier. Now the state's saying, well, maybe she put it in a non-alcoholic drink. So their celebratory drink maybe didn't have alcohol in it. There's no evidence of that, but they're throwing around a lot of theories. Why is that? Because they don't have one. They don't know what happened.
They have a theory. I think you can say the reason they're telling you if is because they don't know. They have a theory. You just disagree with it.
Dr. Christensen and Dr. Ulmer testified that the manner of death could not be determined. This is really important. Dr. Christensen testified the ME's office didn't know enough about Eric's history to determine if it was an accident. They also didn't have enough information to determine it was a homicide. The ME had at least a reasonable doubt as to the cause of death. And the ME isn't held to the high standard that the state is.
It's a good
and
argument.
there was no evidence that the
They do have
autopsy
doubt.
couldn't have been amended at a later date if additional information was received.
But it's not
The
a
ME
criminal.
testified, excuse me, the ME didn't tell you that they couldn't amend the autopsy. He just told you they didn't. What else didn't they do?
Okay.
Why didn't they do a hair follicle test? Dr. Christensen said, well, we don't do that unless we're asked to. Who would you be asked to do that by? Law enforcement. Again, Summit County was only looking for evidence to confirm their theory. Evidence to support that Kouri was behind Eric's death. They did not want to look for evidence that contradicted that theory. Had they done that test, we might have our answer.
I mean, his liver contradicted that
Confirmation
theory,
bias.
Okay.
All right. Let's start with the means. The state did not and cannot prove that Kouri ever purchased.
Let's start with the memes. Words I didn't think I'd hear in closing argument, but here we are. Yes, ma'am, let's start with the memes.
Confirmation bias. All right. Let's start with the means. The state did not and cannot prove that Kouri ever purchased fentanyl. Carmen Lauber.
What's that have to do
Interestingly,
with the memes?
they barely mentioned Carmen Lauber.
Oh, she said means. I'm sorry. I was too excited to get to the memes. She meant means. Right. Motive, opportunity, means, not memes. I was hoping we were going to get to memes. I was.
In their closing.
I was.
The only witness who can put fentanyl into Kouri's hand. Let's talk about her testimony.
Oh boy.
Admittedly, a
Buckle
lot of it was
up.
painful to watch. And in some ways, she's sympathetic. But she is looking at multiple long prison sentences.
That's not what came
and
out.
her only way out, her only way was to testify at this trial. But what she could not do was put fentanyl in Kouri Richins' hands. She told you that she had no memory of what actually took place in 2022. During those interviews, she told detectives over and over again, my brain is fried. I've been using drugs since 6th grade. My memory is gone. So what she testified to you wasn't what she remembered. She admitted on the stand that what she testified to was what she had been shown, what she had been told.
Not how I
Detective
remember
O'Driscoll
that.
told you that Carmen Lauber could not remember the purchase of drugs after Eric had died. When asked by Ms. Nestor if at least one of the times that Carmen allegedly purchased drugs from Mr. Crozier and brought them to Kouri was after Eric's death, his response was, her testimony was not that. She didn't remember it that way. We found digital evidence that supported that. But you know what? She did testify to that. She testified at length and in detail about something that even Detective O'Driscoll said she didn't remember. Carmen Lauber was not able to tell you that she bought fentanyl. She agreed on the stand that it was the detectives that first put the word fentanyl in her mouth, in her head. She was told by detectives in this case that she bought fentanyl. Eric died of fentanyl. You bought drugs. You bought fentanyl. She took that story and she ran with it because she had everything to lose. And Detectives O'Driscoll and Detective Maynard told her, you are getting a big, giant get-out-of-jail-free card. And what do you have to do to get that?
Sorry, chat. I don't know how my screen my monitor froze, but back to Lewis. Sound was good. Screen was frozen. It just froze. Just, all right. Back to Lewis pounding the podium.
Big giant get out of jail free card? Give them the details.
If you're listening in the background, there is a picture of someone holding up a Monopoly get out of jail free card. Ma'am, I don't know if you want to keep making the Monopoly analogies because someone was playing Monopoly and losing. I don't know if the Monopoly analogy is what you want, but somebody's holding a Monopoly card. It sure is.
Free card?
She really was waiting for that card to pop up on the screen,
Give
too.
them the details that will ensure Kouri gets convicted of murder. You heard that from O'Driscoll's own mouth.
Ma'am.
He tried to...
Ma'am, the prosecution put up, like, exhibits and exhibit numbers, and you've put up the Weeping Angels and Monopoly.
Explain it away. But he went in and he told this woman, get out of jail free card, give us the details to ensure Kouri gets convicted of murder. She had to tell them that. She had to tell you that. She had to say she purchased fentanyl.
Oh, boy.
The detectives walked into those interviews not to find out what happened, but to get Ms. Lauber to confirm what they already had decided happened. Again, confirmation bias. She told them at that first interview, I literally never dealt with fentanyl. And she had reason not to deal with fentanyl. She told you that. She had a daughter who had overdosed from fentanyl. She was afraid of fentanyl.
She did say that.
She told them that Kouri asked for something for an investor's bad back. Maybe it was for Eric. But she told them that Kouri asked for an investor's bad back. And that later she asked for something stronger. She asked for the Michael Jackson drug. She told them Kouri never asked for fentanyl.
Did you really want to bring up that Kouri said she asked for something stronger? Because the prosecution didn't even bring that up. The prosecution didn't bring up that Kouri had asked for something stronger. They're probably waiting for it for later, but they didn't even bring that up. I think you wanted to skip over that.
That Kouri asked for an investor's bad back. And that later she asked for something stronger. She asked for the Michael Jackson drug. She told them Kouri never asked for fentanyl. She admitted that she got the word fentanyl from Detectives O'Driscoll and Maynard. She told them she couldn't remember. She asked them to lay it out for her, to put the pieces of the puzzle together, to write it down and I'll sign it. They argued that was because, well, she didn't want to write it in her cell. That's why they wanted us to write it. Well, she could have written it right there at the table, I suppose. But you know what else?
You typed it up for Crozier.
She also told the Assistant United States Attorney basically the same thing. Put it together for me. And the U.S. Attorney or the Assistant U.S. Attorney said, oh, we don't do it that way. You have to tell us what you remember. They literally offered a big, giant get out of jail free card.
A second time with the photo of the get out of jail free card.
They brought up the TV show, The House of Cards, but who held all of the cards in this case? Jeff O'Driscoll told you. Carmen Lauber held all of the cards. Their entire house of cards is being held up by her. And now at trial 3 years later, she comes in here and says she bought oxycodone once and fentanyl 3 times.
Tell me if that lands for you.
She told it very nicely on direct. But when pressed, she couldn't remember anything. Not from 2022, not from 2023. She couldn't remember on Friday what she testified to on Thursday. And you know, I didn't ask her about her mental health or her learning disability to be mean. I asked her because it explains why she was so easily convinced by law enforcement as to what she needed to do and what she needed to say. She described her learning disability as low education. Well, you can decide what that means for yourself, but one possibility is she has an intellectual disability.
Ma'am!
And if that is the case, she is more vulnerable to suggestibility than most people.
Danger! 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 Danger, counsel! Danger! Nope! Nope! Oh, counsel, you're gonna try to explain it, and ma'am, you're just making it worse. Nope. You were doing better before. And you would have been better to stick to grade attainment, which it seems that she was talking about. Nope, hate it so much. You were back up to the House of Cards analogy. You were doing better with the House of Cards. Yikes.
I asked her because it explains why she was so easily convinced by law enforcement as to what she needed to do and what she needed to say. She described her learning disability as low education. Well, you can decide what that means for yourself, but one possibility is she has an intellectual disability. And if that is the case, she is more vulnerable to suggestibility than most people. Easy to manipulate. And they took advantage of this. We all saw it.
That's gross.
They did too, but they had to find someone who would confirm their theory. But you know what? Through all of this, there were a handful.
If she had gone with low grade attainment, it would have been better. She said she started doing drugs in 6th grade. It's reasonable that at some point she might have dropped out of school. But the direction you've gone is a bad choice. Also, you're ignoring all the phones. So there's that.
Things that Carmen Lauber was consistent about. There were a few. Kouri asked for some pain medication. Kouri said that in the Walk the Dog letter. Then she told you, I brought oxycodone from Susan Kohler on February 11th. Prescription oxycodone. Now that's important because if Kouri had any pain pills before February 14th, these were likely what she had. She said Kouri never asked for fentanyl. She said that in all of her interviews. Carmen never asked Robert Crozier for fentanyl. She said that. She was consistent with that. That she bought pills from Robert Crozier.
And
that the pills
Crozier
she got from
say?
him were light green. 15 to 20 milligram oxycodone pills. When she bought from him again, she asked for more of the same.
And he said,
those are the things she said throughout.
And she said, fine. Oh, you stopped
Everything
there.
she said, every other thing she said has changed multiple times. It changed again while she was on the stand. Now she says the number of purchases were more. That changed. The date changed. For the first time, she says that Crozier was the first one to say the word fentanyl. It's the first time we've heard that. Wasn't in the interviews.
Crozier talked about fentanyl in the interviews.
She's not a truth.
And law enforcement said to Crozier, Carmen said that she got fentanyl from you. He said, yeah, she knew what she was getting. I would have done what I said. It was in the recorded interviews.
Person. There were a couple of little things she laid on the stand about. Not super important, but I'm going to point them out because they were just untruths. When I asked her if she was on any medication for her anxiety or any other illnesses, she said no. But then later, when Mr. Bloodworth asked her, she said yes, she was on medications. They were in her car in her purse. She told you Nancy Peterson drove to buy the drugs because she didn't have a driver's license. When we showed her that photo was reversed and that she was driving, did you notice how smoothly that story changed? Oh, well, yeah, I drove one way, she drove the other. By the way, where's Nancy Peterson? There was someone who might have been able to confirm Carmen's story, but we didn't hear from her. What else did Carmen lie about? She sat on that stand and she told you, I never violated drug court after I got out, my get out of jail free card in May of 2023. But then when confronted, she had to admit, oh yeah, I did. That's right. She told you, well, I was holding a can of alcohol, but I didn't drink
At
it.
the concert, right.
When confronted, though, she had to admit that wasn't true. She sat on the stand and she told you that. Oh, I just held it. Oh, but you told your probation officer you drank it. Oh, yeah, I guess I drank it. But what's the most important thing she admitted to lying to? She lied to a judge. She lied to a judge by writing a letter
That's why they
saying
wanted to bring Carmen back in.
that she had been 100% compliant with drug court. And why did she lie to that judge? She wanted to go to Vegas. And she told you on the stand, she admitted it. Yeah, I was untruthful with the judge.
And some jurors might discount her for that. They might.
She was untruthful because she wanted to go to Vegas.
But the
There is a
phones,
lot more at stake here than going to Vegas. She is, again, being untruthful to get what she wants. And what she wants this time is to stay out of prison. And she will say whatever she needs to make that happen. You know what else she got by telling that story in addition to her get out of jail free card? She also got an advance straight to go and pass drug court on the way card. No more showing up at drug court.
Wait, did we really just go to do not pass go, do not collect $200? Are we really trying to still go with the Monopoly analogies? Really?
Straight to go and pass drug court on the way card. No more showing up at drug court.
I think she was trying to. It didn't land, but I think she was trying to.
She told you drug court's tough, but she didn't have to go anymore. No regular check-ins. She just had to text hi or Lauber to Detective Maynard. And most importantly, no more drug tests. She's still on probation. Still waiting to go to court to see if her charges will be dismissed. And she's not being drug tested. Is she telling you the truth about being clean? We have absolutely no way to know. She got everything she wanted by testifying to things that she admitted she had no memory of. Can you feel for Carmen Lauber? You can. Can you believe her beyond a reasonable doubt? You cannot.
But you...
And if you can't believe her beyond a reasonable doubt, you have to find Kouri Richins not guilty.
I don't think that follows. I think you can not believe Carmen and still believe the cell phones.
I don't want to talk about
That's
Robert
just me.
Crozier, because he's also an addict, and he also changed his story. But what makes him different?
You typed up his statement. That's what makes him different. You were the one who was typing up his statement for him.
First, his original story was given in a 13-minute interview while he was coming down from drugs. Not in 10 hours of interviews over multiple days. Detectives came in, and they told him he sold fentanyl. They said, we already know. We know you sold fentanyl. You just need to confirm it. We won't jam you up. Just tell us you sold fentanyl. And he agreed with them. And they asked, did Carmen Lauber know she got fentanyl? And he said, absolutely. But what did he explain to you on the stand? Now that he's been through rehab, now that we know he's sober, he gave people what they asked for when he was selling drugs. He always gave them what they asked for. So when detectives came in and said, well, you sold Carmen fentanyl, Carmen asked for fentanyl, he said yes. He said, what I meant is, if that's what she asked for, that's what I gave her.
It's not how
What
I
else
remember
makes
that
him different
video,
though from
but
Carmen Lauber?
okay.
He changed his story from what the prosecution wanted him to say to what they didn't want him to say. Not the other way around.
Ah.
Why do this? Why would he risk his immunity? It would have been so much easier for him just to stick with his original story. But let's go back. So he gives that original story in April of 23. He sobers up. He meets with the state. He meets with Mr. Bloodworth in April of 25, before he ever spoke to me or to Mr. Berman. And he tells them at that time that he got it wrong.
Okay.
He says, no, I sold Carmen oxycodone, not fentanyl. And how does he know this? He told you. Because he didn't start selling fentanyl until late 2022. And he sold to Carmen Lauber in early 2022. Also, his source gave him fentanyl that was so dark it was almost purple. It wasn't light green. It wasn't light blue. Okay, so then he meets with our team in October of 25. He says the same thing. He signed an affidavit swearing it to be true. He testified to the same thing at trial. I was only selling Oxy in 2022. And not only that, he told you it was prescription Oxy from a pharmacy. So not fake Oxy that was actually fentanyl, but real Oxy.
He didn't know
that. He was
that.
a bit of an expert on the topic. I think he knew more than the drug expert did. He told you, light green pills, those were 15 to 20 milligram pills. Light blue pills, those were 30 milligram pills. His prescription was 10 milligram pills. He knew his stuff. He was a pretty successful drug dealer. And he told you when I sold fentanyl, those pills were almost purple. What did he have to gain by testifying to
Say
this?
the oxy and fentanyl looked exactly
He's never
the
met
same.
Kouri Richins. He'd never met Eric Richins. He didn't know Carmen. He isn't getting anything from anyone.
I mean, except
It's for
immunity.
these reasons that his testimony is more credible than Carmen's. Her freedom is at stake, so she had to say fentanyl.
So is
She
his.
has to give them Kouri. He has nothing to gain. He just told you the truth. The state told you in closing that they traced the fentanyl. It's absolutely not true. Carmen never even looked at those pills. She didn't test those pills.
They said what
She didn't
now?
take any of them, according to her. And we don't know where any of them are. Where are these some odd 90 to 120 pills?
Where did they say that?
They didn't trace that fentanyl. We have no idea where that is. They didn't
What?
trace any fentanyl. So how did Eric end up ingesting fentanyl? What other reasonable explanation might there be? You know, I'm not going to stand here and say to you that Eric Richins was a drug addict. He wasn't a Carmen Lauber. He wasn't a Robert Crozier. I don't think the evidence shows that.
Ma'am? Okay.
But that doesn't mean he didn't use. That doesn't mean he didn't ask Kouri to get him pain pills. He probably did. So what do we know? We know Eric was in pain. He had Lyme disease, which can be very painful. He had back pain. He had knee pain. We know he'd been in Mexico not long before his death. Look at what he was doing right
Then
before
why
his
did he
death.
need Carmen to get him pills? I mean, why did he
right
need Carmen to
before
get him
his
pills? This is the
He's
state's
texting.
exhibit she's showing
Pedro Sonora, back and forth, back
with
and
his
forth.
phone activity.
Did they interview him? Like we said, no. He texts his friend Scott Wagner. More, Pedro Sonora, from 8:30, between 8:30 and 8:36, he texts him 1, 2, 3, well, these are back and forth. But between them, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 texts. He gets a call from Scott Wagner. What's his last Google search? How far is it from Scottsdale to Nogales?
I mean, at least it wasn't how's long. But
And then he
it's
gets
close.
a text from Raul. We also don't know anything about Raul. Maybe he made other calls. The state said maybe Kouri was calling on the Wi-Fi. Maybe so was he. We don't know who else he talked to, but this is what we do know.
Well, ma'am, we had his phone though, so I mean, they could see if his phone made other calls because they had his phone. It wasn't wiped. So
This is a good place to bring up, I think, that the state did stand up here and they told you that we said things in opening that didn't come in during trial, and that's true. Strategies change during trial. But remember, we are not the ones under an obligation to put on any evidence. It's not us.
I mean, that's a fair
We're
way to
not
address it,
under an
I guess.
obligation to prove anything. It's them.
But
Okay, so what else do we find on that?
does that land for you? Yeah, that's true. Sure. But it's not our strategies change and it's not our burden. It's not their burden. Okay. Fair, but the evidence should have been based on what you thought the state was bringing in, but okay.
Put on any evidence. It's not us. We're not under an obligation to prove anything. It's them. Okay, so what else do we find on that first day that Eric died? What else do they find? The hydrocodone bottle. Whatever happened to that bottle? Why wasn't it tested? What was kept in that bottle? The bottle's sitting right by the bed on Eric's nightstand, right next to his phone and watch that were placed neatly in his
Not
charger.
where it was
An
recovered from.
expired prescription bottle with nothing in it but residue. And you can see the residue there. Why would that be sitting out?
This is the zoom in of the bottle that they talked about during opening. I don't know if they'll get the expiration date right this time or not, but
Out a 6-year-old prescription bottle.
I mean, it wasn't 6 years old then.
What might be the best way to bring illegal pills back from Mexico? Put them in a prescription bottle? Put them in your suitcase? What might be the best way to store your illicit oxycodone? Stick them in a prescription bottle? Put them by your bed?
It wasn't.
And now that bottle's gone, and nobody knows where it is, and nobody tested it. And you saw that white powder, and you can look back when you go back, but you saw that white powdery residue on the nightstand next to Eric. Nobody tested that either. So what's another explanation? What could have happened? Eric was about to take his last pain pill out of that bottle that he kept by the side of his bed. He's on the phone with people in Mexico. He's checking how long it takes to drive from Scottsdale to Nogales. Maybe he knew he was getting fentanyl in Mexico. Maybe he thought it was something else, and he accidentally got fentanyl. Maybe had they tested that bottle, we would know. But they didn't.
Then why is the walk the dog letter the walk the dog letter?
You know what else we know, though? We know he had a prescription for naltrexone. And it appears he wasn't taking it. A drug used to help people control craving for drugs and alcohol. It's not a drug used to treat Lyme disease.
But that's what the doctors said when they
There's
testified.
a reasonable alternative. Reasonable doubt. All right, I'm going to move to motive. The state absolutely did not prove that Kouri's relationship with Josh Grossmann was a motive to kill her husband. Josh and Kouri had been seeing each other on and off for about 2 years. You heard from Josh. He testified that their future together was a fantasy. That at no time did Kouri ever lead him to believe that she was going to leave Eric for him. It was clear that Josh loved Kouri more than she loved him. You could see it in his face. You could see it in his demeanor. You can look at the text shortly before Eric died where Kouri was trying to break up with him.
She was?
The state wants you to find
I
that
don't
the
remember that.
conversation Kouri had with Josh about his time in Iraq is somehow evidence or proof of murder. But Josh told you she was grieving, that conversation was about life and death and Eric and bow hunting and the supernatural. That it really didn't even seem that unusual at the time. He only thought it seemed unusual when the private investigator told him Kouri killed Eric. It's not evidence of a homicide. It isn't proof of anything. Yes, they were having an affair. Eric was also having an affair, possibly more than one.
What?
You heard there was a text about an open relationship, and they can laugh about that, but that's what the text said.
No, do not fall into the I have other uses for your throat trap. Ma'am, you are going to lose the jury trying to make unserious texts serious. You have points that you can make. This is not the point. You continue to read that incorrectly, counsel.
Eric was also having an affair, possibly more than one.
There's no evidence of that.
About an open relationship, and they can laugh about that, but that's what the text said.
Ma'am.
And you know what? We do not bring this up to make Eric out to be a bad person.
You don't?
It doesn't matter what he was doing in his personal life. That's not the point.
Then why do you keep bringing it up?
The point is that there were parts of Eric's life that he didn't share with people. Just like he didn't share with Cody that he used marijuana, or even that he took prescriptions. The point is we all have secrets, and Eric had secrets.
Mm-hmm.
But back to Josh. The best evidence that Josh was not a motive for Kouri to kill her husband is that after Eric died, she never did get together with Josh. She didn't show up at the brunch that they'd planned to celebrate the closing on the Midway Mansion. She didn't go on a vacation with him in April. She never even finished paying for that vacation. Josh told you that Kouri changed after Eric's death. That she was grieving. That he saw less and less of her, and ultimately she broke things off. And by the way, if Kouri was as motivated by money as they would have you think, would she really have killed her wealthy husband to run off with the handyman who lived for free in one of her houses?
I mean,
That doesn't fit with the state's theory.
Fair question.
The state says, look at Tex.
She might have thought she was going to have millions and millions of dollars from the Midway mansion because Delulu, but okay.
Replace the words in them with different words. They stood here and made up what was inside people's heads, what they were thinking.
Ma'am, you tried to make the fetch happen with the open marriage text and then said that the state's making stuff up?
The state has to rely on evidence. They have to prove their case, and they can't do that. The state did not prove that Kouri killed Eric in order to be with Josh. All right, money. Money's a motive for a lot of things for a lot of people. Was Kouri a brilliant businesswoman? No. Was her business struggling? Yes, it was.
Struggling's an understatement.
Was there fake it till you make it? There seemed to be a lot of that going on.
Oh.
Brooke Carrington testified that money was...
We've gone Elizabeth Holmes then. Right, okay.
Not a priority to Kouri Richins.
Girl boss.
She could have used an accountant, she said. She didn't even use QuickBooks. And this is all true. A young mother trying to run a business, like most young mothers, young working mothers, did her accounting take a backseat to her family? Probably. The state also wants you to believe that Kouri was cheating her best friend, but that's not what the evidence showed.
Oh, boy.
The evidence showed that the $45,000 that Chelsea gave to Kouri was not earmarked for closing. Kouri could do whatever she wanted with that money. All that mattered was that when she went to that closing on that house, that she showed up with $45,000. It didn't have to be that $45,000. It could have been $45,000 she expected to come in from...
Jurors, you don't understand. It's a shell game. You don't understand how the shell games work. Ma'am, don't argue she's not a murderer because Ponzi scheme. You should have left this point alone. This one was better left alone.
When she went to that closing on that house, that she showed up with $45,000. It didn't have to be that $45,000. It could have been $45,000 she expected to come in from another flip. But then Kouri was arrested and never got the opportunity to do that. That's why that house foreclosed.
No.
But you know what the evidence has shown?
No.
That Kouri, rightly or wrongly, truly believed that that Midway mansion was going to turn everything around. They were celebrating that night. If Kouri was going to kill Eric for money, she certainly would not have done it on the night that she believed she had just secured a multi-million-dollar property. And if you look at the state's exhibit 624D, you will see that Kouri actually made a profit on every single home that she flipped. She had reason to believe that she was going to make a profit on this one too. All the foreclosures, those were all after her arrest. And something else, they say it would have cost way more money than she had to rehab the mansion to live in it with Josh, which again, Josh said was fantasy. That wasn't going to happen. But if you don't believe him, look at text. Look at State's Exhibit 2-17D on page 33. This is where she and Eric are going back and forth on how much it would cost to rehab the mansion. And he says, we can't afford that. We don't even have time for that. What does she tell him? And you can look at it. I don't have it word for word. She tells them, no, we're not doing that. I just need money. I just need to give the numbers, to the investors. She didn't intend to rehab that. She intended to flip it.
You
After
have
a little cleanup.
to rehab it to flip it.
All right, I want to talk about the gifts that the state talked about in their opening.
Finally, we're back around. Everybody was like, Emily, you were so salty. They were talking about the memes and not the memes. I was. And now back to the memes. The misstatements are hard for me, though, because it's just not how I remember the evidence. And again, I think the defense loses the good points with the points that just don't follow. And so not narrowing it down is tough.
And throughout trial.
So now we're back to the gifts, the memes.
They made such a fuss about these. They were accessed on Kouri's phone on March 4th, the morning of March 4th.
Such a fuss.
They were tied to the celebration. That's what those were about. If you look at that exhibit, I think it's 3-40, you can see that the orphan gifts were accessed at the same time, down to the second, as a picture of the Midway Mansion. So what do we know about these gifts? We know that some photos were stored in a cache on the phone, not connected to any particular text. We know that they were accessed the morning of the 4th. We know that at least one of the pictures, the one of the mansion, was sent by Eric the evening before, which likely means all of these photos were sent prior to the morning of the 4th. These were not about Eric's death. She wasn't celebrating death. These gifts were sent earlier, and she was celebrating closing on that mansion. It just doesn't follow she would kill him for money. She received less from life insurance than she thought she was going to make on that mansion. Josh Grossmann told you that she was surprised when she found out about the $1 million life insurance policy from auto insurance. It appears she didn't even know that.
So did she know or not?
Carrington's testimony is true. And by the way, she was a good witness. She is a professional, expert witness. First hired by the family, and then paid $200,000 by the state. A prosecution witness, sitting right here today behind the prosecution.
Is she? I didn't even notice.
Very different than the MEs, who are just here to tell you their findings. But anyway, if you accept her testimony, the life insurance wasn't going to fix the problem anyway. Kouri spent that life insurance within a matter of weeks and was still in debt. And you know what you heard on that phone call between Bryce and Chelsea and Kouri? All I want's the home.
There she is.
All I want. They can have everything else. They can have the money. I don't care. I just want my house where I've raised my boys. And you know what? Eric was making good money.
I won't bring up how much
in 2020
Lewis and Nestor
he told
have been paid
Christina Miller,
by the government
attorney he went to about talking about a divorce, that he was making, his income that year was over $33,000 a month. Cody Wright testified that they made $500,000 each the last year that Eric was alive. I believe there was testimony that there were other years he made even more. Not sure about that, but I think that was in there. So if this case was about money.
If you're listening in the background, the in-court producer, I believe today it is still Grace from Court TV, but the setups on these shots have been telling. I'm not mad about it. They moved the camera ever so slightly so you can see the IO, the investigator, and the former lawyer. Whose face is also facing. I had to just back up.
The attorney he went to about talking about a divorce, that he was making, his income that year was over $33,000 a month. Cody Wright testified that they made $500,000 each the last year that Eric was alive. I believe there was testimony that there were other years he made even more. Not sure about that, but I think that was in there. So if this case was about money, Eric was worth so much more to Kouri alive than dead. Opportunity. Well, I guess her opportunity was she was the only one in the house. Who else was in the house, though? Who else had an opportunity to take those pills?
Eric?
Eric.
Yep, that's exactly where we're going with that.
4 years later, 10,000 searches, over $300,000 worth of expert witnesses.
There were 10,000 searches?
3 weeks of trial. The FBI, the DEA, Homeland Security, the Summit County Sheriff's Office. They cannot tell you how Eric ingested that fentanyl. They haven't done their job, and now they want you to make inferences based on paper-thin evidence. They speculated on a number of things during closing, and they want to tell you, they want you to do their job for them. Tell them no. Tell them if they're going to charge a person in your community with the most serious crime there is, they better have the facts. They better have the proof. They better have more than speculation and conjecture, because that's their job. It's not your job.
It's their job to determine the facts.
I want to talk about the elements.
They have to determine. It's
The first one, aggravated murder.
I think we're getting to murdery. It's their job to determine what the facts are. That's the job of the jury.
Okay, so they have to prove that that Kouri Richins.
Okay, again, I'm going to compliment an attorney. Anytime an attorney brings up the elements of the crime, the defendant's connection to the crime, I think it's helpful. I was surprised by how brief the aggravated murder elements are in Utah. They are brief, but this is what they are. I'm interested to hear how the defense goes through the elements. I appreciate that they're doing it because they need to find which element they are going to kind of pull at the most, because the jury has to find each element.
Intentionally or knowingly caused the death of Eric Richins. The state has not proven this. They haven't even proven that she obtained fentanyl.
I mean, tell me how.
They've not proven where the pills ended up or how Eric took them. The state stood up here and argued, well, it really doesn't matter what drug she purchased. As long as it was an illicit street drug, it absolutely matters. Because what did he die of? He died of fentanyl. There was no oxycodone in his system. There was no other drug in his system.
Right. Right.
They must prove that she purchased and gave him fentanyl. Oh, and let me talk about Becky Lloyd for 1 minute.
Wait, no, don't come back.
She said that she had a conversation.
Wait, ma'am.
After a drink or two, where Kouri allegedly said, things would be easier. I'd be better off if Eric was dead.
The elements.
But what else did you hear? You heard Becky in a recording tell the officers and investigators, I don't think I can testify to that on the stand. I'm not sure that that's true. But then she testified to it.
Not what she said in that call.
No, maybe they threatened to bring a catch pole for her dog too.
Oh boy.
One thing I want to point out here, though.
The thing is, when you scream at the jury in your closing, it doesn't land the same way. And that was an interview with the investigator, not with law enforcement. When you keep misstating things, it just makes me want to correct you, because that's not how the evidence came in.
Testified to that on the stand. I'm not sure that that's true. But then she testified to it. Well, maybe they threatened to bring a catch pole for her dog too.
Snarky.
One thing I want to point out here, though, is if after looking at all the evidence, you believe that Ms. Richins accidentally obtained fentanyl when she thought she was getting oxycodone, and then Eric took those pills voluntarily and died, that is not intentionally and knowingly. That is not aggravated murder. And if you conclude that, you must find Kouri Richins not guilty. All right, attempted murder.
You should have started there.
What is the evidence of this?
Why are you skipping over that point so quickly? Instead of yelling about Carmen Lauber, why haven't we just leaned into the walk the dog letter's true? She asked Carmen to buy the pills for Eric for his pain. She didn't know what she was getting. Eric took it. Why not? She's just like,
and died. That is not intentionally.
I'm surprised she didn't lean into this point more. I'm just going to back it up. I'm really surprised they didn't lean into this point more.
One thing I want to point out here, though, is if after looking at all the evidence, you believe that Ms. Richins accidentally obtained fentanyl when she thought she was getting oxycodone, and then Eric took those pills voluntarily and died, that is not intentionally and knowingly. That is not aggravated murder. And if you conclude that, you must find Kouri Richins not guilty. All right, attempted murder. What is the evidence of this?
Do you think she should have leaned into that more?
And again, it has to be intentionally or knowingly, and it has the rest of the elements there. She had to take a substantial step. So here's the evidence. Kouri bought an omelet and an egg sandwich at 9 o'clock the morning of February 14th. There was no evidence that she left that sandwich in the truck. To the contrary, there was a conversation with her mother saying, they think I left some sandwich in a truck. That didn't happen. Eric said he wasn't feeling well.
That's not what she said.
He took a nap between 11:30 and 2.
She was mad about that she didn't make the sandwich and she didn't leave a note, but okay.
He called a couple of friends and sounded upset. He joked a few days later with Kouri and friends that his wife had tried to poison him, that he'd had an allergic reaction and used an EpiPen. Alex Staking told you that, Ollie Staking. She never said that Kouri got defensive. She didn't say that. She said they were all laughing. She said that Eric didn't seem upset or scared. It was a joke. Wouldn't be the first time a spouse ate something and said, "Oh my God, my wife tried to poison me." But that's it. That's their entire case.
Yeah, but then he died though.
She said they were all laughing. She said that Eric didn't seem upset or scared. It was a joke. Wouldn't be the first time a spouse ate something and said, "Oh my God, my wife tried to poison me." But that's it. That's their entire case. He didn't go to the hospital. He didn't do anything that day but take a nap. Eating an egg sandwich, having an allergic reaction to something, and taking a nap. There is no world in which that is attempted murder beyond a reasonable doubt. Oh, they point out that months later in text to Chelsea, her friend, that she gets some details wrong about that day.
Oh no. She lied.
Maybe because she didn't try.
Wait, where is the getting the details? Where's the line between getting the details wrong and lying? Because Carmen Lauber was lying. Kouri's not lying. You making the same argument on different sides of the argument within the same closing is rough for me. No. She just got a few details wrong. Kouri's not lying.
Oh, they point out that months later in text to Chelsea, her friend, that she gets some details wrong about that day. Maybe because she didn't try to kill him, and in her memory that day really wasn't all that important. She said, "I bought him lunch." Well, it was breakfast. Again, they stood here and said, Eric was thinking this, Kouri was thinking this.
I mean, she said she was there.
You
And
know,
she
off
wasn't.
with Josh, thinking all these things.
She was off with Josh.
None of this was evidence, not any of it.
She was
None
off
of it is
with
proof.
She was off with Josh.
They talked about some IRS calls that she made on those days. No evidence as to what was in those calls. No witnesses from the IRS. Speculation.
Fair.
Conjecture. Not proof. Reasonable doubt. Okay, I'm going to jump quickly.
No.
The other three counts I'm going to go through quickly, but I'm going to go to count 5, which is the forgery count.
Can we not
now,
jump
remember
around?
What we're talking about here. This is one of those life insurance policies that any of us who belong to a credit union get, where you don't have to do anything. You sign here for $100,000 free life insurance.
I don't think you have to sign here for free life insurance is how that works, ma'am. You don't have to do anything. Just sign it.
Union get, where you don't have to do anything. You sign here for $100,000 free life insurance. And this was filled out for both Kouri and Eric. Matthew Throckmorton, the handwriting expert, all he could tell you is that Eric probably did not sign the True Stage insurance policy. Probably is reasonable doubt. And he could not tell you that Kouri did sign it. They have not proven that Kouri forged Eric's signature. And there was no evidence either way if Kouri had permission to sign Eric's name on that True Stage life insurance. I mean, let's be serious. It's the rare married couple who doesn't occasionally say, "Hey, honey, I'm going to sign this for you. Is that okay?"
Ma'am?
But there was no...
He wrote her out of his will, though. This happened.
Evidence either way. She's not guilty of forgery.
Okay.
All right, jumping to the insurance fraud counts, count 3.
If there was permission, then it's not a forgery. Fair.
But there was no evidence either way. She's not guilty of forgery. All right, jumping to the insurance fraud counts, count 3. Count 3
over that
is
faster than I thought she would.
Connected
Honestly.
to count 5. Because this count alleges that Kouri fraudulently obtained that insurance policy, and the fraud was forging Eric's signature. They said there was a reversed Social Security number on there, but the fraud's the signature.
I mean, the phone number, though.
So if the state hasn't proven to you count 5, it automatically follows they haven't proven count 3, and you must find her guilty, not guilty on count 3.
Okay.
Count 4 alleges that Kouri fraudulently collected the true stage insurance policy. All that means is if she did kill her husband and then represented something different to collect that insurance, that would be fraud. But if you find Kouri Richins not guilty on count 1, you have to find her not guilty on count 4. The state has not proven their case.
It's an interesting way to attack that.
They don't have the evidence that Kouri Richins killed her husband. So instead, they have tried to show you as much evidence as they possibly can to convince you that she's the sort of person who would. Getting close to the end. I'm sure you would like me to stop talking, but I have to tell you, I'm afraid to stop talking. Because as I stand here right now, Kouri Richins is still cloaked in a presumption.
Oh boy. Are we trying to just pull in the sympathy from the jury about how hard it is to be you? Notice the tone change, though. It's not that she can't shift gears. It's a choice to shift gears.
I have to tell you, I'm afraid to stop talking.
I bet you are. Cloak of righteousness.
As I stand here right now, Kouri Richins is still cloaked in a presumption of innocence. I don't ever want to walk back to that table. As a defense attorney, that is one of the longest walks a lawyer can make. This entire case is going to flash before my eyes. And all I will be able to think about once I sit down is, what did I miss?
Ma'am, it's not about you.
What didn't we tell you that you wanted to hear? Did I focus on what you wanted to know? Did we do enough? You're about to go through those doors and into the jury room and start deliberations. Everyone in this courtroom, everyone watching around the world, we all wish we could follow you and listen in. But that room, that jury room is yours. It's sacrosanct. In that room, you get to decide. And when you get in that room and you look at the evidence, if you think that Kouri Richins might have killed her husband, that she likely killed her husband, that she probably killed her husband, you must find her not guilty. Because maybe, probably, likely, very likely, none of these reach that extraordinary burden of proof beyond a reasonable doubt. I'm going to ask you to do a couple of things when you go into that room. First, you might be tempted to go around the room and take a vote for guilty or not guilty to see where you all stand. We ask that you refrain from this. Instead, we ask, talk to each other about where you see reasonable doubt. Also, if Kathy or Alex or myself did something to offend you during this trial, please hold that against us.
Oh, look.
And not against.
There's the self-awareness. This is probably the best part of her closing, honestly. Hold it against us, not our client. If we didn't say something that you wanted to hear, if you were waiting for the defense to if you just answer this, don't hold that against our client. Very poot of you, ma'am.
Kouri.
She needed to, because I'm sure there are things that y'all did that offended the jurors.
Talk to each other about where you see reasonable doubt. Also, if Kathy or Alex or myself did something to offend you during this trial, please hold that against us and not against Kouri. Now, the state's going to get up and talk to you again because they get the last word. And the reason they have that last word is because of that heavy burden. But when you filled out that jury questionnaire, we asked you if you would be comfortable making your voice heard in that jury room.
Oh, Jesus.
Would you stand by your convictions, by what you believe? And each and every one of you.
More art. They haven't put up the witch widow yet, though. That's got to be coming. The prosecution put up evidence, and the defense has put up, art?
Jury room. Would you stand by your convictions, by what you believe? And each and every one of you said yes. So here's my final ask of you. When you're deliberating and something comes up that we didn't respond to, will you be courageous? Courageous enough to raise your hand and talk about what our response would be. Raise your hand for Kouri, because you are the last line between an innocent woman and the state. Be courageous. Courage is what this moment demands. The courage to stand between a member of your community and the state, and demand that they comply with the Constitution, that they comply with their burden. Do not let them fool you. Do not fall for red herrings. Kouri Richins did not kill Eric Richins. The state did not prove this case beyond a reasonable doubt, and you have the courage to tell them this and find Kouri Richins not guilty.
Okay. Not a single objection from the prosecution.
Your Honor, 15 minutes now will save me 30 minutes later.
Understood.
Oh, they're taking a break.
Let's just stretch your legs.
15 minutes now will save me 30 minutes later. I guess they're taking a break. Kouri Richins did not kill her husband's getting awfully close. There were things in there that the defense got very close to vouching. The prosecution asked for 15 minutes. We're going to zoom and see if we catch up to their rebuttal. 41% of you thought that we will finish closing today. 33% thought that closing would finish, but no time to deliberate. 25% said no. I'm surprised.
Tell if you wanted to do something on the record or just needed a break.
No, sir, just a break to,
collect your thoughts.
Collect my thoughts.
We'll be in recess until 2:15. Thank you.
I'm surprised that the defense didn't take longer in their closing. I'm surprised we got to the end of the defense closing with a little bit of self-awareness. We got to the briefest amount of hold it against me, not my client. I think the difference in the closing between the evidence that the state put up throughout their closing and what the defense chose to highlight, because of the way the defense chose to highlight it, was kind of stark, especially when we got to the art showing a woman weeping or women mourning that seemed to be like just not even run through like Canva to remove the backgrounds. It was a little tough. But I wish they had gone through the elements more thoroughly versus the kind of scattershot approach. The yelling at the jury, I do not find works well. If there's anything that we didn't say, I think is a good way to start to close in your closing. If there's anything that you really wanted to hear and we didn't say, please don't hold it against our client. This is the only time we get to talk to you. And I hope we've answered your questions. But we know that the state hasn't proved their case. And we ask you to hold them to that burden. But at the end, we got to like fire and brimstone and yelling, which I think a lot of jurors, in my experience, find off-putting when they're being yelled at, unless they feel it's earned. When they feel it's earned, if there's a witness they didn't like, and then an attorney in closing is like, and this, the jury's like, yeah, that. But when you get to all of it is yelling, it loses its impact. If you want to yell about the IO was not great. Yell about the IO. Yell about the IO all you want. The IO was not great. Yell about him. Fine. But to go from yelling about Eric to yelling about his business partner to yelling about Josh and Carmen and then not yelling about Crozier, but then back to yelling about the IO and then yelling about the Richins family, it's a lot. And the defense, I think, got close to the line on improper plays for sympathy when the defense attorney is pulling herself into her own closing, which is an interesting play. I really wanted to see the defense go through the elements of the crime and talk about each of the elements. And when she put them up, I was like, good, we're getting to the elements. And then it was like, let me circle back. And I'm, shit, please don't circle back. Can we talk about the elements a little bit more? It was very broad in the state didn't prove it. And there were good points in there that I think are going to get lost in a lot of things that are just like, you listen to them with the listening to the evidence and you're like, that's not how that came in. And it distracts the jury. If what you're saying to them is not how they remember it, they're sitting there going, wait, that's not how I heard it. I think it was this. I don't think it was that. I don't think this is what it was. And then they've lost the next 3 things that you've said. But they're taking 15 minutes, and then I guess we're getting to the prosecution's rebuttal. So you know what we need to do? Zoom a zoom. Zoom a zoom. We're going to zoom. We're going to zoom a zoom. That's exactly what we're going to do. I'm surprised the defense didn't point out more. I don't want to over zoom. I'm surprised the defense didn't point out more about Valentine's Day. And I'm surprised that the defense didn't talk more about what Kouri was buying, because they made a big deal of it when they made a motion for mistrial. I'm surprised that they acquiesced that Kouri was buying pills from Carmen. That I was very surprised by that. That I was surprised by the acquiescence. Kouri was buying pills. But remember, if she was buying them for Eric and Eric took them, then that's not this. Okay. So let us get to the rebuttal with the jury coming in. The little zoom zoom room. We love some zoom zoom room. The jury's coming in.
Please have a seat as you come in.
All right, the jury got a 15-minute break. We're just rolling with the homies. Rolling with the homies.
Please have a seat.
And then we'll get to Bloodworth's rebuttal. The state gets a rebuttal because they have the burden.
Bloodworth, please proceed.
The rebuttal is meant to address the points that the defense raises in their closing. I can understand why, with the closing that kind of jumped around a little bit, that the state would want 15 minutes to just put it together.
Thank you, Your Honor. Next, guys.
Oh,
Harder
boy.
tricks are not.
For those listening in the background, Emily's already saying, oh boy, yes, they, the witch widow is the first thing that they brought up. I'm surprised that the defense didn't bring it up, but they didn't bring the picture up, but they said it. And that's where we're beginning. I had to back up because there we are.
Next, guys. Harder tricks are not legal standards. Legal standards are what matter. Let's review a couple of the important ones. You'll have them in your instructions when you go back to deliberate. Reasonable doubt. I come back to this one again and again. Evidence usually consists of testimony and exhibits presented at trial. What the lawyers say is not evidence. I've come back to this slide in rebuttal precisely because of defense's closing.
Right.
There is a reason the state provided you in its slides with the cite to every single piece of evidence it argued. We told you what transcript page and line number.
Yes, they did.
We told you what exhibit number. Because what the attorneys say doesn't matter. The evidence is what matters. And there's a reason defense counsel didn't cite you to the evidence. Next slide, Scott.
And again, the defense...
A lot of the evidence is...
The defense could have taken their wind out of the sails. Could have taken the wind out of the sails of this point had they presented their closing differently. But he could read what they were going to do. Of course he could.
Circumstantial. It is. People do not video themselves
and there's the
poisoning
umbrella.
Their spouse. But circumstantial evidence is just as good as direct evidence. You can use circumstantial evidence to conclude facts just as you can use direct evidence. The instruction gives the example of it is wet outside and people are closing up their umbrellas. That makes sense. Let me put it to you a different way.
Pieces of a puzzle, maybe?
Does everybody know what happened here?
Oh, no. Oh, if you're listening in the background, the shit's out of the elephant? I've never seen that used as an example in trial. And oh my, if you're listening in the background, the shit's out of the elephant on this one. Jury instruction number 27. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events. And you just have to see the exhibit. The shit's out of the horse in the rebuttal.
Does everybody know what happened here?
That's funny.
Kouri Richins chose Carmen Lauber. The state didn't. Hold on, let me check something.
That's what it said on the header. The Kouri Richins chose Carmen Lauber.
Kouri Richins chose Carmen Lauber, not the state. Go ahead, Scott. Thanks. Kouri Richins chose Carmen Lauber because she was the drug dealer she knew. The state granted Carmen Lauber immunity because it cares more about a murder case than a drug deal. That should surprise nobody. Kouri Richins chose Carmen Lauber in part because she had control over her. She could help her out. She employed her to some measure. She could help her out. A little quid pro quo. You give me some drugs, I can help you out with your drug court. Kouri Richins chose Carmen Lauber, not me. Her testimony is corroborated.
How very Bloodworth of him.
If you only believe Carmen Lauber's testimony that is corroborated, that is plenty of proof to convict. She was only at that Maverick in Draper 3 times. That's what the digital evidence shows.
3 transactions with Crozier.
Each of the 3 times she was there, so was Robert Crozier. Those were the only 3 times he was there. Their testimony corroborates each other in the relevant matter. It corroborates that they met, that he sold her drugs,
That's
illicit
Crozier's
street
testimony on the
drugs,
screen.
that it had fentanyl. Blues had fentanyl. Corroborates that they weren't prescription drugs. He got them from a plug, not a pharmacy. They were packaged in a little clear baggie, not a prescription bottle. All the testimony of Carmen Lauber and Robert Crozier that matters corroborates each other.
So with these transactions, when Carmen...
Go ahead, we've seen this one again.
I appreciate that he's like, we've seen it. The jury knows. They get it. We don't need to play it again. They understand. And they went past Crozier's interview, which the jury will be able to rewatch if they want to.
Crozier was at the gas station 3 times. Carmen Lauber was there every time. The March drug deal. Timing of this is very interesting. Shortly after Eric's death, Carmen Lauber spoke with Kouri Richins and asked, "Please tell me these pills were not for him." Of course she denied it. No. But then, a few days later, she asked for more pills. It's curious as to why. Perhaps to cover up that the pills were indeed for Eric. If I ask for more, she'll know they weren't for Eric. It's also interesting that she said she needed something to get her mind. What? I don't know.
I have thoughts
Maybe
about
she
that,
wanted the
but
pills for herself. This suggests she wanted the pills
not
for
in evidence.
herself to calm her mind. Which tells you she knows that a pill that she buys from Carmen Lauber is not bad. It's a whole bunch of pills that kill.
And they were showing the
Consciousness of guilt
of the cleaning
is
transaction
evidence
from the
of
9th.
guilt. Kouri had a guilty conscience. She couldn't talk to her father that night, not because she was overcome by grief, because she couldn't face. She could not face the man whose son she had just murdered. We're going to play these clips right here now. This is when Kouri Richins is asked whether she's going to tell her children, whether she's going to talk to her children. Notice Kouri Richins' reaction in the moment. To this will be Katie Richins' reaction in the
We
moment.
talked about this when they originally played it.
Go
I'm
ahead,
not
Scott.
surprised they're
Where are your
juxtaposing it.
children now?
Asleep in that room, 2 are awake with their ear to the door. I God, I would go out. Please somebody
No,
take
no,
them
no.
out. No, what happened? What happened?
We don't know. We went to bed.
Hey, Clint's here. He's gonna help.
Oh no! It skipped! Oh, the tech is teching at me. Why? I don't know. Hold on. We're gonna try to jump back in time to the middle of closing. It was just like, nope, we're done. At least it'll be easy to find where we were on the videos playing. We talked about this when it came into evidence about the difference between Kouri's reaction and Katie's reaction on the body cam. It was a stark difference then. Sorry, chat. We got to cue that back up. That was tech be teching. Tech be teching. All right. I backed up a little bit. I know it's always a cliffhanger. It's so wild. All right. We backed up. And we are going to watch that
Kouri Richins
again.
Is asked whether she's going to tell her children, whether she's going to talk to her children. Notice Kouri Richins' reaction in the moment. To this will be Katie Richins.
And then the screen froze. Today is just, it's like, you know what we're not going to do? We're not going to just let this go smoothly. It's not your internet, chat. It's interneting.
Reaction in the moment. Go ahead, Scott.
Where are your children now?
Asleep in that room, 2 are awake with their ear to the door. I God, I would go out. Please somebody take them out.
This is Katie.
No, what happened? What happened?
We don't know. We went to bed.
Hey, Clint's here. He's gonna help. Where are my boys?
The kids are in there.
This is the sister. Where's my brother?
He's in this room.
No. Do I see my brother? Good. Baby.
Kouri, is there a way you could relocate your boys upstairs?
Yeah.
Because there's going to be a lot of traffic.
Yeah, I'll tell her now.
They pan too.
Kouri Richins walks away.
It's got to be hard for her to re-listen back to her own grief in court.
Katie then takes the boys upstairs. In moments of tragedy and profound sorrow, you not only comfort your children, they comfort you.
They put up screenshots.
Kouri Richins hides her face because she doesn't know how to react because she is not grieving.
They put up a bunch of screenshots.
She doesn't want to see other people see her non-reaction. She's not grieving because she feels no grief. She just murdered Eric. You heard Deputy Wynn testify. She wasn't crying.
He did say that. You can roll your eyes all you want, Kouri, but that's exactly what he testified to. You can roll your eyes at Bloodworth all you want. Go ahead, but that's what Wynn testified to. Ma'am, the jury was just advised that they are allowed to consider their observations of your face. Why would you face at them in that way after they're told that they can consider your face? Weren't you sitting there?
Non-reaction. She's not grieving because she feels no grief. She just murdered Eric. You heard Deputy Wynn testify. She wasn't crying. Deputy Wynn's body camera did catch a moment of surprise. That's the moment he informed her that he, Deputy Wynn, was sending Eric's body for an autopsy. That's her surprise. She didn't tell anybody that night that Eric used fentanyl because she thought she would get away with it. She didn't think anybody would find out that Eric used fentanyl. And the minute Deputy Wynn said, "We're sending his body for an autopsy," that's her reaction. The 2016 empty hydrocodone bottle is immaterial. Eric had no hydrocodone in his toxicology results. The only other hydrocodone reference in the entire body of evidence before you is that investigators recovered on the first search warrant a bag, like a Ziploc type bag, full of hydrocodone pills in the laundry room and the mudroom of the house. Perhaps Kouri Richins removed them from that bottle and staged the crime scene.
Ma'am, you're still facing. He's allowed to make argument about where the other hydrocodone was found. And that's why he didn't make that argument before in closing, because he knew that the empty bottle would come up. But you know what didn't come up once? Weed gummies. You know what the defense didn't talk about once in closing? Weed gummies. No, that's not true. They said they didn't find him in the first search warrant. A week plus of trial. Gummies. And then bottle. Right.
This is also inconsistent with the notion, having those hydrocodone bottles in the house, pills in the house is inconsistent with the notion that Eric had a secret drug habit and was going to the street for illicit pain pills. And there's a baggie of hydrocodone in the house.
Right. If you had it, why would you?
Okay, there is no good reason these images.
Now we're on to the memes. But it's a fair point. Why would you risk buying something off the street if you had prescription pills left in the house? It's too risky.
Pain pills, and there's a baggie of hydrocodone in the house. Okay, there is no good reason these images were accessed the same exact
I was trying to move the closed
minute
captioning.
that
Sorry.
deputies departed the house the morning that Eric died. None. And there is, by the way, despite what defense counsel just told you, there is no evidence that Eric Richins sent these images. He sent an image of the Midway Mansion.
Why the idiots everywhere? Why the idiots everywhere? Unless she's talking about what, her investors?
Okay, there is no good reason these images were accessed the same exact minute that deputies departed the house the morning that Eric died. None. And there is, by the way, despite what defense counsel just told you, there is no evidence that Eric Richins sent these images. He sent an image of the Midway Mansion the night before that was accessed at the same time as these images. Sorry, he sent an image
of the
Midway Mansion the night before, but it was not the image that was accessed at the same time. The image that was accessed at the same time is the distance full view of the Midway Mansion, which makes sense in this context, not the image that Eric sent of the pile of rocks in front of the Midway Mansion. Details matter. We don't know who sent these images,
because Kouri
but we
deleted her
do know
phone.
that they were accessed on Kouri's phone at 8:29, the exact minute that deputies signed the log out of the house, and that whoever accessed them turned the phone this way to view them better. They also viewed the distant image of the Midway Mansion. Maybe she was celebrating the Midway Mansion. Maybe she was celebrating Eric's death. Either way, there is no good reason these images were accessed at 8:29. Kouri Richins minimized how Eric died because she needed to cover up her involvement in Eric's death. The worst minimization was the one to his father. After speaking on March 17th with the medical examiner's office, Kouri Richins told Eric's father, knowing this was not true, that Eric Richins died in part of COVID and in part of the same lung fungus that Jean's wife, Linda, died of.
Eric's mom. I didn't realize how much that would circle back until we heard that recorded call with Bryce, but it sure circles back in that call with Bryce.
That is not only covering up her involvement, that is cruel. She covered up with the medical examiner. She pretended she didn't know what Quetiapine was, even though she was prescribed it. She pretended she didn't know what acetaminophen was, even though it's Tylenol, and there is probably not a mother in the United States that does not know what Tylenol is.
I mean, it's a fair point.
She pretended she didn't understand the word illicit. She has a master's degree.
Oh boy. She wanted that to matter. It matters now.
In feigning ignorance with Dr. Christensen, she was fishing for information to craft her defense. She was asking, was it injected? Did he eat it? She wanted to know what the medical examiners knew so that she could craft around it. She was really worried about the amount of alcohol. On April the 13th, Detective Woody told Kouri Richins that Eric died of fentanyl intoxication. Right after that, she tells Josh, oh, it was just a trace. Chelsea, it was just a trace. It was his lungs that were shot to shit. She is minimizing, deflecting, covering up. She is distancing herself from her murder.
The texts, the texts, the texts.
Manner of death on the death certificate is immaterial. It's a box we check It's used for statistical purposes. They turn the information over to the Bureau of Vital Statistics. It's immaterial for this case. You determine the manner of death. It's murder, aggravated murder. Perhaps in a perfect world, the medical examiner would amend the death certificate, but you heard Dr. Ulmer.
She retired.
She signed it on June the 6th, 2022, when the investigation was really in its infancy. And she had one foot out the door. It was her best solution to finish her report before she retired.
I think that's fair.
It is what it is. Bureaucrats.
I know a judge that would try to sanction you
Eric
for
did
that.
not ingest the THC gummy laced with fentanyl.
Oh, back to the gummies.
When asked if she ate one that night by Deputy Wynn, it didn't seem like he did. Toxicology, there was no measurable THC in the toxicology analysis.
I think they thought
Eric's
defense was
blood
going to bring it
or
up.
Gastric.
I think they thought defense was going to talk about the gummies in their closing. The defense just skipped right over it and went to the empty bottle instead because there's an answer for the THC gummies. But I think that's why it's in their rebuttal.
When asked if she ate one that night by Deputy Wynn, it didn't seem like he did. Toxicology, there was no measurable THC in the toxicology analysis of Eric's blood or gastric. The THC that they collected on the April 13th, 2022 search warrant, right, the first search warrant, it was found in the cabinet above the toilet in the master bathroom. Wasn't there the night before. You heard Deputy David Pimentel talk about how he searched it. You could see his search on the body cam. It wasn't there. It was put there after Eric died. That's where most of the gummies were. There was also a package in the kitchen, which was never searched the night he died. But all the gummies were sent to the lab for testing. In fact, the gummies, lots of stuff was sent to the lab for testing. None of it confirmed any fentanyl. Brian Holden, he was the state crime lab tech that testified.
I don't even remember Holden testifying, honestly.
Detective Haskell works the streets of Salt Lake City, drugs his whole career.
We heard about everything being tested in broad strokes, but that was weeks and weeks ago.
Never seen fentanyl-laced marijuana. That's that's cover-up. That's misdirection.
I remembered that, the THC laced.
Kouri Richins' plan, if it was a plan, to make money on the Midway mansion is not tethered to reality. Across her portfolio, she lost money, and she lost money on nearly every individual project. She even admitted, it's out of my league, but the margins are so insane that I had to pick it up and then figure it out. Ha, 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 help. That's ha, 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 with $3.2 million of other people's money. She's intensely ambitious.
Pockets, if you will.
Her plan was not tethered to reality because she could not, with more money than she could even imagine, overcome the Corps of Engineers holds on this project.
Well, there that is.
Not
Right.
gonna happen.
You can't even flip it adequately because of all of this. Chat was just asking, bring up the Corps of Engineers. There it is. Ask, and it's in an exhibit.
She asked Eric Richins for input on how much it would cost to rehab the house. That's the text string right there. read the whole thing, you'll see that she sold the Midway Mansion to him not as a project they were doing, but as just a sale that she was brokering.
Interesting. Is that why she was saying no? Oh, we're gonna get the video from the party. Interesting. I bet the jury will go back and look at those texts. Was she making it seem like it wasn't a job they were doing? Because Eric was like, we don't have time for this. And she's like, oh, no. Making it seem like she was brokering it, not that she was buying it and flipping it. Interesting. And now to the party video.
Okay, you can clean that one, right?
Okay, ready?
Run.
Okay, I'm getting all three.
Cheers, boys. Cheers.
Yep, come back in the corner with us. There we go.
Richard.
Richard.
Yep.
I still don't know what that means.
Richard.
Look, Chachi's so good.
Ron, turn that all sexy out of here.
Oh! you were an Afghanistan warrior.
You are an Afghanistan warrior.
People grieve differently. There's no ancient artwork of that photograph.
Oh, shit. Oh, boy. Oh, boy.
This book provides kind of three pieces of insight into Kouri Richins. The first is she wrote it, had it written,
oh, the book,
and published it in early 2023 when she knew that investigators were investigating her for the murder of Eric Richins. She promoted it. Her mother sent a book to investigators, all to deflect attention away from Kouri Richins.
The book to investigators was wild.
She also wrote it to make money. You see the emails, they're in evidence. She thought she would sell 100,000 copies in 10 months at $5 profit a copy. That is not tethered to reality. But it does provide insight in how desperate she was for money. That she would trade. She would trade on her sons and the death of her father to make money.
Yeah.
The final things it tells you about
she's not going to like that.
Is that she wanted, as part of her facade, as part of her appearance of success, privilege, and affluence, she wanted to be an author. But she didn't write it. And you can see from her writings and text messages, Orange Notebook, the notes, the walk the dog letter. Not only did she not write it, she's not a good writer.
Oh, damn!
But she wanted to appear as one. The appearance was what was important to her.
Wow. It's like Bloodworth's been reading the chat. Not only did she not write it, but she's not a good writer. You read her emails and the walk the dog letter and the rest of it. He was just like, no, ma'am. No, ma'am. Oh, boy.
Of success, privilege, and affluence. She wanted to be an author. But she didn't write it. And you can see from her writings and text messages, Orange Notebook, the notes, the walk the dog letter. Not only did she not write it, she's not a good writer. But she wanted to appear as one. The appearance was what was important to her.
And that's his point, right? The appearance.
In defense's closing,
he put up a snippet of the walk the dog letter highlighted. Here is what I'm thinking, but you have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it.
When you strip out rhetoric that could be argued at any closing, any time, anywhere, on any case, when you strip that out of defense's closing and you hone in on substance, the entire substance of the defense's argument is based around trying to explain the walk the dog letter. Kouri Richins is saddled with this letter and needed to craft the defense around this letter. It's obvious that the letter was written to get her brother to testify to a narrative that would explain everything.
She's telling them everything.
Let's unpack the letter in about 15 or so sentences, not with what Kouri Richins wrote, but with what the evidence shows.
Interesting.
The translation from what Kouri Richins wrote to what the evidence shows. First part, here is what I'm thinking, but you have to talk to Ronnie. He would potentially have to testify to this, but it's super short. What the evidence shows is this says, I'm thinking that if you tell Ronnie to testify to what I'm about to write, it will explain everything and I will not get convicted.
You will need to tell Sky.
Ronnie will need to tell this to my lawyer because I just made it up and it will have to come from him. Never mind that I was arrested 4 months ago. I need an excuse for Ronnie and Eric to be hanging out. Never mind that football season ended a month earlier.
And he's putting up the parts of the letter on the screen.
I need to explain the fentanyl, and fentanyl must be everywhere in Mexico. Never mind that Eric would have to fly with the fentanyl, and I later say that Eric would not fly with drugs for fear of getting caught.
The internal inconsistencies. He keeps putting up different sections of the letter.
Never mind that I know this story despite Ronnie never telling me. I need to explain why everyone will testify that Eric never used drugs.
This is about when they traveled.
This kind of happened once with THC gummies on a trip to Hawaii. Hopefully this is enough to corroborate my entire walk the dog story.
Kouri has
I need
never
to
done any
distance
type of
myself
pills.
from fentanyl.
Is what's on the screen. Asterisk. Reword this however he needs to make
These
the
are my
point.
made
Just
up
include it
words,
all.
but Ronnie can make up his own words.
Why do you need to reword the truth?
If Ronnie does not say these things, I'm convicted.
What he put on the screen was it can be short and to the point, but it has to be done upon information and belief.
Not say these things, I'm convicted.
It goes on to say, lol, they never found pain pills or fentanyl in my house because he hid it in an allergy bottle in the work truck, and Cody emptied out the work truck within a week, so they were never found.
I need to explain why investigators never found a trace of fentanyl in my home. Never mind that it doesn't make sense that Eric hid the fentanyl after asking me to buy it.
When you talk to Ronnie about this, meet up with him in person. I worry your house and phone are bugged.
Don't get caught passing this made-up story along to Ronnie. That would be horrible.
He's just translating the walk the dog letter into argument.
Tell Ronnie to keep the story short so that he does not mess it up.
Tell Ronnie not to
Since his
overanalyze
conversation with Eric never happened, tell him that it was only 2 minutes long.
I imagine Kouri didn't know lawyers could argue and pick through the things that you said. She didn't have the benefit of watching the Adelson trial before she wrote the walk the dog letter.
He needs to do this so that I do not get convicted. I can then extract revenge on Eric's sisters.
And what he put up on the screen was, tell him I need him to do this. Bring me home, and then we will get those damn bitches. Have the conversation with Ronnie before he meets with Skye. Then tell him to tell Skye at the meeting about the convo. Interesting seeing this be played in court while Skye is also sitting in court. I don't know if the jury knows who Skye is by face, but they heard in testimony that Skye was Kouri's previous lawyer. We all know that Skye's sitting there.
Remember, I just made this story up, so my lawyer does not know it yet.
Tell my lawyer. She needs distance from it too. My lawyer cannot
All the evidence
suborn
in this
perjury.
case proves that Kouri Richins murdered her husband and the father of her 3 children, Eric Richins. There is no other rational explanation for the evidence. And despite all the evidence, Kouri Richins clings to the facade that has enabled her to get away with so much for so long.
Oh boy.
And despite all the evidence, Kouri Richins doubles down and blames Eric. She is intensely ambitious. See through her facade, check her ambition, do not let her get away with murder.
And that's the end of the rebuttal.
All right. Next step. Brittany, if you would please swear in the bailiffs that will watch over the jury during deliberations.
That is the end of closings. I'm going to put up a poll to see whose closing you liked better.
Y'all raise your right hand.
They are going to
Do
be
you affirm
sworn.
that you will take charge of this jury?
Do you affirm that you will not courthouse Becky this jury? And if anyone tries to courthouse Becky this jury, you will hip check them into a wall. Thank you. There will be no courthouse Beckying. Mary, this is a great question about Skye. I can answer that once let's get the jury discharged, and then we will have some time for questions. Do not allow any fuckery, because this court clerk would never.
And take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered, subject to the pains and penalties of perjury. Thank you.
Thank you. Ladies and gentlemen, a few additional instructions. If you want to read along, you can fast forward to instruction number 46.
These are the very final charging instructions for
Four-person
the jury.
selection and duties. Among the first thing you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into several sections, one section for each count charged. Each count has separate instructions. When rendering your verdicts, you need to make sure only one verdict for each count is marked. You may be asked additional questions about the basis of your verdicts. Remember, any response you give on the verdict form must be unanimous. Regarding jury questions during deliberations, these instructions should contain all the information you need to decide this case based upon the evidence. However, if you have a question or need clarification during deliberations, please write a note and give it to the bailiff. I will review it with the lawyers. We will answer your question as appropriate.
I like the way that instruction's worded.
This brings us to one of the more difficult parts of the trial for me personally.
Seat and yeet. Oh, the yeeting is so hard at this point. Look how sad the judge is. The yeeting is so hard. This is the worst part. It stresses me out. Can you imagine sitting there for this whole trial and all of a sudden it's like, and yeet. So sorry, you're the alternate. Yikes. He hates it.
A jury in the state of Utah is 8 jurors, and there are 12 of you. We intentionally impanel alternate jurors to ensure against the unforeseen because things happen. Jurors fall ill. They suffer a personal or family tragedy during the length of the trial. Sometimes they simply don't follow my instructions and they get exposed to information that it's not appropriate for them to have. Because we can't see around every corner, we impanel alternate jurors to ensure that an emergency or other unexpected circumstance does not cause a mistrial. We simply can't try a multi-week trial without the help of alternate jurors, and for these reasons, the service and sacrifice of alternate jurors is just as valuable and just as deserving of respect as the remaining jurors. Moreover, the service of alternate jurors does not end when they leave the courthouse today. Rather, the alternate jurors are still subject to all of the court's instructions and restrictions. Because if an emergency arises during deliberations, one or more of the alternate jurors may be called back.
Yeah, you may have to come back.
Join deliberations at that point.
I like the way they explain the alternates.
We could not have expected that all of you would be so hardy and so diligent in following the court's instructions, and so we impaneled 4 alternate jurors. The alternate jurors in this case are jurors 9, 10, 11, and 12. If jurors 9 through 12 would please stand.
It's just the last seats.
An important instruction. This case isn't over. You're still impaneled. Please do not talk about the case. Please do not let anyone else talk about it to you. Please do not read, watch, or listen to anything about this case. And do not do any research of any kind about it until I call you personally to let you know that all of these admonitions are lifted. Thank you for your ongoing service in this case.
So
please
hard.
rise for the alternate jurors.
The alternate jurors are getting yeeted. They can't talk about the case until they're called back or a verdict is reached.
Yeah, Greg, if you would let them out, I have a couple of extra instructions for the 8 remaining.
It's just such a bummer. Being an alternate is just the worst, but they're not being kept at the courthouse for the rest of the day. They can't go look at information about the case.
Okay.
They can't talk about the case. They just have to wait. And it would suck. But they do get to go
Members
home.
of the jury, as you deliberate, you may have questions. If you do, please remember, you can write a note, give it to the bailiff. I'll review it with the lawyers, and we'll answer your questions as appropriate. Please remember, though, that the bailiff cannot answer any trial questions for you. Just as you have not been allowed to research or investigate matters on your own during the trial, you may not use any outside source to research or investigate any matter as you deliberate. No online dictionaries, no online maps, nothing outside the evidence presented in this case. We will provide for you in the deliberation room the exhibits. You may take your notes with you. You may take your copy of the jury instructions with you. We'll provide a copy of the verdict form. This case is now submitted to you for deliberation
and they
determination
go to deliberate
of your verdict. Please rise for the jury.
All right. Jury out. It's time for them to begin deliberations. And because we are on, well, time is a construct time, I think the jury's probably been out maybe about an hour. That's about how far back I think we are. But
folks, have a seat.
Those
Thank
are
you.
kind of guesses based on those in court. So I
Ms.
think probably right around
Nestor,
an hour.
Ms. Lewis, anything else on the record?
No, Your Honor.
Okay. Mr. Bloodworth, Ms. Shervanek?
No, Your Honor.
All right. Let's make sure Brittany has your contact information. Regarding scheduling, my normal practice would be to check in with the jury around 4:30 and just ask them what they would like to do regarding continue working into the evening or retire for the day and come back tomorrow morning. Any objection, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. I need one member of your respective teams at least to begin confirming with Brittany after we go off the record that we have consensus regarding the exhibits that have been admitted and will be going back into the jury room. If any disagreement comes up, let me know. We can handle it on the record. Ms. Nestor, anything further at this time?
Your Honor.
Mr. Bloodworth?
Miss Nestor sounds
No, Your Honor.
All right.
Under the
Court
weather.
will be in recess. Thank you for your patience.
All right. Court is going to be in recess. It is almost 4:00 local time. So we're going to hang out because, wait, what? I already forgot. I was reading chat. What time did the court say they were going to check in? Did he say 4? Hold on.
Court will be in recess.
Hold on. I'm going to back up. Emily, you were reading chat. I was.
The record that
I lost my train of thought.
Retire for the day and come back tomorrow.
All right. Hold on. He said 4, right? 4:30?
Scheduling. My normal practice would be to check in
Emily, you just wanted to hear the judge talk more. Yeah, we were promised 2 more weeks of trial.
with the jury around 4:30 and just
Okay, he
ask
said
them what
4:30.
they would like to do regarding continue working into the evening or retire for the day and come back tomorrow morning. Any objection, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.
Well, that's about a half hour from now.
I need one member of your respective teams at least to
Okay, that's about a half an hour from now. I also got past a note that they came back onto the record briefly. So thank you, Team Baker. That we're gonna hang out and see. That's about a half hour from now. So we've got Zoom room and we got a ton of questions. And we're here. So let's see what they come back on the record about. Because I don't know.
Ms. Nestor.
They did come back on the record though. All right.
Back on the record in
Let's see.
231-500-139.
I imagine they haven't even left the courtroom yet because they need to go through the exhibits and make sure that they've got everything. I did have one trial where we didn't even get the exhibits back or the verdict forms back, and they buzzed with a verdict, but this is not that case. I imagine the jurors are going to want to sleep on it. We will talk about the alternates. We will answer questions. I just want to see what they put on the record now. Because the attorneys wouldn't have even had a chance to leave the courtroom.
Mr. Bloodworth and Ms. Shervanek are in the courtroom. Ms. Lewis, Ms. Nestor, and Mr. Ramos are in the courtroom with defendant Kouri Richins. As the 8 jurors were walking out and making their way, to the jury room, juror number 2 pulled Deputy Zag aside and handed him this note, and as she was handing it to him said,
"There's another note?" This jury has been prolific with the notes. We have another note. Why does this stress me out? This stresses me out.
Juror number 2 pulled Deputy Zag aside and handed him this note, and as she was handing it to him said, I thought we were supposed to receive a factual stipulation before we got the case. Or
They were Somebody's going through their notes and checking it twice. There was a factual stipulation. Somebody's checking their notes because that was done at the end of the prosecution's case and then everything went fucking sideways. Oh my God. They were supposed to read it on the record.
words to that effect. And the note says factual stipulation, ? How would you like to respond, if at all?
Y'all were supposed to read it.
Yeah, it was an exhibit. When you were going to read. 865 is the exhibit.
It's regarding, I believe, the Burmester stipulation of fact that we had introduced to Your Honor.
But not read?
But not read.
It had not been
May I direct
read.
them to it by number?
Yes.
I think that might be best.
Can we have a consensus about what the number is?
8-65.
Can we confirm? We'll look at it together.
That's funny. Well, somebody's checking their notes.
Katie, are you able to pull it up?
Katie is the tech individual for the defense.
It would be 8-65.
That's what everybody
If
thought
you
it
would mind
was.
plugging in, we'll look at it together.
Let's look at it together. I don't know what it says because I didn't read it.
Digital copy of that. I think it was
Scott, if you wouldn't mind plugging in, we'll look at it together.
Oh boy, the jury is paying attention. They introduced the factual stipulation. They did not read it. Somebody's paying attention. And 8-65 is the exhibit number for the factual stipulation.
We did provide Your Honor with a hard copy.
And we marked it with a sticker.
Yeah.
Scott, can you just plug it in?
For whatever that's worth.
It
Scott.
should be on the screen now, Your Honor.
Yeah. Let's see.
Scott, can we just, if Katie can't pull it up, can you pull it up?
It's among the things we're sending back. Yes, Brittany?
What are we doing?
Okay, so I will just do my usual question, factual stipulation, ? Answer. Please see State's Exhibit 8-65. Any objection, counsel?
No, Your Honor.
No objection. I had another question. Just in the event they want to view a physical piece of evidence.
Good. Stipulation of fact. They put it on the screen. It was like they heard us screaming for the stipulation of fact. Let's read it together. This is 8-65 that the jury was like, hey, weren't we supposed to get a stipulation of fact? What was that? Stipulation of fact. It is the agreement of the parties to the following facts. 1, Megan Phillips is employed by the Utah Bureau of Forensic Services Crime Lab. On May 2nd, 2022, she received 19 items brought in by Chelsea Gibson from the Summit County Sheriff's Office. Ms. Phillips inventoried the items compared with a prepared UCJIS form and printed labels for each item. Each label identifies the item and has a barcode that allows it to be scanned whenever it changes location or custody within the lab. Ms. Phillips then scanned the items into the crime lab custody and placed them in the secured evidence vault. The evidence vault is a secure room with restricted access. Ms. Phillips placed the items in this case in a uniquely identified place in the evidence vault. Once analyst Brian Holden was assigned, Ms. Phillips took the items out of the spot in the evidence vault and took them to Brian Holden's individual evidence locker in the adjacent transfer room, where she scanned them, updating the new location, and then notified Mr. Holden. State's Exhibits 9-1, 9-10, 9-11, 9-12, and 9-13 were among the items Ms. Phillips received from Chelsea Gibson on May 2nd, 2022. The items have been opened and resealed, but otherwise in substantially similar condition to when they arrived. It is a chain of custody stipulation, unless there are more points.
Like the gummies?
Yeah, any of it. A phone. I don't know.
Yeah.
So now the next question being asked to the court is, what about the physical items of evidence? That's not an issue. That is just it's a stopgap that the parties stipulated to. It doesn't need to be read on the record because it's admitted, so the jury can just read it.
I had another question, just in the event they want to view a physical piece of evidence.
Like the gummies?
Yeah, any of it.
Not the
phone, I
gummies.
don't know.
Yeah.
Miss Gibson has custody and control of them. She knows that we may need to alert her
Okay.
if they need it. So
Got it.
if that's a question that comes up, we would just have to get to Chelsea and she can bring it over.
We'll keep you posted.
That sounded like
Ms.
Ms.
Lewis, Ms.
Sherman
Nestor, Mr. Ramos, any objection?
No.
Okay, that's what we'll do. Now, I'm about to go off the record, but I need a lawyer from each side to
I need a
stay
lawyer?
with the Scott and Katie of your respective sides and reach consensus with Brittany about what's going into the jury room before you leave the courtroom.
Yes, sir.
Even if the lawyer doesn't do any talking, I just need you to stick around. Thank you. Very good. We're off the record. Thank you.
Oh, sorry for the on chat. I know they're contagious. Lyndon in the chat said, I need a lawyer, Andy Cohen, and a camera. Stat. All right. Well, the jury is deliberating. We're going to answer some questions. We'll see if the court checks back in with the jury. We're going to be caught up in real time in just a moment here because, well, we're caught up in real time with the jury deliberations. Are we going to just let them deliberate? Yes. Would you appreciate, here, let me just start a new poll. Let's see. 97% of you thought that Bloodworth's argument was more persuasive. I think there will be some that even if they don't feel that the state has proved every element, might still find that to be, the more persuasive closing argument, even if they think that there are holes there. I do not think the defense had the best closing. I don't know. Closing. I have no comments as to anybody's clothing today. Kouri didn't have a jacket today. Do I care? Not really. It just was not, well, for the reasons I said before, well ordered, easy to follow. And I think that they lost their points with it being scattered. And then it was just odd. Nestor bringing in her own experience in that way was odd. So let's get to questions. We're going to leave this in real time. And once I leave this, well, let me do that. Let me leave this up with, do we want a comfort seal? Do we feel better with a seal, chat? Do we want to keep the seal on just to see what happens? Yes. Most of you are saying yes. I was going to put a poll up about leaving the seal up on the screen, but a lot of you are just like, yes, just leave the seal. Just leave it up. We'll just make it a little bit smaller. We'll just leave the seal up. Emily, are we just rearranging how your entire setup is? Sure. Why not? Emily's fought with tech enough today. Why not more Emily fights with tech? It's everyone's favorite part of the behind the scenes of the podcast is EDB fights technology. It is a regular feature of the behind the scenes podcast recording. And we'll just leave this up. All right. Give me 1 second. We'll rearrange things. Why not? We'll fix it all in post and we'll get to questions because no, that's not what I wanted to do at all. Nope. We wanted to move the camera over. So there we go. We're just doing it like that. It feels very off balance to me. It's fine. It's all fine. It'll be fine. We'll fix it in post. It'll be fine. Just leave it there. All right. Let's get to questions while we leave this up. I'm actually going to turn the volume on this down so it doesn't jump scare me because that's going to happen. It's been a busy day. So the jury is going to have a check-in with the court in about 20 minutes. We're definitely going to have at least 20 minutes of questions. If now is the time where you need to just pop off and get some emails done and what have you, fair. Make sure you have the Law Nerd app because the second we hear anything or when we know that the jury is going home for the day, we will let you know in the Law Nerd app. If we are going to, we're going to hang out. I don't think the jury will be back today. That would really surprise me. There's too much in this case for me to assume they're going to be back today. So we're going to answer some questions. We'll let you know in the app and we'll go from there. So a number of you are saying that the defense has released a statement. That would be silly. It's that the jury's still deliberate. That would be silly. We'll get there. We're going to do a quick recap of closings. We'll take a look for it. We're going to answer some questions. That would be odd to do. But if they did, I'll reach out and see if the prosecution has any response. Because, I mean, fair's fair. If they did put out a statement, we can ask. So we'll take a look. Let's see if the court, I'll see if the court put out anything from the court. Here's what the court said. The jury is now deliberating. Please remember, there was no filming or photography directly outside the courthouse. The rule remains in effect even after a verdict is reached. We will bring attorneys and or families to the parking lot following the trial. If they would like to make a statement, please adhere to this rule and keep your cameras in the northwest corner of the parking lot. That is the statement from court. But we'll pull it up. Let's try to do a summary of closings and go from there. I am surprised that closings got done today. I think the jury is probably very thankful. The jury has like an hour and a half maybe of time to deliberate today. I don't think that's really enough time for them to come to a verdict on a trial this long, especially when you have a murder, an attempted murder, 2 fraud counts and a forgery count. That's a lot for the jury to consider. You have 13 days of testimony and some days that got a little bit kerfuffled. There are things that came up in closing that I forgot. And I was like, wait, what? And if I was a juror, that's one of the things I would want to go back and look at. How did you remember this? How did this land with you? What do you think? Remember, they have not had the opportunity to talk about this case. We've gotten to talk about it for 15 days. The jury has not gotten to talk about it at all. They can't talk to each other about it. They can't go home and talk about it. They can't rewatch it. They can't be like, oh my God, that was crazy. They don't get to do it till now, and they're going to need some time. They need to pick their 4-person, which they get to do on their own, and then they need time to talk about the case because it's important for them. And after closing, I imagine their brain is just going to be like, I need a minute. I need a minute. I need a minute to process all of the information. And what we saw from the jury note at the end of this case is that they are paying attention. They're like, hey, I thought we were going to get a stipulation. What was that? Okay. Which means there are jurors that also have loops they're waiting to be closed. And that level of attention to detail, if I were the defense, I'd be really happy about. Because the defense needs to point out those details where the jury should be asking to close those loops. And I don't know if I don't know if that closing was precise in the way one would hope when they are trying to point to holes. I think the scattershot approach of, well, you can't believe Carmen Lauber, and you should speculate that when we asked about her learning disability, it was this because she's highly suggestible and manipulable, malleable to law enforcement suggestions. There was not a lot of precision. And I think that's why in rebuttal, we saw the prosecution talking about precision, that being precise matters, that what was said matters. Because I think at times in the defense closing, they invited fact checking. Hey, what about this? Hey, what about that? Hey, is that really what was said? And in the prosecution's closing, there were more times where I was like, wait, that's an interesting point. I remember that evidence. I didn't make that connection. That's not how I remember that evidence coming in. Then again, I have been with this case since the bond hearing, in 2023. So my memory of the evidence is not just this trial. My memory of the evidence goes all the way back into the pretrial motions. And there were things that we saw in pretrial that we did not see in this trial. And there are things we saw in this trial that I was surprised that the judge kept out. And there were connections, even with all of that, connections made by the prosecution that I was like, oh, that's a really interesting point. And the defense trying to take that evidence again and modify it did not land with me in the way that the evidence came in. And I think there were ways that the defense could have made some good points on, do we know that this is this? Do we know that Kouri Richins was procuring pills? And they acquiesced to that. But Eric asked for them. Are we leaning into the walk the dog letter being true or not true? Is Carmen telling the truth about selling Kouri pills or not pills? It was like, this is true, but this is also not true at the same time. And I think after a really early day on Thursday, almost a full day on Friday and a full weekend, I just expected more precision from the defense closing, because I think there will be people who watch this case and are not as comfortable with circumstantial evidence. And I think the defense could have leaned in to the circumstantial evidence and kept some of those doors open that the prosecution was going through in their closing and pulling those doors shut or trying to. And the prosecution leaned in. Hey, this is where it's said in that transcript. This is where it's said in that transcript. This is where it is here. And that's not what we saw in the defense closing, but they had time to get there. I was surprised. And then I was also surprised that part of what the defense said in their closing was, yeah, strategy changes. Eric was having multiple affairs. They said it was an open marriage. Strategy changes. Okay. Interesting. But when you are going up against a prosecution team that you know is methodical, that you know is precise, trying to meet them there and then not getting all the way there is tough. And it did not land as well. I'm curious what you think about the closings. Let me know. We're going to go through some of your questions. And it seems that the defense has made some kind of a thing. I'll go grab it. Thank you to Team Baker for grabbing that. Because sure, it's wild. We'll reach out if we want to. We can reach out to the prosecution and ask if they have a statement. I'm not going to do it right now because the judge is going to check in with the jury in 10 minutes and see if they want to keep deliberating. We haven't even gotten to questions yet. But let me pull that up. I'm going to switch around our layout just a little bit here so I can pull that up. Give me 1 second. I'm going to just leave court running, and then we'll switch back over to court. This is a wild choice. Emily, have you read this? No. It was posted by Kathy Russin on Twitter. Team Baker went and grabbed that. Thank you for grabbing me the link. Let's see what it says. They posted this 4:53 p.m. That would have been my time. So half an hour ago, I guess. Statement from Wendy Lewis, Kathy Nestor, and Alex Ramos, attorneys for Kouri Richins. After 3 weeks of testimony and closing arguments, this case is finally where it belongs, in the hands of the jury. We are grateful to the jurors for the seriousness and care they have shown throughout this trial. They have listened closely to every witness and every piece of evidence, and we respect the responsibility they now carry. For nearly 3 years, the public has heard accusations about Kouri. Those accusations created a narrative that spread far beyond this courtroom. But in court, accusations are not enough. The law requires proof. After 3 weeks of testimony, the prosecution has failed to prove its case. You should have just started your closing argument with this then. Sure. The standard in this country is proof beyond a reasonable doubt. That burden has not been met. I mean, if you respect the jury to do their job, isn't it for them to decide that that burden has not been met? Why are we trying to get out ahead of a conviction? Does this read like we're trying to get out ahead of a conviction? This reads like we're trying to get out ahead of a conviction to me. But if you believe that it's in the hands of the jury, why don't you just wait? Wait. Okay. After 3 weeks of testimony, the prosecution has failed to prove its case. They say the standard in this country is proof beyond a reasonable doubt. That burden, they say, has not been met. Kouri has maintained her innocence from the very beginning. Over the past several weeks, the jury has had the opportunity to hear the full evidence, not the headlines, not the speculation, but the facts. We believe in the jury system and we trust the process. Kouri should finally be able to go home to her three young Kouri should finally be able to go home to her 3 young boys and begin rebuilding her life. That's wild. Okay. It's interesting to put out such a strong statement while the jury has barely gone out to deliberate. That's just a choice. The team that gave the most interviews in this case was the defense. I think what really shifted this case from the beginning was the walk the dog letter. I mean, the bond hearing didn't help. The preliminary hearing didn't help, but the walk the dog letter was a giant shift in this case, and the defense was mad about it then. They're going to still be mad about it now. And we trust the jury. But this is what we think they should do, but we trust the jury. Interesting choice as deliberations have just begun. But what, hoping that maybe the alternates are home looking at Twitter? Sure. I don't think we've seen a team release statements other than Depp Heard, where there was like a week-long break and everybody was releasing statements, which was weird too. I don't think we've seen a team release statements prior to a verdict coming in. However, Kouri does have a 26-count fraud case pending for her. So I don't think, no matter what the jury comes back with, they would just release her. But okay. Interesting choice to make a statement. It is a strange choice timing wise for me. All right, don't worry. We've got the comfort seal up. We're going to go. The PR is just odd. Also, I wonder why they would want to even mess with that while the jury's deliberating. But there are lots of questions from this defense team or lots of strategies that have been interesting. I think it was very interesting, though, that we got to closing and they were just like, oh yeah, in opening we said we'd show you those things. Strategy changes. Strategies might change, but the facts don't. And I don't think we're at, Kouri, we've proven that Kouri knew about the trust and that she knew she wasn't going to get anything. They didn't even argue that in closing. They insinuated it in opening, but they didn't even argue it in closing. There's a reason they didn't argue it in closing, I'm sure. Judge M, what are you, Judge M, what are we? It's a man without a robe. Hold on. Judge M. We're going to go full screen. Do I think he's just probably checking the bench to see what was said? Yes. But are we backing up? Yes. Because it's a judge without a robe. It's robeless. Look. He's like, we're not on the record. Judge M's too tall. They can't focus on the seal. Judge M's like, I just need to check my calendar for tomorrow. And then the camera person is like, shit, we're without the robe. What's going on? No. Chat, he's just checking his, I'm sure he's just checking his computer on the bench for his work docket before they check with the jurors to see if they're going to be released for the day. But Judge M without the robe. I know, the scandal. The scandal. This is why every courtroom should have a fan. This is why there should be a fan in every courtroom. So we can focus on the fan. It's so much easier. Oh no, the judge without his robe. All right. They're going to check in with the jury in like 10 minutes. We're going to answer your questions. We're going to see what they do for the rest of the day. If you do not have the Lawnerd app, we built it for you. It is free on iOS and Android. Lawnerd app at lawnerd.com so that we can let you know when we are going live. I do not think the jury will have a verdict today. That would surprise me quite a bit. We've been surprised before, but I would be surprised. I would imagine they would want to go home and sleep on it. And I imagine there's more they want to talk about because it's not just a murder case. They also have those financial counts that they need to parse through. And they're going to need some time. And they're going to want to talk to each other. But when we do go live, I'll let you know. When we are going live, we're going to see what happens today, though. We're just going to hang out. We're hanging out today. Let's go to questions. A lot of you are asking what we're keeping on the other screen. Ryan Hall, y'all. I hope that I think we're out of the target zone today. I don't know how he turned around. He streamed so much last night and then turned around and streamed today. For those of you who are like, Emily, what is Ryan Hall, y'all? He's the internet's weatherman. He streams all of the severe weather. And what I appreciate as we were watching from our take shelter as the tornado sirens were going off last night, which our cats, let me tell you how much our cats love that exercise in getting into your safe space. Not much. We were watching Ryan Hall, and the thing that Travis said is he's like, you know what I really appreciate is that even when they deliver, like, you need to get into your safe space, he's like, there's no stress to it. It is just delivered with a just factual, neutral, you guys need to keep an eye, you need to be prepared. This is when they're telling you to get to your, like, it's just the way it's delivered is fantastic. So the prepared, not scared of the weather folks, I appreciate it. So yes, I popped into the chat yesterday until our sirens started going off. And then I was like, oh, well, our sirens are going off. We tune in quite a lot to Nashville severe weather because they cover the counties here. And it's always a good time for me to try to teach Travis, like, this is how we need to pay attention to the weather. Because next year you're going to be living still with weather, but not in my house. So we need to just keep in mind. And then we got distracted talking about how Ryan Hall's like built all of his stuff because I'm fascinated. Sandra and everyone who gifted memberships, thank you. I think we will get a chance to pull up everyone who gifted memberships today. I appreciate it. Rebecca said, so thankful to be here with the Law Nerds and EDB. I feel like I'm with friends. I'm ready for this closing. I was surprised. Like, Bloodworth went in. Like, there were times when Bloodworth like went in. Like, in. Yeah, it was wild. A few of you are saying you were unaware that Kouri Richins has other cases pending. No worries about that. She has a financial case pending. I broke it down close in time to when they filed it over the summer. It accounts for more of the financial stuff. Mortgage fraud, the stuff with Bestie's house, and the rest of it is in that case. So yes, there are other cases pending. There are other cases pending. And so that factors in here as well. Her defense attorneys, of course, are focused on the murder case. It is the most serious. Bad Girl Sniper, I am so sorry to hear that your paw nerd is missing. I hope he will find a way home. Cats are very good at that. So I hope that you will be reunited soon. That has got to be incredibly stressful. It's got to be incredibly stressful. We got a question. DK asked, so the defense going to present their case in closing? Basically. I mean, the defense has every right to just be like, hey, they didn't prove it. Let me tell you why they didn't prove it. I think attacking Carmen Lauber and Eric and others indicated that the defense is worried about those things, but I would have liked to have seen them spend a little bit more time on the elements. I think they had room to argue in those elements. I think at the end of the day, with Kouri's own statements and texts, it's going to be hard for them to overcome it. But it depends on the jury. It depends on how the jury evaluates the evidence and what the other jurors think, because they're going to want time to talk. So let's see. Emily asked, why would a defense attorney saying they're going to prove something when they don't have to prove anything? The opening statements and the way they were done was interesting because they've got to know what's coming in the prosecution's case. They've got all the evidence, but the evidence will show, the evidence will show, the evidence will show. And then to have Nestor in opening say, I'm going to ask every witness this question, she didn't. Even little things like that, if you're not going to follow through with them, I don't know why you would just say them. But the defense has leaned into like words, just words. But the way they attacked Carmen Lauber, I think really belied how much they were worried about Carmen Lauber's testimony. But then to be like, oh yeah, no, Kouri bought pills from Carmen, but they were pills for back pain because Eric wanted her to. By the time you get to closing, throwing too much spaghetti up at the wall to see what sticks is really going to be a problem. Really, really going to be a problem. Let's see. Kimberly said the prosecution stipulated to defense directing witness staking during the prosecution case. Then defense rested, quote, without putting on a case. If the prosecution had rebuttal witnesses related to that defense direct, when would they have called them? During their case in chief. So the prosecution still was in their case in chief when staking was given a direct by the defense. They had the opportunity to then do a cross of that witness, and then they could have brought in rebuttal witnesses still in their case in chief before they rested if they wanted to. So they had the time then to do it. Lemon Holly, you're not alone. Lemon Holly said, I think they should have let Ramos do the closing. I don't disagree, but I don't think that the jury saw Ramos enough. It was like day one and then maybe one or two other crosses. I think Ramos improved over the course of his crosses, and then he was just gone, which was odd to me. Absolutely odd to me that Ramos was just kind of gone from this defense case with the witnesses. So I was surprised. Task and Conquer said, if they strike something from the record, does it stay in the transcripts or do they delete it? It stays in the transcript for appellate purposes, but it talks about what was stricken and it referenced what was stricken from the record. But if something is stricken from a witness testimony and a transcript is provided to go back to the jury, it would be stricken from there. So they wouldn't read it again, but it does stay in the record. But if a transcript is prepared for the jurors to consider, it would come out of that, if that makes sense. I think that was a great question. Justice Junkie, thank you for the gifted memberships. I'm sure because we have lots of new law nerds that will ask, I do not poll as to the questions that the jury ultimately has to decide. I think that there will be definitely some, depending on how you see this case, that might find one closing more persuasive than the other, but still not necessarily agree. Which is completely fine. We don't really get to deliberate the way that the jury does. I came into this case with a lot more information than I have in some other cases, but ultimately it's the jury's decision. And I don't roll with, let's stake how we see a case up against how the jury sees the case. Because even in a trial where we come in like jurors, we still see the stuff going on during trial that the jurors don't see. We still have more information than they do. And ultimately, it is their decision. So I don't poll as to ultimate questions for the jury. I saw a couple of you asking when the sentencing is for Banfield in May. I know it's like, We're done with trial. What do we do next? Don't ask. Don't ask. What do we do next? Until after there's a verdict of some kind. No. We're in verdict watch. That's what we do next. We're in verdict watch. We're in verdict watch. And we will be in verdict watch until we are no longer in verdict watch. And we'll go from there. MiniDev78 said, thanks for the distraction from the blizzard. The weather, right? Wild. Ashley Elizabeth just said, moo. I know, utterly ridiculous. The utter conversations. I saw a couple super chats asking or talking about her not doing CPR. The not doing CPR is a big one. And a number of you in the chat who have had the unfortunate experience of doing CPR. I saw B2 comment on it and others who have done CPR. It's odd to me that on the call, Kouri's not asking about things that are happening during CPR, which A, I've heard on other 911 calls, and B, the first time I did CPR ever, I was like, is this supposed to be happening this way? Is this supposed to be happening this way? This is, and especially knowing that once CPR was started on Eric Richins, there was quite a bit of fluid that came back up from Eric Richins. I'm trying not to be too graphic, but there was no question about that from Kouri, and Kouri did not have anything on her at all. She did not sound out of breath. There was no indicia of CPR, and her phone was objectively not on speakerphone. So there's room for like stress, but that I think the juxtaposition of Kouri and Katie just kind of highlights that stress and the different levels of panic. So also Kouri didn't have anything on, any blood on her, any fluid on her, anything from doing CPR. So I believed in justice after the closing. Deliberation starts immediately. Yes. And they are deliberating now. They have not put on the record whether or not the judge has asked the jury if they want to leave for the day, but I imagine they will tell the lawyers and they will ask the jurors what they want to do. And once we see any information about that, I will let you know. But we're going to keep asking questions for now. So Kouri not asking like, is CPR supposed to go this way? I'm hearing this, I'm feeling this, I'm experiencing that is odd to me. But I don't think she did CPR based on everything we've seen. So Captain Retz, thank you for the gifted memberships. I appreciate it. Alessi's fantabulous lexicon in the chat said, I've been summoned for jury duty. First time in Texas. I hope it's an interesting case because I usually get picked. Good luck, good luck, good luck. And I hope it's an interesting case too. I do. Kat said, great closing arguments. One of the best. It was incredibly organized. I really liked Bloodworth's closing. Did you notice the no notes? It's been a minute since we've seen a full closing argument with no notes. Right. It's giving that Bloodworth has done a lot of trials. Fitzy games, are there any lesser includeds? Nope. No lesser includeds in the jury instructions. No lesser includeds given. I do not know if that is a quirk of these charges or of Utah, but no lesser includeds. Let's see. There was, Stephanie asked earlier, EDB, since Lewis was the one to object, does that tell us she'll be doing closing after all? I think so in hindsight. However, I don't know. I don't know what the choice was to split the two attorneys doing opening and closing, because I don't think that Lewis is easy to listen to. So again, you have to earn the outrage. And we did not see that here. I think with Bloodworth, there was a little bit more earned outrage, but even then the words were pointed, but the tone was not angry. So it's a different delivery. I don't like it when prosecutors are also fire and brimstone. I think it can come across a little heavy-handed. So even with the pointedness of the closing, the way it's delivered does not come across as heavy-handed. I think we've seen some. I can't think of one that was heavy-handed. I think Georgia Kappelman, I don't think hers was heavy-handed. I think Georgia Kappelman had moments where she was just like appalled, but I think it was well earned, where in her closing, she was like, are you fucking kidding me? And I think it was, again, earned. I think the jury was with her in those moments. B2 said, I actually had to perform CPR on an aircraft. I will spare the details, but no matter who you are, CPR is exhausting. Yes, and that would have been very stressful. And yes. And it was wild. Casey Cat, similar experience. I did CPR on my neighbor for 16 minutes till medics arrived. I tore my rotator cuff. He had a massive coronary and was dead, but we tried. It's exhausting. It's exhausting. And you try. And there is a stress that comes with trying, even if it's almost beyond hope to try. And we did not hear that from her. And we did not hear Kouri Richins on that 911 call sound like, well, the way that she purported herself to sound to her bestie, which is, I think, more telling, because the defense wanted to say you can't judge somebody's grief. Okay, I will take you at face on that. You can't judge somebody's grief. Fair. Then why is she lying about it to her bestie? Why isn't the statement to the bestie, I don't even know what was happening. I was completely numb. I was stunned. I don't know what I did. I don't know what I said. I don't know what happened that day. I remember they arrived. I remember Katie arrived. The entire thing is a blur. I have no idea what happened. Why make up a story to make yourself look like you did more than you did? That part is tough to get over. And I think the defense could have guessed that Bloodworth was going to be precise. So, music to my soul. Did the instructions cover consciousness of guilt? Yes, they did. And yes, they do. And yes, they did. Emily, if you get Bloodworth on the show, please ask him about the pants. We'll have to see how things play out. But because I want to moderate expectations. There is a pending criminal case here. And asking him to comment on facts that have not come into evidence in this case could be tenuous depending on what the outcome is. But who knows? Maybe at some point, Bryce will make a statement about the pants. One can hope. But we did see other people's pockets, not other people's pants, but other people's pockets. And the shits out of the horse elephant analogy, I think, was a very visceral closing argument. I've never seen anyone use that in closing. It's very good. It's very good. Kathy, thank you for the gift of memberships. I saw in chat a question that I wanted to grab real quick from RESQ. I hope I pronounced that right. ARR. Emily, it's always Talk Like a Pirate Day? Yeah, sure, why not? Why wasn't it mentioned that EMTs could tell Kouri never did CPR? Because I think, A, it's for the jury to remember, and B, her own lies about it were pretty telling. So I think that's why they just let it be. But yeah, they were like, we know that it didn't happen. For sure. Let's see. Allie Mama Bear said, inaccurate financial statements is pretty darn generous, Bloodworth. The spliced statements. Yeah. Yep. Bloodworth is the type of classmate I'd want in a group project. I think Bloodworth is probably the type of classmates a lot of us were in a group project where we were like, if I don't do it myself, everyone's going to let me down. So I might as well because Bloodworth was precise, but he was precise this whole trial. It is one of the things I appreciate about him as a prosecutor. He is not overwrought. He is not heavy-handed. They're not pulling anything over on him, but when the defense would shenanigan, he was not getting caught up into the swirl of shenanigans. He was like, all right. You want instruction? Have an instruction. You want to do that? Fine, we'll do that. Fine. Just fine. Fine. Sure. Go ahead. Whatever. Just, yep. He did not get pulled into the swirl of the defense. And some attorneys would. It would be hard not to. It's frustrating. And it was constantly something. It was constantly a different plate spinning in the air. And it takes a pretty seasoned attorney to not get pulled into that. And even when they were arguing in court and the defense was just like spinning plates in the air, instead of feeling the need to rebut every single point, which we saw from Brendan quite a lot most recently, what you saw from Bloodworth was, is there anything the court needs me to respond to? Because just for the record, what we actually said was this, this, and this. The misrepresentations were hard for me. I find it very frustrating. But I think I've made that clear, that I find it frustrating. Let's see. Motion for a laundered blanket in the merch shop. Motion to snark. I will keep it in mind maybe when we get back around to colder climates or colder weather, even though now we're in that fake spring number 1, 2nd, 3rd winter. We'll see. Akron said chucking a mimosa every time the defense asked for the court's indulgence during their close. I don't think they asked for the court's indulgence during their closed once, which I appreciated. Love that the visuals came straight to stream, not just the cameras filming the screen. I think the plugins and the way the courtroom worked was fantastic. The graphics, I think, were great. They did a fantastic job. I think the presentation of evidence, there was a lot that the prosecution needed to do, for sure. And I think that they did go through those. I was surprised how short the element instructions are. They were concise, the element instructions, truly. And I will probably go back through and screen grab them and share them on social. There was not a lot to the element instructions in Utah with this. Not a lot at all. Ashley Elizabeth said she needs to control her face for real. They can still see your face, ma'am. Yeah, they didn't like it being pointed out, did they? Not at all. Really, really didn't. Really didn't like that at all. Michelle said attempting to get caught up on stream, watching it sped up while I speed it up is hard. Loretta said my daughter Carly also is in the chat, lost 3 cousins to fentanyl. I'm so sorry, Loretta. All had struggles. This trial has both of us with them heavy on our minds and hearts, I am sure. And the attacks as they were levied in court, I'm sure did not help. However, the goal of the defense is to truly throw every bit of doubt they can at the wall. They do have to be mindful, not of us and not of how we see something, but of how the jurors see it. And they know the jurors that are on their jury, but not everyone shares every family experience they've had. Not everyone shares every detail of a cousin, of a friend, of a friend's brother's friend. Not every juror shares every single thing. And the defense didn't seem to be concerned with the way that they went about attacking some of the witnesses in this case. I think the difference between how Carmen was treated and how Crozier was treated was fairly stark. And I think that's tough. Yeah, I think that's a tough thing for them to overcome. Let's see. We will. Draft H74 asked Emily, when do attorneys begin preparing their closing arguments? It depends on the attorney. I am sure everyone is different. I would ask every attorney in their chat the same question. For me, I would start preparing closing arguments when I first got a case file. Like, what am I going to have to prove on this case if I thought it was going to go to trial reasonably? If I looked at a case and was like, oh, this probably isn't going to settle. What are the elements of the offense that I'm going to have to prove? What are the facts that go to those elements? What am I going to highlight? And then it continues to iterate throughout the process of the case. And I imagine the defense starts to do the same thing, because you need to know, as the case comes in, what evidence you need in, what witnesses you have to have in, what exhibits you have to have in. You can't put in everything. You need to know what you're putting in. And so for the state, you, I think, want to work backwards. What are the elements of the defense? What facts go to those elements? What witnesses do I need? And then you build it out from there. And as the defense, you're looking at, what is the state going to bring in? Because you have all their case file. And where are their gaps? And where is their doubt? And then what do we need to get out in cross-examination to go to that doubt? And everything, I think, should be focused on how you're going to explain to the jury this case. And you work from there. I don't think everybody does that, but it would surprise me if people didn't have it in the back of their mind. So, Ashley said, this debt makes me feel better about my own debt. I mean, I think that debt gave people anxiety in this. It was a lot, quite a lot. Doesn't the cop give away that she's in custody? I don't necessarily think so. When there's law enforcement in the courtroom, I think most people expect there to be bailiffs in the courtroom. Dawn asked, Emily, what was your most difficult case? There are a lot of ways to categorize difficult. And well, some of my difficult cases were difficult cases getting my office to dismiss them because I didn't think they should be prosecuted. Some of my difficult cases were emotionally difficult. Some of my difficult cases were factually difficult because the witnesses were difficult. I had one of my very first felonies was a case where the victim refused to come to court, and we had a single eyewitness and the defendant. It was a very difficult case, but it just depends on how you mean. Some of my most difficult cases I do not talk about because I think that though my therapist probably also has a therapist to talk about all of the trauma, I'm not going to do that to chat. Nope. Some of them are incredibly tough, but yeah, victims refusing to come to court is always a hard day. Doesn't stop you from winning a case, but it's a hard day. So, and there are some that just stick with you that are tough. So I know that therapists have therapists, which is why we leave it there. But yeah, working in juvenile court was some of the hardest cases for sure. And juvenile trials are just different. They're not jury trials, but it's difficult. It's difficult on a different level. So, yeah, some very difficult cases. Elaine, thank you for the gifted memberships. JJ, thank you so much. I know that it's a hard answer. I know it's a hard answer, but it's just the truth about cases. Factually difficult cases, I liked being a prosecutor because you can say, we can't prove this case. We're not proving this. We're not doing this. And some of those cases were hard fought to get our office to dismiss them. But I think those are very worth fighting for when you go to your bosses and are like, no, we shouldn't do this. And I've had a lot of colleagues do the same and walk into their bosses and be like, we're not trying this case. We're not doing this. Who filed this? What the fuck is happening here? Why are we doing this? Be gone, case. I've had coworkers walk into boss's office and be like, you don't want to dismiss this? Fine. You do it then. You do it. And I think prosecutors should. I don't think they always do, but I think prosecutors should. And I think they should be, I think it should be something that is treated with a bit more solemnity in some offices than it is. I don't know if every prosecutor's office supports their prosecutors dismissing things. They should. LA is just so busy. LA is so busy that going in and being like, we can't prove this is not hard. Or when you filed it, it looked like we could. And now we can't. So we're done here. Easier than some other jurisdictions. But then again, I worked in a really busy jurisdiction. Sherry said, Bloodworth drank and left no drops. Never beating those allegations now. Never, ever. Just never, ever happening. Let's see. When you have Miss Jake, when you have EDB on one device and Ryan Hall on the other, is he still live? He was live all night last night. Emily, you could just go check. It looks like he finished streaming about 40 minutes ago. And I imagine when the court checked in with the jurors, they said they wanted to stay a little bit longer because they have not come back out. Let's see if there's another. I don't see another email, but they have not come back out. And the judge would have checked in with them by now. So, yeah, I imagine that the jury said they wanted to stay a little longer. Do I think that means that they'll be done tonight? No. No, I don't. I think it means that they barely got to deliberate today and they wanted a little bit more time to talk before they left. Duels Day said this call is giving I'm just a girl. Same with the body cam. The squeaky. Oof. The squeaky was tough. The squeaky was even in the call with Bryce. And I think the call with Bryce gave more context around the 911 calls and others. Stephanie asked, was the son ever questioned about whether he had nightmares or had Kouri in his room that night? I don't know. Anything to do with the kids would have been sealed. I know that at some point during this case, there was a discussion about whether there would be witnesses who were minors. And then there were jury instructions that were put in for that purpose. And then they were all taken out. So I don't think the prosecution would have called the kids because, again, it could be very true that that Kouri went in and slept in her kid's room. And if kids were having nightmares, they might not even remember. And it might have been perfectly true that she was sleeping in the room or that the kid's like, I'm asleep. I don't know. Like, you don't traumatize a kid by bringing them into a trial like this if you don't absolutely have to. And I think Kouri's own actions, whether she was sleeping in her kid's room or not, it's just as easy for her to go to her kid's room and lay down on the floor and pretend that she's there. So yeah, you don't bring in a kid unless you absolutely have to, especially in a trial of one of their parents for their other parent's murder. There's no way the prosecution would have wanted to do that, especially for a kid that's like, I was asleep. I don't know. Yeah, no. Even in Karen Reed, I think that the overwhelming feeling, even though they were older kids, they were older teens, I still think a lot of the feeling is you don't do that to the teens. Even though they had heard Karen and John arguing, even though they were percipient witnesses to other things, I still think juries overwhelmingly do not like when kids are brought in, especially if they don't feel like it was absolutely necessary. A lot of you are asking about what time it is. The local time, it's almost 5 p.m. local. We don't know. The court said they were going to check in with the jury at 4:30 and see if the jury wanted to stay a little bit. The jury seems to still be there. They've been deliberating, it seems, about 2 hours. That's according to Court TV. Court TV has a producer in the courtroom, so the producer kind of knows when the jury walked back. So that is, I mean, where that information comes from. But I'm going to answer some more questions. I still don't think they're going to come back with tonight. I really don't, because I just don't think we're going to see them come back with anything this evening. So I'm going to answer questions though. And then y'all are going to get the Lawnard app, and then we're going to be on Verdict Watch tomorrow. That's what I anticipate is going to happen. Let's see. I'm just going through and trying to answer questions that can be answered. I see a lot of these. April, this was a good question. Do we know if she actually went on the vacation with her boyfriend? They did not go on vacation, and apparently Kouri never finished paying for it, but they did not go into, they did not go on their vacation. So let's see. Chris Bowman said, at this point, I'm thoroughly convinced that Bloodworth or someone on his team is watching. 100%. 100%. I have zero questions about this. At this point, I think he is just winking at chat on more than one occasion. But yes, 100%. But you get to see a lot of thoughts, opinions, and information by going through chat. That doesn't surprise me. And I imagine that the lawyers will look at multiple chats and multiple different perspectives on this case and multiple different people talking about this case, not just me. That wouldn't surprise me. Chatty 911 Kathy said, why does she get 3 public defenders? Just a quick reframe on that. Kouri's lawyers are appointed counsel. They are not through the public defender's office, because the public defender's office, I imagine, was conflicted out, and they were appointed counsel, and based on the nature of the case and the volume of evidence, the state or the county got to decide what was appropriate for this level of case, and that's what they did. So yeah, that's what they did. But there would have been a conflict with the public defender's office and probably the alternate public defender's office because of Crozier and Carmen. Sky was privately retained. Oh, and we had a question about Sky earlier about why Sky conflicted off of the case. We only know so much about why Sky conflicted off of the case because the court put it on the record a million years ago. But the conflict had to do with something that came up in the civil case with regard to the estate and not with this criminal case. So whatever conflict arose in that way. And that's where we're at. So it was not because of the walk the dog letter. It was not because Sky saw that her client was trying to lie to her and smuggle Crest white strips and went, fuck this shit, I'm out of here. It was none of that. It had to do with the civil case, something that went on in the civil case, and her not being able to still be on it. The exact details of that, we don't know. So we do not. B2, yes, we will. I might take a quick restroom break and we'll play it. We have binged. We need to do it. We have not done it, but we will. I'm going to answer some more questions in super chats and we'll go from there. Scrambled eggs. EDB is watching it snow. We're in extreme heat warning in Vegas all week. Right. Little Queen said, would we find out though? Generally, if the jury decides to stay, the information officer will share, or the members of the media that are still sitting in the courtroom will share. Ciao Bell. My brain just added words. Is Utah DP state? It is, but this is not a DP case. That was not pursued in this case. Garden Girl, is it appropriate for the defense to just put out a statement during deliberations? I don't know if it is specifically inappropriate. I think it is on the ill-advised, but I don't know if it is specifically inappropriate. So I think it is ill-advised, but I don't think it's responding to the evidence. I don't think it is necessary. I think it could have been held until a verdict came in, but again, the defense is still, I think, and I view it through this lens, the defense is still doing their best to defend Kouri Richins. And I think this is just them still doing their best to defend Kouri Richins as they see it. And there were all these narratives out there, and they didn't like that she was called this or that, which we don't do here, even when it's hard. We didn't put weird names on things. We didn't talk about whether it was a Moscow Mule or a lemon drop shot or this or that. We look at the facts. I think that the facts in this case are not helpful. I think Kouri Richins' words and actions are the strongest evidence in this case, in addition to the timeline. And I think that, if your spouse is like, I got really sick, Kouri tried to kill me, and then dies 2 weeks later, I think that's really tough. I think that's really tough to get around. And also, if you need to remind your family of the truth, why are you saying that you're trying to remind your family of the truth? Just put it in your own words. If the truth will set you free, you don't need to just take vague notes. The walk the dog letter's real tough. It's giving Donna. Also, Kouri's entire phone wasn't yeeted. It was a period of time that was yeeted. And that's tough too. So yeah, it's not easy. And this is, Brandy said, I still don't know if I'm 100% on her guilt. And that's fair. We'll see what the jury does, but everybody gets to view this case the way that they view this case. And I say it all the time, but that's why jurors deliberate. There are things that I will, the seal wiggled. It wiggled. There are things that we will forget. There are things that a juror will forget. There are things that one juror will think is important and another might not. And that's why they deliberate. It is not meant to be one juror deciding things in a vacuum. It's deciding it as a group and having those conversations. And it's important. And I think that there will be some who are like, it didn't close the loop for me. And that's fair. I also worked as a prosecutor. A lot of cases, especially murder cases, are circumstantial. It being a circumstantial case does not bother me. Having people who were involved in drug dealing being the witnesses that were involved in drug dealing doesn't shock me. That's who's involved. I'm not surprised by any of this, but my tolerance and threshold and how I see that is informed by my own experiences. I would have different feelings, I think, about Carmen Lauber's testimony if the digital evidence wasn't what it was. I think the digital evidence is stronger to me, and I want to see the digital evidence and what the digital evidence supports and doesn't support. I always want to see the digital evidence every single time. Always want to see it. And I think the digital evidence in this case was strong, especially in the way it supported some of the other evidence. Also, what was wiped from phones was strong. I was honestly surprised that Grossmann's phone wasn't wiped. Really surprised. Really, really surprised. And Grossmann's phone was broken, but they repaired it. Hey, buddy. Hi. Grossmann's phone was broken, but they repaired it. So that says something too. Hi. Yes, I know. Your boy's at practice. I'm sorry. George is like, what are we doing? What are we doing? Bucket Pinata said the jurors note is proof that they will be diligent. Yes, which is also a juror that's like, hey, we were supposed to get a stipulation, is also a note to me that they are going to go through this case with diligence. I think so. So, hi, George is just climbing on my feet at the moment. Let's see. The seal wiggled, but not much more after that. It looks like notes from the courtroom indicate that we should know in about another 20 minutes if the jury is going to stay much longer. I might take a moment and run to the restroom. So, hi, George. So, Lisa, I hope I answered this. Lisa said, do you think Sky dropped out due to ethical or financial? It was a conflict. We heard it was a conflict. So that is what we heard. But let's see. I'm seeing some statements that the jury has already been asked if they will stay and has said they wanted to stay. And the judge ordered dinner for the jury. So they're going to be deliberating through dinner, which is fair. So I think if they're going to be deliberating through dinner, we have been streaming for almost 8 hours. I think it's fair to keep an eye. I do not think the jury is going to come back with a verdict tonight. I'm not surprised they want to talk after, 3 weeks of testimony that they want to chat and that they're like, sure, order dinner. Fine. I'm not surprised. I still don't think that they'll be back tonight. But if they are, we'll just go live and I'll let you know. You guys are like, who pays for dinner? The county. Summit County would pay for dinner. So, George, do you want to say hi? No, you just want to curl up on my desk? Sure. All right. George is just like, what are we doing? What are we doing? George does not want to be picked up. We can try. George, Okay. George is like, nah, I don't necessarily. I know the judge did bet them a steak dinner. He owes them. George is like, I don't want to be on screen. I don't want to look at the screen. I just want to curl up. I know. Your boy's at practice. He's just like, I'm over it. I want you to pet me while I look at the birds. Yep. George is like, this is not my jam. It's not my jam. Fair enough. Fair enough, buddy. All right. Let's see. I'm going to answer a few more questions, and then I'll keep an eye on the jury. I think that when they leave for the day, they are going to be exhausted, and I will let you know in the Law Nerd app. Let's see. I think Vicky Thomas, I don't think you're alone. Vicky Thomas in the chat said, I don't like how they attacked Eric, especially with his family being in the courtroom. I don't think it's going to sit well with a lot of jurors, because I don't think the evidence bore it out. If the evidence bore out that Eric was even casually using THC, I think you can make those arguments. I think they're fair to make. Look, it's fair this and it's fair that, but that's not what the evidence bore out here. And so I don't think it is more than just argument. And I think that's tough. Long Island Hillbilly said, was Bloodworth implying that Kouri was standing behind the elephant? I don't think so. I think the implication was that you can understand what happened even if you didn't see it happen. It leaves an impression, right? And you can learn much from that impression. So that's what I think. Let's see. I think I got to all the gifted memberships. Thank you to everyone who gifted memberships. If I missed it, I'm sorry. Are they just testing to make sure that we're all still paying attention? What is the court camera doing? Are you just trying to stress us out? I do not know why the camera was flashing between the seal and the lights. I have no idea. No idea why. Maybe just trying to stress everybody out? I don't know. But the jurors are getting dinner ordered in. They will be allowed to stay. I don't know how late they'll be allowed to stay. Actually, let me ask real quick. Because I can just ask the press liaison. Give me 1 second. I'll find out. And George, there's so much fur. Oh, streaming with cats is dynamic. Let's see. All right. I'm just going to ask because I'm curious. And I want to see what she has to say. All right. Why not? We're here. We can ask. And then I can let you know in the Law Nerd app. Spirit of the Tree says, I think the evidence was similar in the Murdaugh case. I think that the evidence was different. I think the financial crimes evidence actually was a little bit more pointed here than it was in the Murdaugh case. I think Murdaugh's statements changed the Murdaugh case significantly. Murdaugh's own statements kind of wiped everything else out from that case. But I think the direction, I think how closely tied the financial evidence was here was actually more closely tied than it was. But Murdaugh lying about being at the kennels and then being on the recovered video was a huge thing. Like, why lie? And in some of those moments where every moment matters, why lie? Like, why are you lying? And I think that is a big deal too, because why are you lying? And the implication of those lies are pretty big. So that's, I think some of those lies will come back in this case, like they did in the Murdaugh case. Some of you have asked if convicted of all counts, can that be used in the financial trial? NY Mom 67. That's a great question. 67. Which is probably 67 and not 67. I think that there would be argument to keep some of it out. I don't think the homicide could be used in the financial case. It would be too prejudicial. And I think that would be tough. So I think it would come under motion. And the prior financial crimes, I would need to look at the dates. I would need to look at the dates of the financial crimes. The underlying facts could, but not necessarily the convictions. So we would need to see what happens, and then I would need to look at the dates again. So that's what I would want to see. Some of you are letting me know in the chat that it has been said that they are going to deliberate till at least 7 p.m. Mountain. I'm going to wait and see if the court liaison responds. Let's see. Okay. I just got an email from the court that said the jury has decided to stay and work past 5. We do not know how long they will deliberate for or at what point they might decide to take a break for the night. Okay. So that's what the court liaison has said. I don't know if there's differing opinions, but that's what the court liaison has said. So that's what I'm going with because that's what the court liaison said. So I'm going to keep an eye on that. Law Nerds, it has been 8 hours of streaming. I would be very surprised if the jury came back tonight. I would be very surprised. It is 5:15 local. The jury is ordering dinner. They've decided to stay. Again, I would be very surprised if they came back with a verdict tonight. I don't think they will. I think they probably just want to talk and then sleep on it and see where they get. It would be very, very fast for them to come back with anything tonight. But if they do, we will fire up another stream and we will go live because they can deliberate. What did the court say? They can deliberate when it says they can deliberate. We don't know how long they will deliberate for and at what point they might take a break for the night. I will let you know. I do not think they will be back today. I will send out an app notification when the jury goes home. I will send an app notification if we are going live, which I would be surprised. But I will send app notifications out on that because again, they can keep deliberating. We did not play any of our bings, and I did not get through all the super chats. So I'm going to try to go through and answer some questions one more time. If I missed things, I'm sorry. It's been a very long day, and we did not take much of a break at all today. We are going to have to. We will play the bing before we leave. I just wanted to make sure you guys A, knew where I would update you, B, knew how I would update you. And again, I would be very surprised. Emily, can we just reiterate that more? Yes. I'd be very surprised if they come back tonight. It would be surprising to me. What a favorite way to celebrate Law Nerd anniversary. Well, happy Law Nerd anniversary. We have lots of comments about the defense turning off their mics. I don't even know if they knew that they could because every time they did, it was Ramos getting up and turning them off. But it was at times distracting. I agree. Let's see. We've a couple questions about Murdaugh. I think we already answered that. Did Kouri ever consider that if her story of Eric ending himself was accepted, then most insurance wouldn't pay out since it was a deliberate act? No, because that didn't come up until later, right? I don't know why my camera just went out of focus, but that didn't come up until she had been charged. And I think that's why she didn't lay the groundwork there when EMS was there, because that wasn't the case. I do think that she was truly surprised that they would do an autopsy. I don't know what she thought. I don't know what she thought, but I think she was surprised that they would do an autopsy. I don't know how she was surprised by that, but I think she was. I do. So let's see. A lot of questions. How much do we think of this as client driven? I don't know. They would have to talk with their client about stuff, but again, the attorneys have to agree. There are times that a client is going to say, I want you to argue this, and the attorney's going to be like, no, we're not arguing it that way. Trust me, I've gone to trial more than you have. That's a good thing because it's different than civil, where criminal attorneys take input from their client and don't. The ultimate thing that a attorney cannot decide for their client is whether or not they testify. They can give input, but ultimately the client gets to decide that. And that is something that is very client driven. Nurse of Interest said, wow, what a wild ride. This trial was definitely, I don't know what I expected. It was not this. This trial was more of a roller coaster than I anticipated. Much more of a roller coaster than I anticipated. Yeah, everything in pretrial had gone fairly smoothly, kind of like when we got to the charge conference. Things had gone fairly smoothly. And then wild, absolutely wild. And then it seems that everybody at the defense table is also sick, which is unfortunate for them because it seemed everybody was under the weather. Let's see. I'm going to try to get to questions. There's a lot of comments that I know I'm not going to have time to pull all of them up, but did the defense know this book report was due today? I'm surprised at the slide presentation, though that might have also been strategy to be like, look at how polished the state is. Look at the resources of the state. Look at all the money that was spent. Look at how it was driven. And we're just the defense team. We're the little guys. And it's Eric Richins' family and all of the money. They're just beating up on us. It didn't come across to me, but that might have been some of where they were going because I was surprised at the defense, the way that they used their exhibits. I was surprised by that. Totink, I think. The amount of misstating evidence and facts and her demeanor are off-putting. The misstating stuff was really difficult for me. It was difficult for me to follow the defense with. It started an opening with this expired on this date. I'm like, that's not what it fucking says. I should have known then. I should have known then. The misstating stuff frustrates me. Rose said that's all about the searches. The defense really just kind of skipped right over the searches. She's curious, you guys. What happens if somebody's poisoned? She just wants to know. Everybody just Google searches if somebody's poisoned. What does it go down on the death certificate as after their spouse mysteriously dies of something that can't be found in the house because it's all inside of their stomach? What? Nothing to see here at all. I'm not surprised that they went after the investigator. I just don't think it was a great look, but if they can get one juror on their side to be like, is the family behind all this? Would Kouri have ever been charged? I don't know how that'll go in the jury room, but you gotta hope for one juror that's going to go back there and say, but what about this? And what about this? And we binged. I heard that one. And I think that's why you saw the defense using the painting of all of the other jurors and one lone female juror sitting there being like, well, not fighting back, just sitting there and getting pointed at. It was a choice for sure. Yeah, it was a choice for sure. Let's see. Trying to get any more questions. I saw again a lot of comments. You guys are you guys are funny and I appreciate it. Martha said 50K watching. Holy cow. Everybody wants to come and chat with the law nerds. I like to come and chat with the law nerds. I'm not surprised because law nerd chat is the best place to chat. Obviously, it's the best place to come and chat. It's where we want to chat. Emily's just starting to repeat herself because she's tired. Yep. That's true. Gossip and Rumor, good to see you in the chat. Thank you for the gifted memberships. I know I won't get through all of them. Melanie, thank you for the 50 gifted memberships. We have so many new members. We're going to have to play our Bing because we just binged. I think we should do that now. And then we're going to wrap up because EDB is tired. B, EDB needs to eat and check in on the kids and the cats and all the things. And then we'll see what the jury does. They might be out for another, maybe an hour? They're going to deliberate for like 3 hours today. I don't think that's enough time for them to come to a verdict. I really don't. I wouldn't even suspect that they come to any questions tonight. I think they just talk. It's a mutual widow angle. That's why. Hops, the mutual widow angle. Yeah, the defense kind of started it with this is a wife becoming a widow. Did they not know that Chelsea referred to Kouri being a black widow in the call? They knew that if they listened to the call. And I think when the call got played, I said, why would you open with wife becoming a widow if you knew that Chelsea's making a statement about being a black widow? Why would you do that? Because the second Chelsea said black widow, I went, no, she did not. Nuh-uh. Nuh-uh. Why would you open with that? Like, why? Craziness. Just craziness. All right. Can we have a timer for how long the jury was out for deliberations? Time is a construct in my mind. I do not have a timer to put up on our screen. Maybe for next trial, we will get a timer. The timers, again, here is my word about timers. They start when the jury goes back to deliberate. The jury will stop deliberating if they take bathroom breaks. Sometimes they don't deliberate when they eat. It is just a rough estimate. But they've been out for about 2.5 hours. I wouldn't be surprised if they deliberated 3 to 4 hours tonight and then went home. But I will keep you up to date in the Law & Order app. Make sure you have the app and your notifications on. Notifications on this channel on. I would love to stay in chat, but I have got to go check in with my family. It is late. It is 6:30 here. It is 5:30 local time. They are getting dinner, maybe out for another hour before they go home. When they go home, I will let you know.
All righty.
Oh,
okay.
We have a surprise Ryan Hall y'all starting because I opened YouTube and YouTube was like, you want the weather? Apparently I do. But I will keep you posted in the Law Nerd app. I am keeping an eye on the jury. We will keep an eye on the jury. I think they will just go home for the night and we will resume Verdict Watch tomorrow and we will have some options for you tomorrow. Also, Team Baker and the mods and all of the Law Nerds, you guys have been amazing. Thank you. It has been a very full day of closing arguments. And I thought, they'll let us know in a half an hour, like an hour later. Like an hour later, it was like, oh yeah, they're going to order dinner. Perfect. But we have binged a couple times this trial. For those of you that are new here, it's part of our sub counter. You can hear it make that little noise in the background, which we heard a little bit earlier. And when we hit 100,000 subscribers, I was on stream with Dr. B, my husband, and this happened, which is why it binged. Oh, it binged! Move your head! Oh, it's been a minute. It has been a minute. It has been a minute. But Law Nerds, do not worry. We will keep you posted. Thank you to our moderators. Thank you to our team. A huge thank you to our sponsor of today's stream. I appreciate our sponsors that let us, do streams the way we want to, not turn on ads during stream. Keep them at a minimum on the replay. There was one day this week where they got last week, might have been the week before, where they got out of control due to an error not on our end. And we were like, holy moly, what happened? I appreciate that they let us, A, keep you up to date with the case briefs, B, keep our streams uninterrupted other than EDB's ADHD interruptions, and make the replay crew absolutely tolerable. I appreciate it. So a huge thank you to Incogni. Yes, it is absolutely what I use and have for years at this point. Law Nerds, I don't think I'll see you again this evening. So take care. Stay tuned to the app. I will keep you posted. Get some food. I think we're going to be on Verdict Watch tomorrow. I would be very surprised if we're not. I think we'll be on Verdict Watch tomorrow, but I will keep you posted. Have a good night. Take care of yourselves. Hydrate. What an interesting closing arguments today, weren't they? I'll see you tomorrow. I suspect. It could be a little longer than that. I'll put up some polls in our member places. We'll see. But I think with 3 weeks of trial, they're going to need some time to deliberate. And we're on Verdict Watch. So, Law Nerds, stay tuned. I'll see you soon. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.